following agenda for us today. We will shortly hear the remarks of the ICTR President, Judge Vad Johnson. Following, there will be a keynote address by Rwandan Prosecutor General Richard Muhumuza. At 9:30 to 10:30, our first panel will convene, and they will deal with the very compelling theme of strategies from streamlining cases and case management at the international level. We will then have a second panel that will start at 1:30 to 3:30, and that will deal with the theme of sexual violence, crimes, and assessment of evidence in international tribunals. We will conclude the day with our third panel at 4 till 5:30, and it will be on the vast theme of cooperation of domestic justice mechanism with regional and international courts. And this theme will be dealt in 2 days, starting today, and we will follow on the same theme tomorrow. So it is my great honor to give at this time the floor to the ICTR President, Judge Vad Johnson.
Excellencies, colleagues, invited guests, ladies and gentlemen. Thank you for being here for the events marking 20 years since the creation of the International Criminal Tribunal for Rwanda. It is my honor to welcome you today to this international symposium on the legacy of the ICTR. First and foremost, I would like to take a moment to thank those who made this symposium possible. I will start with the government of Tanzania. Thank you for all of the assistance in putting together this symposium, and more importantly, for being such great and gracious hosts of the ICTR over the past 20 years. Next, our sponsors. Thanks to UN Women and the Planethood Foundation for supporting this event, and a very special thank you to the German government, our main benefactor, for the extremely generous support provided. Finally, and equally important, a warm thank you to the ICTR Legacy Committee and all of the staff of the ICTR and MICT who volunteered their time in an effort to ensure that we have a successful symposium. That we have gathered such an esteemed and diverse group of participants here today is a testament to the importance of the ICTR's work. Over the coming days, we will reflect on the events that took place in Rwanda in 1994 and the impact they have had on international justice mechanisms and on genocide prevention. In creating the ICTR, the United Nations Security Council established an international tribunal for the prosecution of persons responsible for genocide and other violations of international humanitarian law. One of the goals for this tribunal was that it would contribute through justice to the process of national reconciliation and to the restoration and maintenance of peace in Rwanda and throughout the Great Lakes region. It is my sincere hope that as the ICTR shortly closes its doors, part of its legacy will be that it dispense justice in the manner envisaged by the Security Council. I would like to put forward some ideas that I hope will spawn further discussions in the coming days. Indeed, it is important to remember the voice that the ICTR provided to victims and survivors of the genocide in Rwanda by becoming the first international tribunal to enter a judgment for genocide and the first to interpret the definition of genocide set forth in the Genocide Convention. The conviction of Prime Minister Kambanda also represented the first conviction of a head of government for the crime of genocide and sent a clear message to the international community that all those who commit genocide or other atrocities, regardless of their position, will no longer be able to hide from justice. The ICTR significantly expanded the jurisprudence related to crimes of sexual violence and rendered the first international verdict holding members of the media responsible for broadcast intended to inflame the public to commit acts of genocide. But this tribunal's legacy is not only that of its jurisprudence. This tribunal, along with the ICTY, was an incredible step in the evolution of international justice in administering an international court with a limited mandate, and it was also a place where people came to understand in some small way what happened in Rwanda. Most of us were not in Rwanda during those 100 tragic days in 1994, when over 800,000 men, women, and children were brutally killed. However, many have since dedicated a large part of their professional lives in the pursuit of international justice. Whether working to find justice for the victims and survivors of the 1994 genocide in Rwanda that targeted the Tutsi, or working to ensure that the justice dispensed was just, whether working to ensure that the records and the stories told were preserved for posterity, or working to keep safe those brave enough to share their stories, whether guarding the rule of law or guarding the lives of those who passed through the ICTR's halls, all were shaken by the dearth of humanity in the accounts they heard, and all were touched by the strength and courage they saw in the survivors. We must never discount how important the people are to the tribunal's legacy. The ICTR is not only about the 93 individuals indicted, or the 10 cases referred to national jurisdictions, or the milestones it achieved in international justice. We have come a long way since the establishment of the ICTR 20 years ago, and while we have faced many challenges, there have been countless lessons learned from the experience of the first ad hoc international criminal tribunals. As we reach the conclusion of the ICTR, and as our sister institution, the ICTY, also nears completion of its mandate, we see a world much changed from 1994. It is a world where a permanent international criminal court now exists and thrives, along with several other international and hybrid tribunals, standing as a warning to all who discount human lives and human rights. And also a world better equipped to recognize the only warning signs of genocide and other atrocities, and work to prevent rather than just punish these acts. Over the course of the next 2 days, we will discuss areas in which the tribunal has gained considerable experience, whether by way of developed practices or by the lessons we learned through the first attempt at truly international criminal justice. From the legal and administrative side, we will discuss the ways to streamline case management, assess evidence, and safeguard fair trial and detention standards. We will examine what works and what doesn't when it comes to cooperation between an international tribunal and the relevant domestic justice mechanisms. We will also see how the ICTR worked to build capacity and perform outreach activities, even without a specific mandate to do so, and the impact this had on the peace and reconciliation process in the Great Lakes region. As we begin discussing the legacy of the ICTR, and in part its relationship with Rwanda over the past 20 years, it seems very fitting that Rwandan Prosecutor General Richard Muhumuza is here today to deliver the keynote address for this symposium. Prosecutor Muhumuza has been the Prosecutor General and Vice President of the Prosecution High Council since September 2013, and prior to his appointment, he spent 15 years at various levels of the National Public Prosecution Authority. Prosecutor Muhumuza has vast experience in prosecuting international crimes in Rwanda and continues to play a leading role in international cooperation and in the ongoing efforts to secure the arrest of the 9 remaining fugitives. His efforts in Rwanda and the support he has provided to the tribunal have been instrumental to the ICTR's effort to complete its mandate. As the ITR draw ever closer to completion, I have no doubt that Prosecutor Muhumuza will continue, as the ICTR has done for 20 years, the fight against impunity and the fight to ensure justice for all of the victims and survivors. I want to wish everyone a great symposium And I will now turn the floor over to the Distinguished Prosecutor General from Rwanda, Mr. Richard Buhumuza.
Good morning, everyone. Thank you, Judge Johnson, for the kind words and for inviting me to speak on behalf of my country on this auspicious occasion. Excellencies, distinguished guests, ladies and gentlemen, all protocols observed. Today, we commemorate the 20th anniversary of the existence of the International Criminal Tribunal for Rwanda. 20 years ago, Rwanda was thrown into an apocalypse designed and implemented by the men and women prosecuted at this tribunal. During the hearings in the trial chambers of the ICTR, the horrible story of the 1994 genocide against the Tutsi unfolded, and the full scale of the tragedy is well documented at this tribunal. In hundreds of thousands of court transcripts and in English and French, in thousands of hours worth of audio and video testimony in Kinyarwanda, French and English, the legacy of this tribunal is captured for posterity. The work of this tribunal will forever be available to future generations of students, researchers, and anyone interested in lessons of the folly of tribalism, ethnic division, racism, and any other perceived differences humanity uses as an excuse to eliminate the other. It is noteworthy that this tribunal has achieved a lot in its 20 years of existence. At the forefront of these achievements is that for the first time in the history of an international court, the ICTR managed to orchestrate the arrest and trial of almost an entire government that oversaw the genocide. It is doubtless that without the complicity of political, military, and local leaders, genocide cannot be successfully implemented. In Rwanda, this fact is demonstrated by the evidence heard by the ICTR trial chambers, where for the last 20 years, almost every key witness to what occurred in Rwanda testified either for the defense or the prosecution. Notable among the witnesses was General Romeo Dallaire, the UNAMIR commander who watched helplessly as 1 million lives were lost. The ICTR should also be noted for the wide spectrum of suspects tried. On trial at ICTR were cabinet ministers of the interim government, such as Jean Kambanda, the Prime Minister, military leaders such as Colonel Theoneste Bagosora, journalists such as Hassan Njeze, businessmen such as Yusuf Munyakazi, notorious local leaders such as Conseiller Michael Muhimana, religious leaders such as Pastor Elizefan Hachutimana and Father Athanase Seromba. There are also women such as Pauline Masuhuko. This wide spectrum of suspects reflected the true tragedy of the genocide in Rwanda. Men and women from all walks of life were complicit in ensuring the destruction of the Tutsi ethnic group. In addition, this tribunal has made huge contributions to the field of international criminal law. Most notable among these is the progressive nature of the crimes of genocide and rape as a crime against humanity, whose definitions ICTR has expanded. Today, it is accepted that rape can be genocide and no proof of consent is required for rape as a crime against humanity if coercive circumstances can be proved. These developments reflect the true nature of both crimes. For during genocide, if a suspect has the requisite intent to destroy a protected group in whole and part, and further this intent rapes members of the protected group, why then would this not constitute genocide? And if a victim has only two choices, either rape or death, it is quite evident the elements of consent is rendered moot. The above progressive nature of the jurisprudence of the ICTR, including the definition of rape, has influenced the practice of criminal law with regard to genocide, crimes against humanity, and war crimes in many countries. It has particularly influenced the conduct of trials and the jurisprudence we use in our courts in Rwanda, because we are trying the same genocide with the same co-perpetrators, similar massacre sites, and evidence. In addition, now that the ICTR is winding down its work, we are preparing to take on the work left unfinished by the tribunal because of its definite mandate. As much as we in Rwanda appreciate the many achievements of this tribunal, we take note of a number of issues that concern us as the ICTR's work comes to an end. Let me state that the relationship between this tribunal and my country has been a mixed bag over time. There have been difficult moments that must be put into context. Rwanda represents a constituency that includes victims who have not always seen this tribunal as representing their best interests. When a court dispensing justice that has a lofty ambition of contributing to reconciliation in Rwanda is located far from Rwanda, and news reports state that a key suspect is being released for technical reasons, it becomes a problem. When victims and witnesses to mass murder are told the suspects are innocent, criticism should and must be expected. Despite these few difficult moments, I can state that Rwanda has been the single country in the world that has cooperated most with the ICTR than any other. Thousands of witnesses were facilitated by Rwanda to provide their testimonies in Arusha and The Hague. Witnesses were provided with security and many other services as required. Rwanda cooperated and continues to cooperate with ICTR and MICT officials. Without Rwanda's cooperation, I believe the work of this tribunal would have been near impossible. I must, however, note that ICTR has and continues to cooperate with Rwanda as well. Most notably, ICTR has been instrumental in providing capacity building and mutual legal assistance. One of the enduring concerns Rwanda has in view of the imminent closure of the ICTR is the location of the tribunal archives. The work of this tribunal represents a major part of Rwanda's history, a part representing a tragedy from which future generations of Rwandans must draw lessons for the future. This legacy is ours and must be returned to Rwanda where it rightly belongs. Rwanda will never stop requesting for the archives to be moved to Rwanda, no matter how many generations it takes. Another legacy of the ICTR that concerns Rwanda is that it never had a provision for reparations to victims. As we remember, the reason why this tribunal was established, let us never forget the victims and survivors of the 1994 genocide against the Tutsi. For true justice to exist, there must be compensation as well as punishment. Heinous crimes leave survivors with no family support, and they must therefore be provided with reparations to help rebuild their lives. I, however, note that the ICC has such provisions. This lesson has therefore been learned and will benefit future generations. Although the tragedy that has brought us to this moment is one that we will never forget, there is hope in a lesson well learned by all of us. While we remember the tragedy of the 1984 genocide against the Tutsi, we choose not to be defined by it. Rwanda is defining her future as a united country. A country where you are not labeled the Tutsi, Hutu, or Twa on your national identity card. A country where ethnic hatred and rhetoric has no place of honor. Today, Rwanda is a country where the likes of RTLM and Kangura can never thrive. More than 70 years ago, the world proclaimed never again to genocide. 20 years ago, this refrain was repeated over and over again. Even today, this refrain Okay. Thank you. Ladies and gentlemen, I said more than 70 years ago, the world proclaimed never again to genocide. 20 years ago, this refrain was repeated over and over again. Even today, this refrain is constantly proclaimed, but is hollow and a mere rhetoric to many. Humanity still witnesses genocide, crimes against humanity and war crimes in many countries. When you are a victim of genocide, you are always hopeful that the international community will put an end to your horror. Over and over again, the rest of the world has fed victims of this tragedy. In Rwanda, because we have been victims and know the importance of standing on the correct side of history, we have chosen to make never again a reality for many potential victims across the world. We are contributing troops to protect potential victims of these heinous crimes from certain death. In Sudan, in Central African Republic, in Haiti, to name a few. We are steadfast in our resolve to secure a better future for our people and others who find themselves in our unfortunate circumstances. When the men and women tried that this tribunal fled Rwanda, they left behind a broken country. Rwanda was literally on her knees. Majority of you here had the misfortune of visiting the massacre sites and have been witnesses to what befell Rwanda. With 1 million dead and thousands of suspects, a broken economy and a fractured society, Rwanda could have buckled and become one of the many failed states. Dare I say it was the hope of the architects of a country's tragedy that Rwanda would never rise from the ashes. As I speak to you today, Rwanda's justice sector, along with other spheres of public life, has revived. Against all odds, we are a country not defined by the 1994 genocide, but by accolades strived for through unity of purpose. We know our past, but most of all, we know what we want for the future generations of Rwandan children. Failure was never an option for us. It is very easy for many to forget that what happened to Rwanda is a mere 20 years ago. We are always held to a higher standard than most, despite the seemingly insurmountable challenges we faced. I can assure you that we are up to the challenge, for we hold ourselves to a much higher standard than is expected of us. Time and time again, Rwanda has defied expectations. Let Rwanda's success story provide hope for others in our situation. As we commemorate the achievements of this international organization that has contributed immensely to the development of international criminal law, let me also recall that it is at this tribunal that revisionism and theories that promote the denial of genocide has originated. There is no doubt that a small number of people involved in the trials at ICTR espoused theories that sought and still seek to exonerate the perpetrators and blame the victims. They have formed a clique of willing proponents of a theory whose continued repetition essentially promotes genocide ideology and perpetuates the crimes outside the courtroom. For if you deny the true nature and scale of genocide publicly, you doubtless promote the ideology that caused it. The aim of the proponents of these revisionist theories is to rewrite Rwandan history. This tribunal has, however, rejected these theories. It is this tribunal that categorically stated that genocide against the Tutsi of Rwanda was committed in 1994. The majority of you know the truth because of the work you did at this tribunal. It is my hope that as you leave this chapter of your lives to do other worthy work, you will continue to be witnesses to what happened in Rwanda and continue to reject the attempt to minimize the extent of the mass killings in Rwanda. As we remember the work of the ICTR and reflect on its achievements, let us remember that our work of striving for justice and our struggle against impunity is far from over. It is a stain on all our collective consciences that 9 men, architects and major perpetrators of the genocide, are still at large. Felician Kabuga, Protem Hiranya, Augustine Bizimana, Fulgence Kayishema, Phineas Munyarugarama, Aloys Ndimbati, Ladislas Ntaganzwa, Charles Kubwabo and Jandikayo are still at large and must be apprehended and brought before a court of law. Wherever they are, they should know that Rwanda is determined to find them and ensure justice is done. Let me remind everyone that Rwanda, these 9 men are not the only fugitives we seek for their law in the crimes of 1994. We have transmitted 244 indictments, extradition requests and international arrest warrants to 30 countries worldwide. We are determined to pursue arrests, extraditions or prosecution in foreign jurisdictions, and we call upon all judicial and legal authorities concerned to work with us. Our legal system is functional. Sometimes we are unfairly vilified while other countries are given less scrutiny with regard to transferred cases. We welcome the scrutiny because we are confident in our legal system and our commitment to try these cases with international minimum standards. As noted earlier, we have cooperated with international and national legal authorities in the past, and we will continue to extend this cooperation to the mechanism for international tribunals and other international and national legal authorities dealing with the 1994 genocide against the Tutsi. While your work at the ICTR is winding down, it feels like ours at the National Public Prosecution Authority is beginning. We are prepared to take up the baton from the ICTR office of the prosecutor in investigating and prosecuting the remaining fugitives. To all of you who dedicated a part of your lives to fighting for justice for the 1994 Tutsi genocide, you leave behind for the international community in general, and Rwandans in particular, a lasting legacy of a fully documented genocide whose effects we still feel today in Rwanda. Your work has contributed immensely to capturing for posterity what happened in Rwanda. You should be proud of having been a part of a small group of people in world history to do this noble work. Ladies and gentlemen, I want to thank the management of the ICTR and the MICT for inviting me to speak on behalf of my country on this very important occasion. And I thank you very much for your kind attention. Thank you.
Thank you very much. And we thank very much the President, the Honorable Judge Wagner Johnson, for his welcome remarks. And we also thank Mr. Richard Muhumuza, Prosecutor General of Rwanda. At this time, we would kindly ask our panel members to convene in their seats, and the Honorable Judge Wagner would certainly introduce each one of them. and we will start the session as soon as possible. Thank you.
I invite the panel members to move to the high table. Please allow me to express my sincere appreciation to the Prosecutor General for his very fitting remarks, which represents an excellent prelude to the start of this Legacy Symposium, and to the first panel on strategies for streamlining cases and case management at the international level. As a trial chamber judge and president of the ICTR, I'm very familiar with the common criticism that trials and appeals at the international level are extremely time-consuming and at times inefficient. In that respect, I believe that we have convened an excellent panel and discussants who come from various institutions and who will shed more light on the work of international courts. This panel, as well as the panels coming after us, are under a very tight time schedule, and I'll do my part to not exceed the time that has been allocated to me to moderate this panel. I will start by introducing the 5 presenters and the discussants. I will not attempt to summarize the presentations or comments by the discussants. They are very short as they are and should not need any summarizing. The first presenter on our panel today is Jean-Pierre Fonté, who is here on my right. Mr. Fonté has been the Deputy Registrar at the International Court of Justice since 2013. He has significant experience in the fields of diplomacy, legal affairs, and management, having worked more than 19 years at the United Nations. Prior to being elected as Deputy Registrar, Mr. Fonté was Registrar of the United Nations Dispute Tribunal in Nairobi from 2009 to 2013. He also previously worked at the ICTR as Programs Director and Legal Advisor and Special Assistant to the Registrar. Our second presenter, who's sitting here on my right, is His Excellency Justice Erik Møse. Justice Møse is a Justice of the Supreme Court of Norway and has been a judge of the European Court of Human Rights since 2011. He was previously a judge at the ICTR from 1999 to 2009, Vice President of the Tribunal from 1999 to 2003, and President from 2003 to 2007. Prior to that, he was Judge of the Court of Appeals in Oslo from 1993 to 1999, Supreme Court Barrister, and before that, Deputy Judge and Head of Division in the Ministry of Justice in Norway. He chaired inter alia the Council of Europe's Steering Committee for Human Rights and the Expert Committee for the European Convention for Prevention of Torture. Our third presenter is Roman Boyd, who's sitting there to my left, who has been the Senior Legal Officer and Chief of the Appeals Chamber Support Section of the ICTR since 2004. Prior to his appointment to his current position, Mr. Boyd occupied the positions of Legal Officer and Judgment Coordinator from 2002 to 4 and Associate Legal Officer from 1999 to 2002 at the ICTR. Then the following presenter is Upendra Baghel, who sits almost to my far left. who works with the Appeals and Legal Advisory Division of the Office of the Prosecutor of the ICTR. He has been involved in investigating ICTR cases since 2000, when he joined the Investigation Division of the ICTR in Kigali. Prior to that, he worked as an Indian Police Service officer for 11 years, as well as various civilian police operations with United Nations peacekeeping operations in Angola, Bosnia, and Herzegovina. Our last presenter is Tom Adami, who is currently the Deputy Chief Archivist for the MICT, and he manages the Arusha branch archives. From 1999 to 2007, he was the archivist at the ICTR, where he was the head of the Judicial Records and Archives Unit of the Court Management Section. He has been a professional archivist since 1992. And then we have three discussants. The first one is Susan Lam. She's the only woman up here, so she should be recognizable. It shows our gender policy here. She's a professor and vice dean at the Jindal Global Law School near New Delhi, India, following 16 years with the ICTY, ICTR, and ECCC. She previously occupied the positions of Senior Judicial Coordinator to the United Nations Assistance to the Khmer Rouge Trials and the Senior Legal Officer to the Trial Chamber of the ECCC from 2009 to 2013. She was Judge Moses, or President Moses' chef de cabinet, and Senior Legal Officer in Chambers at the ICTR from 2005 to 2008, and in various other capacities with the ICTY from 1997 to 2005. The following discussant is Will Patterson, who is sitting next to Susan Lam, who is currently the Senior Advisor to the Canadian Department of Finance in the area of multilateral institutions. Previously, Mr. Patterson was a legal and policy advisor to two successive presidents of the ICTR, Judges Dennis Barre and Khalida Rashid Khan. And prior to moving to Arusha, he was an associate at Clifford Chance Law Firm in London, England. And then finally, but not least, our final discussant is Andres Perez, who currently works as the East Africa Coordinator for the United Nations Office on Drugs and Crimes, the UNODC, Global Program on Cybercrime in Nairobi. Prior to joining UNODC, Mr. Perez served as Chief of Party for the Public International Law and Policy Group in South Sudan and Libya, as well as Rule of Law and Development Consultant for different organizations in South Sudan. Mr. Perez also worked for more than 6 years at the ICTR in various capacities, including as Judgment Coordinator for the Khmer at Al case. So please remember everything I said when we go to the individual presenter or discussant. I now give the floor to Jean-Pélé Fonti.
Thank you very much, President Johansson. I've been asked to say a few things from a registry code management perspective on strategies for streamlining cases and case management at the international level. I'll focus my few words on some of the achievements of the ICTR in that area, especially in the early days, and they will allow you to see how, in a particularly creative way, the registry looked into the difficulties that the court was facing and crafted strategies that somehow contributed in improving the delivery of justice, which was the core business of the institution. So I've selected 3 or 4 of those examples. And the first illustration has to do with simultaneous interpretation from and into Kinyarwanda. And Kinyarwanda is the language spoken by most of the witnesses that appeared before the tribunal. And in the early days of the ICTR, the testimonies were given in Kinyarwanda, but the interpretation was done in a consecutive way. So the witness will speak, the interpreter will take note and interpret from Kinyarwanda into French. It will go into the French booth. The French booth will interpret for the other stakeholders in the courtroom. This was extremely time-consuming, and that is something that was not anticipated when the tribunal was established. Of course, the solution, the easier solution, would have been to look for professional interpreters in the market and hire them. The problem is, on the labor market, we had no professional interpreters with the required skills. So the tribunal, the registry, had to cope with the situation, and the only solution found at the time was to develop an in-house training program. So what the registry did was to recruit on the global market colleagues with Kinyarwanda as a language and with the required potential to very quickly grasp the professional simultaneous interpretation skills to be able to operate. So that was done, and an 8-month in-house intensive training program was organized by the registry. And this significantly contributed, to the improvement of the way justice was rendered, and more importantly, reduced significantly the time it took for trials to be conducted. I remember President Mercer in those days saying that simultaneous interpretation in Kinyarwanda saved between 20 to 25% of the court time. That's the first example of how creative the management and staff of the tribunal at the time tried to find solution to the problem that was faced with. And I would like to seize this opportunity to pay tribute to those who spearheaded that project, Oscar Tanifum and Justine Dongo Keller, with other colleagues. Now, the second illustration has to do with the transcription of court proceedings. In the early days of the ICTR, we had court reporters. They will come to court, produce transcript a week or two after the proceedings. It was later on reduced to a few days, but we came to the conclusion that producing transcript on the same day or producing real-time transcript will be extremely useful for the court. Now, on the market at the time, we had the required software to produce real-time transcript in English, but that was not possible in French for various reasons. One of the reasons being that the French court reporters were using one software that did not have, the capability of facilitating the real-time transcription. So what the registry did in cooperation with court reporters was to join hand with an external contractor, one, to develop a software, and two, to organize an in-house training program. And we used the Bagasora trial, to pilot the project. And again, quoting President Moser, we saved 30% of the court time just based on that strategy. And this project was developed under the leadership of two colleagues, Sylvie Vandrich and Patrick Eno, with the strong, very strong support of Registrar Adam Adieng. It's good to pay tribute to them. Illustration 3, it's a very simple one. It might appear to be extremely obvious, but the impact was significant, is the establishment of the trial committee. And the trial committee was simply a committee composed of representatives of the Office of the Prosecutor, the Chambers, Registry, and defense lawyers. The mandate was very simple: to sit down long in advance, review the readiness of the cases for calendaring. And it turned out to be extremely useful because those working sessions, which could be equated to status conferences or case management conferences in the absence of a judge, where the opportunity for participants to review the case readiness, look into pending issues relating to maybe pending motions, translation issues, investigations by defense lawyers, so on and so forth, really helped prepare the tribunal to embark into its completion strategy on stronger, firmer basis. Now, the next example, which cannot be only attributed to the registry but to the tribunal as a whole, is the completion strategy as a process. In my view, it really helped the leadership of the tribunal to come together and assisted the leadership in refocusing on the core business of the tribunal with clearer goals and set timelines for their completion. And looking at the completion strategy, its requirement of a 6-monthly reporting to the Security Council truly contributed to streamlining the process, because it was very clear what the court wanted to do, and the time set for it to happen was also extremely clear. And I would like in this regard to pay tribute for their outstanding leadership in developing and implementing the ICTR completion strategy, to former President Mercer, to Prosecutor Hassan Jallo, and to former Registrar Adamadian. So I think I've exhausted my almost 10 minutes. Of course, we can say a lot more about how the registry contributed to streamlining the management of cases, but some of those ideas will probably be discussed when we review other themes like witness protection program, legal aid program, so on and so forth. So I'll choose to stop here, and thank you for your attention.
Thank you, Jean-Pierre, also for keeping the time. You made reference to, I counted 3 times, to the very dynamic president of the ICTR, Eric Mercer, and now I give the floor to the man himself.
Dear friends and colleagues, it's so nice to be back and see so many familiar faces here. Thank you so much for the invitation, President Johnson, and I think the introduction by Judge Van Johnson and also by the Prosecutor General of Rwanda reminded us a bit of the perspective in which we should see ourselves today. Now, my topic is managing trial, as you have seen. It's 2 words. And how do you, in 10 minutes, make a summary of 2 words based on an experience of more than 10 years? It's a bit of a challenge. First of all, I think maybe some general aspects could be mentioned. A trial is in itself, of course, a wide concept. We all know, because we are all insiders in this room, that there is this distinction between pre-trial, trial, and judgment writing, the 3 stages in connection with one trial. Is this the right volume if I speak like this? Do you all hear me? Okay. So that's for sure. But the link between the pre-trial stage and the trial stage, which I want to stress, namely that you run into trouble if the pre-trial stage is not properly planned, was so well illustrated by what happened in 1999. And since I see some persons here who may not have that experience, that is one of my illustrations to start with. Because in 1999, when the former prosecutor was not given acceptance by the trial chamber to drive one case of 29 indicted persons, the strategy changed, as you remember, to 7 big trials. And that autumn in 1999, when we tried to make those 7 trials ready to get into the courtroom, showed how vulnerable the process was. In particular in connection with disclosure and translation. So that is one example. And another link, and now not between the pre-trial stage and the trial stage, but the trial stage and judgment writing, is of course that the judgment writing starts during the trial itself, at least when it comes to making witness summaries. And that is my second illustration. I remember how the tribunal went a long way from stage 1, not making witness summaries during the trial, stage 2, making summary witness statements during the trial, but in a very summary form, and finally stage 3, chambers writing witness statements in judgment form, which was a huge step forward. So I will not talk more about judgment writing because Roman will talk about that at the appeal chamber, and much is common. A second general point is, of course, that there is a need for an overall strategy when you manage trial. And I'm not now talking about the completion strategy, but rather the trial strategy, which is an important part of it, namely the issue of twin tracking and shift system, and the issue of avoiding recurring problems which have slowed us down previously, according to a lot of experience. How do you avoid them in the future? With other words, the need for planning. And this leads me to this joint responsibility of the entire tribunal when it comes to trial management. Of course, to the leadership, the presidents and prosecutor and registrar's offices, but also, for instance, to the Coordination Council, which was introduced in 2003, where the three of us met once a month approximately since 2003, and which was really one of the important element to make sure that all these difficult general problems could be sorted out. So that was the Coordination Council. And that leads me to the next point, namely that there is generally a need for some kind of comprehension of our role, namely that our work must be based on consultation, coordination, and cooperation with one common goal, namely to facilitate trial management. And the examples given by Jean Pellet, which he had very carefully chosen, are, in my view, excellent illustrations of how the tribunal as a whole has to identify the problems and move on. Because there is a politician who once said, the problem with politics is that everything is linked to everything. But it's exactly the same with the trial. The problem with the trial is that everything is linked to everything. And that is, has been so amply demonstrating during our years on our common journey until today. So there is a need for vigilance all the time, and much more vigilant, I would say, than at the national level. When it comes to the need for planning, which I've already mentioned in a general perspective, I think there are many ways of planning which gradually developed and which I would like to recapitulate. First, the need to plan really the periods and dates for the two segments of the trial, namely the prosecution and the defense case. In the beginning, there was no such trial. It just came a bit happenstance-like. But exactly this kind of long-term thinking, you have this time, you have that time, you have to finish within those periods, was one step forward. And I also think that part of this was a lack of understanding in the beginning of the particular problems faced by the defense, because it was not so easy for the defense who stayed at home part-time, who had to travel and maybe try to survive with their local business at home in parallel. They needed plans, and they were expected to be available, but couldn't always be that at short notice. So this kind of long-term planning facilitated matters for everyone. There was Furthermore, in addition to general planning, the need to meet in advance for each particular trial. And here, of course, you all remember that in 1998, the pre-trial and pre-defense clauses were introduced in the Rules of Procedure and Evidence. That's Rule 73 of the rules. Bicentennial. But then came the trial committee, which Jean-Pelé mentioned. But of course, the trial committee didn't include the defense. So there was also a need to supplement the system with informal status conferences before the trial in order to make sure that everything would run smoothly. Status conferences before the trial, where you discuss disclosure issues, translation, and maybe even things like trial records from other jurisdictions, how they should be solicited, because they might be of wish. And I remember us developing certain checklists about what we had to remember, but which was not in the rules, in order to make sure that we didn't overlook anything. And then, of course, status conferences during the trial, and that was something which became rather popular on both sides, in particular when it comes to planning of within the segment, what would happen the next week or the week thereafter, what would be the exact agenda. That was also something that came gradually. This brings me to the availability of witnesses, which was a huge problem in the beginning. I cannot count all the examples of trial chambers sitting empty, waiting for a witness who didn't come, either because there was a problem in his resident country, or because he had fallen ill before he left, or because, many witnesses being fragile, the witness had become ill just at the eve of his testimony. And that gave rise to this idea of fallback witnesses. And to some extent, there was a need for more than one fallback witness, because the experience showed that the second witness might also fall ill or something would happen. So there was again this need of extra vigilant, I think, in order to make these international trials be efficient. Linked to the witness was another recurring problem, namely when the witness gave new evidence which was not in his witness statement. That was a terrible problem for both sides. Suddenly it appeared during the preparation, the preparatory talks between counsel and the witness that he would say something new. And then he came out with it with the courtroom, and the other party said, "We are taken by surprise, we want an adjournment." A perfectly legitimate thing. But of course, it lost time. We lost time. And for that reason was developed this practice of will-say statements, so that whenever a counsel, the night before even, realized that there was something new, he had to send an email to the others in the courtroom in order to say, "This is coming up," so that the element of surprise was left.
You just mentioned time,
Yes.
and so do I.
Yes.
The timekeeper is to the left, and you insist on looking to the right. That's why you didn't see the warning signs. Can you sum up?
We are about to close.
Yes. Not all others, but you are.
Yes,
If
I
you
am.
could just,
Yes.
round up.
So that these are just a few examples I wanted to mention, as you understand, namely the need to sort out these problems that always reoccurred in order to limit them. And I think that it has been some kind of a journey where we all have contributed, and much more could be said. Thank you very much.
Thank you, Erik Moser. I acknowledge that it must be difficult to give all your thoughts on such a broad subject in 10 minutes. We now move from the trial level to the appeals level and go to the man behind the scene at the appeals chamber in The Hague, the ICTR appeals chamber, Roman Boyd.
Thank you, Mr. President. Good morning, everyone. I will speak this morning briefly about streamlining case management at the Appeals Chamber. With the delivery of the 3 appeal judgments at the end of September, the ICTR Appeals Chamber has reached a point where only one case remains on its docket, the Butara case, which concerns 6 convicted persons and is comprised of appeals by each of them and the prosecution. This means that to date, the ICTR Appeals Chamber has delivered 44 appeal judgments concerning 55 persons. This morning, I will outline how the work of the Appeals Chamber has been organized and how the tribunal has supported this final aspect of its judicial activity. I will then conclude with a discussion of some of the elements of efficient case management at the Appeals Chamber. I will start by giving a brief overview of the structure and output of the Appeals Chamber. The Appeals Chamber is composed of 12 judges, 6 of whom were elected to the ICTR and 6 to the ICTY. Once assigned to the Appeals Chamber of his or her tribunal, ICTR or ICTY, each judge is sworn in as a judge of the other tribunal as well, and serves as a judge in both appeals chambers. The presiding judge of the Appeals Chamber then assigns a bench of 5 judges to each appeal from judgment. Over the years, judges serving in the Appeals Chamber have each been assigned to as many as 10 or more cases of appeals from judgment proceeding simultaneously before the ICTR and ICTY Appeals Chambers. Just looking at the ICTR caseload, for example, last year and also in 2012, the Appeals Chamber had before it appeals concerning 17 persons, which, depending on briefing, it worked on in parallel. Since the first ICTR appeal judgment, delivered in the year 2000 in the case of Sarushago, the Appeals Chamber has delivered between 1 and 6 judgments per year, completing on average appeals from judgment of about 4 persons per year. Okay, thank you. I will now discuss the various resources the ICTR Appeals Chamber has had at its disposal for its support and how we utilize those resources. The number of staff directly allocated to Appeals Chamber support has varied with the workload and the respective budgets over the years, ranging from just a handful of legal officers and other registry staff to a maximum allocation in chambers of 24 legal officer posts. Some of the legal officer posts were earmarked for assistance to individual appeal judges, with 1 associate legal officer being assigned to each ICTR-funded judge at the Appeals Chamber. These legal officers have assisted the judges to whom they have been assigned with all of their cases, both before the ICTR and the ICTY Appeals Chambers. The core of the work of these legal officers has been to assist their judges in reviewing appeal submissions and drafts of decisions and judgments, and assisting in the judges' preparation for hearings, deliberations, and in their review of judicial drafts. When needed, and workload permitting, the associate legal officers directly supporting individual judges have also joined drafting teams whose work and composition I will now describe. Thank you. Under the direction of the presiding judge in each case, we have formed drafting teams to assist individual benches of judges on the various cases pending before the Appeals Chamber. The function of the teams has been to carry out focused research and drafting on individual appeals. In each case, the team would assist the presiding or the pre-appeal judge in monitoring the pre-appeal activity in the case, in researching issues arising, and in drafting pre-appeal orders and decisions. The drafting team would also assist the bench in preparing for hearing the appeal or appeals in the case and in preparing for deliberations. An important part of this process has been assisting the judges in preparing a compendium of all submissions and issues arising in an appeal, compiling all relevant jurisprudence, and in analyzing the submissions and issues in the appeal in light of the applicable law. Finally, the drafting team would assist the bench in the appeal judgment drafting process. We have kept our drafting teams as lean as possible In our experience, this has contributed to keeping to our timelines and producing quality drafts. This is perhaps because on small teams, the working relationships are close and dynamic, and every team member feels ownership of the work in the case and also the urgency of every assignment. For example, in a case concerning one convicted person and 2 appeals, we might have, as the immediate drafting team, 1 coordinating legal officer working with 1 or 2 junior legal officers. Normally, these legal officers would also be working on other cases in parallel, which hopefully would be at different stages of briefing or preparation. When needed, we would assign additional legal officers to the given case to complete a task, like specific research or site checking, or to meet a deadline. With this background, I would now like to highlight some of the factors for efficient case management at the Appeals Chamber. The foundation for efficient organization of Appeals Chamber support has been the making of projections that forecast the overall caseload, and within it, the various stages of individual case preparation and judgment drafting in terms of months, indicating the staffing level needed for each stage, for each month. As circumstances evolved, for example, as projected trial judgment and delivery dates changed, or as briefing deadlines within the case were adjusted, we updated the projected appeal schedule to reflect a current and realistic forecast, keeping in mind our lean and flexible staffing model. In turn, we used the projections as basis of budget requests, ultimately leading to recruitment and staff on board. Once adequate resources were ensured, we strove to employ them efficiently. To this end, we have relied on dynamic team management. As I mentioned earlier, creating small drafting teams and having staff work on multiple cases at a time, allowing them to redeploy between cases and assignments depending on case management needs. This has helped ensure compliance with timelines and also that everyone has had an even workload. We have tried to organize support to the Appeals Chamber in such a way that legal officers assigned to a case at the judgment drafting stage were also assigned to another case in the pre-appeal stage, so that, for example, the drafting team or the various legal officers could turn to pre-appeal work in one case when awaiting comments on a judgment draft in the other case. This dynamic team management was predicated on the continuous monitoring of developments and progress in every case. I had already touched on the preparation of a compendium of submissions and applicable law and analysis in preparing an appeal for a hearing and eventual deliberations and judgment drafting. This compendium, or extensive bench memorandum, or preparatory document as we have called it, has had a major impact on effective and efficient appeal case management. The preparation of such a compendium in a given case has highlighted for the bench all issues raised by the parties, as well as all relevant jurisprudence, and has identified in advance of the hearing of the appeal issues needing clarification from the parties. In addition, the preparatory document has facilitated the judge's deliberations and the judgment drafting process, as it has provided a streamlined presentation of the issues and applicable law with full references to the parties' written and oral submissions, case record, and jurisprudence. This has expedited the judge's consideration of the issues presented in the given appeal, enabling the appeals chamber to deliberate and draft and deliver a judgment within as short as 5 months of hearing the appeal, as was just recently done in the Nzabonimana and Nizaimana cases, for example. Finally, I would also like to emphasize the indispensable role of timely translations in the efficiency of the appeal process. With the tribunal having 2 official working languages, the appeals chamber has granted requests to vary the briefing timelines to allow for translations to be prepared and filed. The language section was of course seized of translation requests not only for trial judgments and party submissions that were necessary for appeal briefing to proceed, but also for other translations. It has therefore been vital for us to closely coordinate with our colleagues in the language section to indicate and periodically review the level of priority for the various translation requests, and also to keep the projected appeal schedule to date. With this, I would like to close my overview of streamlining case management at the ICTR Appeals Chamber. I hope that I have managed to highlight the key aspects of our organization that have by this point enabled us to fully complete all but the last case before the ICTR.
Thank you, Roman Boyd. We now move from the registry and chambers to the office of the prosecutor. I give the floor to Pendra Patel.
This my presentation. I will deal in two parts. One is evidence management and second is case management from OTP perspective. As we know, international crimes are very complex. They deal with socio-political situations, historical cultural regions, and they are extended over a time frame. They are multidimensional and they are perceived differently by different people. Keeping in this background, what type of evidence we gathered in last 20 years almost working? The sources were various investigation papers came through our investigators in Kigali and from various offices and different places. Then some documents were received out of cooperation with other states and some other organizations. Types of evidence, basically documentary in the form of witness statements, even diaries, maps, diagrams. Diaries, they were handwritten in multiple languages. Kenya-Rwanda, many documents were in Kenya-Rwanda and the French. English were very few documents. Some documents were in different languages, like Dutch language or some other languages. Then we have exhumation records, radio broadcast, audio video tapes, interviews, even x-rays and pathologist reports. If we compile these evidence, there are almost 1 million pages of evidence in OTP. When it is preserved or is stored, it goes 700 linear meter. So we can think of large volume of evidence we have. How it is to be preserved? There was OTP made environmentally controlled with fire detection and suppression system room where they are kept and storage room with strict access control. How to analyze this evidence which was paper based or in some other form? That's why all the evidence were digitized and they were records, digitized records, and they were categorized, they were cataloged in different series to facilitate us. Now we can think of such a large volume of evidence which was gathered not in one day, after 94-95, in last 19 years or so. So it happened most of the time, the evidence which is available, which is not available in 2004, may be available in 2006. So that's how the problem came, this database generated over the time. GILAB is one of the our evidence management tool, because with technology changes after 2000, as we know, then GILAB came up, and GILAB is the repository, main repository was there where all documents were scanned. And they were text searchable with logical methods. I'll go through how this GILAB was used as a research tool later on. Now after this, let me go to the case management issue. OTP rightly assess that streamlining the case through case management is the best tool, because onus is on the prosecutor to prove the case in the court and to bring the case in the court. So case has to be managed efficiently. So through case management, all the cases were streamlined. There are two kinds of mechanisms were adopted. One is OTP-wide mechanism, which every team is following, and second is team-wide mechanisms. OTP-wide mechanisms, basically electronic tools were used largely. Various databases, softwares, because technology is changing. GILAB is one of the tools which was used for case analysis. Research, analysis, access, and to get the documents. Even I was in Kigali before 2000, GILAB was not there. But when GILAB came up, then all documents are available immediately and all OTP members were given. It's like like some kind of multiple users. Access to all staff was given. Second is for coding and decoding of our witness, because all the witnesses were protected by and large. So giving them pseudonym, there was database, GELOD, which is Global Evidence Legal Officer database was used. Text map was used, is a transcript management software to search the transcript, to locate evidence on the, to locate and then summarizing them. Case map was case analysis tool which was used to link evidence, facts to objects and issues. And it gives the reports. That's how we analyze each case on various facts and issues. Analyst team used analyst notebook to link targets to facts and evidences. Then OTP witness management database was there. Then conflict itself, as I told, conflicts are very complex. How to understand the whole conflict, which happened in 94 and it's having historical regions from 1959 and even much beyond. Master chronology was developed in OTP, where all the events and incidents were plotted on time frame and location. That's how OTP got a whole overview of how events were happening in different parts of Rwanda. Various experts' assistance was taken. Expert on socio-political field, administrative structure, constitutional experts, medical legal expert, language expert, and a lot of videotapes and Radio Rwanda RTLM tapes were analyzed through Kenya Rwanda experts. Sharing of information among the OTP members, because OTP was a large unit, hundreds of staff was there, how to share this information. That's why OTP held regular meeting and support units were created, which was centrally located support units. And they were specialized in different fields. That's how every member will access them. Then OTP portal was developed where information was there to all OTP members. Review of indictment, because indictment is the basis on which charges are there and the whole case is being laid out. There was a review committee in OTP which used to review the indictment, and that's how it became very helpful, that it ensured that indictments are evidence and facts laid on the basis of facts. Then each team had its own mechanisms. Each team did thematical analysis and evidence analysis on each case. Thematic analysis where they were putting evidence according to the themes of the case. What themes are there, like killings, incitement, meeting, or arms distribution, they have evidence, list of evidences. And evidence analysis, what kind of priority of evidence? So all evidence are listed. There may be witness statement, contextual evidence, documentary evidence. Then each team is having its own case management timeline, where they will put how the trial session is starting, scheduling witness, how the witness should move, and how witness to be examination. And through this timeline, we do the advanced planning. Disclosure was also done very systematically by all the teams, both incriminating and exculpatory material. As we know, format of disclosure kept on changing. Before 2000, all were paper format disclosure. After that, disclosure was done in CD, DVD format because volume was large. Then the record keeping was done. Tables were made in Excel sheets or table or GELOD format. And in the last, latter part of 2004, 5, 6, we developed electronic disclosure suite, which was very helpful so that defense can access it from remote locations. Pre-trial briefs were very focused, and as Judge Moses had discussed, time limits, word limits, they kept OTP focused on the issues. All those. Out of this exercise, which in last 20 years we have learned a lot of lessons, because these were very complex cases, happened after Nuremberg and Tokyo trial first time, ICTR, ICTY, and we learned lessons. So these lessons are basically in the field of evidence management, OTP witness management, and disclosure system. In the first evidence management, we have to put our preservation, storage, and analysis techniques as the type of evidence is changing now. Form of evidence and volume may change it. Witness management has to be more proactive because now people have digital identity. How to track witnesses? They have digital identity. GPS location can be used. How they are meeting, contacts will be listed. because it can be more web-based mobile application can be done. Same way disclosure system, there may be a centralized unit, and centralized units can be there to do research analysis, and it can be a focal point for all teams. It can support the teams. That's all my presentation. Thank you very much.
Thank you, Upendra Bagel. We now turn to a division which has become more and more topical in the transfer of responsibilities from the ICTR to the MICT, namely the archives of the registry. So I give the floor to Tom Adan.
Thank you, Mr. President. Distinguished guests, ladies and gentlemen, colleagues, it's a great honor to be here today to talk about the legacy of the ICTR archives, and I was going to highlight some lessons learned from my time managing the Judicial Record and Archive Unit between 1999 and 2007. During the course of its 20-year existence, the ICTR has generated over 4,000 linear meters of records. To provide an illustration of what that means, if you were to place archive boxes, which are yay big, side by side, they would reach over 4 kilometers. And for those of you who are familiar with the Arusha environment, that would be from the ARCC building to roughly Sakina or down past Temi Hill. One unique aspect of the records of the international criminal tribunals is the high percentage of records that have archival value, which means that they have been designated for permanent retention. When archivists talk about permanent retention, that's exactly what we mean. We are obligated to keep these records forever. For most institutions, between 5 and 10% of their records are considered to be of archival value. But for the ICTR and the ICTY, approximately 50% of the records have archival or enduring value. In other words, approximately 2 kilometers of the ICTR's 4 kilometers of generated records will be retained permanently. These are, of course, just the physical hard copy records. We do also have petabytes and petabytes of digital records. The ICTR's archives include records generated as a result of all the ICTR's functions, including the operations of the detention facility, provision of support to Defence Counsel, investigations and prosecutions undertaken by OTP, the support and protection of witnesses, external cooperations in relation to enforcement of sentences, among others. Going back to the concept of the 2 kilometers of records which will be retained permanently, I'd like to draw your attention to a segment which is approximately 550 meters long, consisting of the judicial records, which are all records created or received as a direct result of the ICTR's core function, the judicial process. This includes all filings such as indictments, motions and submissions from parties and non-parties, and decisions, orders and judgments issued by the chambers. Also included are 20,000 exhibits tendered in court in cases before the ICTR, as well as the transcripts and audiovisual recordings of approximately 5,800 days of hearings. When the ICTR was established in 1994, the concept of using digital technology to facilitate access to records was still a relatively new concept. Only hard copies of judicial records were maintained, and any user would need to physically visit the court management section to request copies of records. This meant that if a representative from Defence, OTP, Chambers or the Registry required access to a record to be able to carry out their work, they would need to line up in the corridor of the first floor of the Kilimanjaro wing to wait for a photocopy. Within 5 years of its establishment, the ICTR Registry had acknowledged that this method of managing records was not efficient and was not adequately facilitating the judicial process. Therefore, in 1999, the ICTR implemented the use of an electronic records management system to ensure that the users of the judicial records had access to the information they needed when they needed it directly from their offices. It was decided that a system called TRIM, which is an archive and record management application widely used within the UN system, would be implemented at ICTR. A professional archivist was hired to oversee its rollout and configure the system to meet the specific needs of judicial records. In 2000, the backlog of judicial records, which had been created up to that point, were digitized and entered into the TRIM system. At that point, the ICTR had completed between 5 and 10% of its judicial work, and the backlog of judicial records consisted of approximately 50 linear meters. While this quantity is certainly not insignificant, the impressive foresight demonstrated by the ICTR in having implemented this system early on cannot be overemphasized. The early action taken by the ICTR to improve work practices in relation to the management of its judicial records is commendable. In the first years after its implementation, TRIM was not particularly popular with the legal officers, but in time it became indispensable to the work of the tribunal. Between 2004 and 2008, during the peak years of judicial activity, internal users of TRIM accessed on average 300 judicial records every day. It's not difficult to imagine the daily queue on the first floor of Kilimanjaro if those users needed to visit the court management section to request a photocopy. In addition to facilitating the work of the tribunal, the implementation of an electronic record management system also enhanced public accessibility to the ICTR's judicial records. In 2003, a public interface of the TRIM database was released and remains accessible on the ICTR website to this day. It provides external users with direct access to all public judicial records of the ICTR, greatly enhancing the ICTR's visibility and promoting awareness of the important jurisprudence created by the ICTR over the past 20 years. The ICTR has also undertaken impressive records preservation initiatives. The judicial records include not only records in paper format, but also the audiovisual records. Between 2008 and 2011, the ICTR successfully completed a project to generate preservation quality digital files of all audiovisual recordings of its court proceedings, numbering over 27,000 hours of proceedings. This ambitious and technically complex project remains, to the best of our knowledge, the largest scale audiovisual digital preservation project ever undertaken in at least this part of Africa, if not within Africa. As a result, the preservation of this key component of the ICTR's legacy is assured. While the ICTR has done many things right in relation to the management of its records and archives, there are some areas which could have been done better. It's with that great thing, hindsight. We're all wiser after the fact, and which offer the could have been done better, and which offer the opportunity to develop lessons learned for the mechanism. For example, while preservation was the primary objective of the audiovisual project, enhancing accessibility was also a goal. Publicly accessible versions of the audiovisual recordings were not produced at the time that the hearings took place, and the audiovisual project therefore also included a redaction component, which entails the removal of confidential information to produce a second copy of the recording, which can be made accessible to the general public. Audiovisual redaction is a time-consuming and labor-intensive process. While this requirement was identified in 2003, it wasn't implemented until 2010. The implementation of procedures to produce publicly accessible versions of the proceedings in real time when they are recorded would have prevented this shortcoming in terms of accessibility. This should not, however, detract from the considerable accomplishment achieved. The recordings most likely to be of interest to the general public can and will be accessible once they are transferred to the mechanism. Another area which in hindsight could have been improved is the centralization of record management responsibility across the entire organization. I was only responsible for judicial records. There was somebody else who managed the administrative records. OTP had their own information management unit. So in hindsight, that could have been more centralized and harmonized at the enterprise level. Another result of the lack of centralization was that there was a delay in development of key policy documents, which should have been undertaken a lot earlier. There is a common misconception that archives are all about the past, but there's no real point in maintaining archives if they're not accessible for future users. The role which the archives of the ICTR can play in contributing to the field of international criminal justice and ending the culture of impunity is unquestionable. Third-party partnerships and collaborations with similar institutions, access and outreach programs and capacity building initiatives are all areas which should be explored early on in the life of any organisation responsible for managing records. While the ICTR has made significant progress in these areas, a lesson which the mechanism can learn from the ICTR is to embark on these types of initiatives as soon as possible to maximise their effectiveness. If I may run over time a little bit, it's appropriate to mention at this forum that the ICTR Archives was nominated and shortlisted for the inaugural UNESCO Memory of the World JICJI Prize in 2005. So it's internationally acknowledged that the ICTR Archives is unique and worthy of high praise. In conclusion, the legacy of the ICTR will live on in its archives, which capture the accomplishments of this historic institution. By enhancing public awareness of past abuses of human rights, war crimes and genocide, as well as the significant contributions made by the ICTR in the field of international criminal justice, the archives of the ICTR have the potential to contribute to the prevention of the occurrence of future atrocities and strengthen the concept of international rule of law. I'm honoured and proud that as an archivist with the mechanism, I have the opportunity to contribute to preserving and enhancing public awareness of the ICTR's legacy through its archives. Thank you.
Thank you, Tom Adamia. I was especially pleased to hear that our archives only reach the top of Mount Meru. I thought it was Mount Kilimanjaro. Because of the time that the opening took, we have to break now for our mid-morning tea break. I hope you have noticed how disciplined we've been up here time-wise. And I appeal to you to show the same type of discipline and come back not later than 15 minutes. That's 10:45. Yeah.
Thank you for taking your seats, ladies and gentlemen. Welcome back in, Karibu. And thank you for reconvening so promptly. We will now hear from our three discussants that Judge Johnson will kindly introduce. But prior to that, I will beg your indulgence for a short housekeeping issue. During our next break at the lunch break, I would kindly invite the participants who were sponsored to provide us copies of their passports. That could be done at the registration desk, and it's a must for administrative reasons. I thank you very much. Judge Johnson?
Yes, welcome back. I'm not quite as grateful as our master of ceremony of the discipline, but it will go from your time to ask questions to the panel, so you punish yourself. But first we will hear the remarks of the three discussants, and the first to go will be Susan Knapp.
Thank you very much, President Jonsen, and thank you very much for the organizers of this fantastic event. It's been immensely moving for me to return not only to a place where I spent 4 extremely happy years of my life, and to see so many friends and colleagues from many parts of the world, but also on this occasion of the 20th anniversary of the Rwandan genocide. Like many of the panelists today, I confront the impossibility of distilling the totality of the lessons learned in trial management from my experience of the ICTR within 5 brief minutes. But I'm going to take as my point of departure where the colloquium yesterday ended off, and that is to look towards the future and the reality that many of the future proceedings in this area are likely to be in the form of hybrid tribunals or direct international assistance to domestic prosecutions. And what I'm going to do is try to distill in 5 brief minutes some of the lessons that I took away from my ICTR experience that benefited or at least influenced the trial chamber of the ICCC in Cambodia, which, as many of you will know, was a hybrid tribunal based in Cambodia. And I really have to thank with a huge amount of gratitude the experiences that I had here, because I think, in essence, in a nutshell, the ICCC in trial management confronted absolutely every last one of the problems and the challenges that the panelists identified today, and then some additional ones as well. Another theme that I would like to highlight is that the role of the senior legal officer can be also immensely useful in terms of efficient trial management. Essentially, by its ability to establish informal channels of communication with individual parties and the parties collectively. The aim of that is to firstly convey information to the parties, to alleviate any concerns they might have, to avoid any small day-to-day irritations and resolve them proactively, and also to obtain from the parties information that is up-to-date and relevant in terms of trial readiness. The overall goal of these initiatives is basically to prevent these small irritations from leaching their way into the courtroom, which will simply impede the process in a way that's unnecessary. This can be challenging in certain quarters, and it was before the ICCC, because that sort of channel of informal communication is not equally accepted across all judicial cultures of the world. But given the size and the scope of trials of this nature, everybody rapidly came to appreciate that absent some form of dialogue that is outside the courtroom, it's really just effectively impossible to manage proceedings of this sort of scope and size. Language issues bedeviled the ICCC as well, for all of the same reasons that Dr. Formete highlighted. The added difficulty of a hybrid tribunal or a national tribunal is that one loses the luxury of being able to operate solely in one language alone, whereas in the ICTR, chambers would either be in effect francophone or anglophone. The reality is that in order to have any form of discourse whatsoever, translation into Khmer was a functional necessity. The way that we managed that was to actually have a lot of informal meetings between the trial chamber president and myself, where he could be apprised of routine issues and thus obviating the need for the entire chamber to meet, and with incidental translation demands. The reality of having a trial chamber presided over by a Khmer-speaking president completely obviated any ability to render a lot of oral decisions spontaneously, because those same decisions needed translation. The final thing that I would mention is that the ICCC experience graphically highlights the problems of the size and scope of trials in relation to severance of proceedings, whereas my experience from the ICTR distilled a lot of experiences in managing multiple cases simultaneously. The ICCC was one single case of massive dimensions. It had a very streamlined indictment of merely 780 pages. It had 4 elderly accused, all of whom were in their 80s, 2 of whom ultimately did not survive to the verdict. And it became absolutely essential to limit very drastically the size and scope of proceedings. We did so through severance, which has a different role before the ICCC. And while severance was necessary, it unfortunately proved to be problematic to implement, absent sufficient consensus by the parties regarding this role. So to briefly summarize, trial management before the ICCC required very brief, short decisions, many in memorandum format, a lot of informal meetings outside the courtroom, drastic reductions in witness lists and the scope of the trial, and specific management of victim participation of 4,000 victims aligned to the trial, which was fabulous in many senses, but not an unalloyed gift to effective trial management. So I will leave my remarks there. Thank you.
Thank you, Susanna. And I give the floor to Will Patterson.
Thank you very much, and I'm also very honored to be here, and thank the organizers for inviting me today. At the outset, I just have to say that I'm here in my personal capacity and that my views do not necessarily reflect those of the Government of Canada. So with that, I want to pick up also on some of the themes of the presenters today and discuss trial management based on my experience in the Office of the President, the ICTR, with both judges Byron and Khan. In particular, I'd like to discuss pretrial practices that are aimed at improving trial efficiency, which were in many ways, of course, pioneered by Judge Moza, and to pick up on the theme of consultation, coordination, and cooperation. As Dr. Fomente mentioned, these initiatives have shortened the length of time required for trial, and they operate while upholding the highest standards of fair trial rights. Of course, as many of the panelists have discussed, international criminal cases are often complex, with the added challenges of availability of witnesses in faraway countries, scheduling, translation, evidence that relies on international cooperation. And it's important for the sustainability of international criminal mechanisms to ensure that best practices are put in place to make trials as efficient as possible. So I'm going to just briefly discuss elements of pretrial that have not yet been mentioned, and then I'll expand on elements of the informal pretrial process that have been touched upon by Judge Moza. And if I have time, which I don't think I will, so I'm not sure why I'm saying this, but discuss the importance of early review of the indictment at the end. So it's important, first of all, to appoint a pretrial chamber early on, which was really responsible for preparing the case for trial and convening all the parties. And the pretrial chamber makes sure that there can be a smooth transition to trial, and that transition is done effectively to trial. Also important is the expedient appointment of defense counsel, so that all parties can be involved in the pretrial process from the outset. Now just moving on to discuss the informal status conferences and expanding on what Judge Moza has already said. At the first opportunity, the pretrial chamber would meet informally with all parties to set expectations, get a sense of timing, and also possible roadblocks along the way. So what are some of those roadblocks and challenges? And I'll go through each party involved. With the defense, it's really to find out if there are any issues anticipated at the very beginning. Can the trial chamber or other sections of the tribunal help? Often these issues involve international cooperation or resources. For the prosecution, to ensure early disclosure of evidence. For translation, has been mentioned before, to make sure that that translation knows what's required, and also that early translation can be done. So can translation get a head start before the trial begins? With court management, to plan trials to favor space and also resources, and with victim and witness services, if parties anticipate, they'll call witnesses from abroad to make sure that that process starts from the beginning. And then finally, and Susan kind of mentioned the role of legal officers, but to make sure chamber staff are there as well to effectively support the judges and also to get to know the parties at the outset. And we really found that informal meetings are helpful in establishing a collegial environment to make contact for all parties and to make sure parties support the timetable and have raised any potential problems early on. We also found that this practice led parties to contact each other directly, and also, as Susan mentioned, to help to use legal officers to resolve problems early on. And if firm timelines can be established at the conference or at subsequent meetings, it would be quickly followed by a scheduling order by the trial chamber outlining milestone dates, so what dates the parties need to meet. And then the chamber would track those timelines and milestone dates closely, and where there were not extenuating circumstances, try to hold the parties to the agreed timeline. Now, I only have 20 seconds left, so I think I'll probably wrap up there and not discuss indictments, but if anyone wants to discuss that in the Q&A, I'm happy to. And thank you very much.
Thank you, Will. And now to our last discussant, Andres Perez.
Thank you, President Johnson, and thank you to the committee for the opportunity, for providing me the opportunity to be here. Rather than take my 5 minutes to illustrate groundbreaking strategies for streamlining the drafting process, I'd like to share with you how to use some basic established procedures and strategies to efficiently manage your time, and above all else, to keep pace, especially if there is a looming deadline that is quite intense. Sorry, a bit loud.
No, not loud, it's just the interpreter.
Yes, okay. Drafting a judgment and coordinating a judgment drafting process can be very intimidating, particularly if you're dealing with a complex, multi-accused case. And one thing I'd like to suggest is the value of drilling down and breaking up the process into its constituent parts. And then once you have those, for example, when does the outline need to be done by? When do the deliberations need to begin? When must they end? When would we need the footnoting to be done and the summary? And if you place those carefully into your calendar, you're already going to have a roadmap for how much time you have to do these things. And as you continue to go down and create internal deadlines, you're going to make your life a lot easier, because otherwise you're staring at a seemingly insurmountable task without a real clear sense of where to begin and where certain bits need to end. As a second point, I'd like to underscore the value of sticking relentlessly to that schedule once you've established it. Of course, flexibility is important. Things will change. There will be transitions and turnovers. And you can adjust within the parameters of threshold deadlines, but you must always, if I may, observe those. For example, with a deliberation schedule, if you've established that you absolutely must have 3 deliberations per week so that you keep pace, and you can only have 2 in 1 week, make sure you do 4 next week. I know this sounds basic, but it's really, really important to never let go of the process, because this is not an area where procrastination is in any way possible. I'd like to underscore the value as well of understanding and appreciating the big picture when these judgment drafting processes happen. A lot of times in multi-accused cases, as opposed to single accused, you aren't dealing so much with a discrete set of facts in one location at one point in time, but rather a vast array of happenings over years and years and years. So as a result, if you become too focused, in my opinion, on individualizing parts of the indictment without understanding how they interrelate, all right. But yeah, so understanding the big picture is crucial. And that actually is really important for time management, because frequently, if the big picture is lost, particularly on matters such as joint criminal enterprise, command responsibility for high-level superiors, drafters are going to be sent down rabbit holes with their drafting, which is frustrating and demotivating at times to the drafter if this continues for too long, but it also slows down the process and causes people to spin their wheels. If you understand the big picture as you embark on the process, it's less likely that you will waste time drafting options A, B, C, D, E, F, G, and H. You'll maybe narrow it down to 2 and make a decision from there. I'd like to also mention how important it is to keep the drafting team motivated. Oftentimes, one is under extreme pressure, there's a lot of work, and if one is to expect a lot from the drafting team, I think it's also important to convey a little bit of understanding in return. For example, the Caramera team did not apply a moratorium on leave to its drafters at all, which I'd like to think reduced or increased motivation. I can see that my time is running out. I'd like to say that while these may seem like basic tactics and perhaps self-evident, if you apply them correctly, it can produce very good results. The Caramera case had a particularly intense deadline, and we were able to complete our drafting process in slightly less than 1/3 of the time that is normally taken by multi-accused cases of that size. So it works. Thank you for your time.
Thank you, Andres. Do the comments from the discussants call upon any replies from panel members? It doesn't seem to be the case. So now the floor is free. We have micros at the tables closest to the high table, and we have a sort of floating micro for those who are sitting behind. If you want to ask a question to the panel members and are lucky enough to get the microphone, please first state your name and your professional link to the symposium, and also indicate if you ask the question to a particular panel member or to the panel as a whole. And please be brief. So, do you need a microphone? Who's in charge of them?
Hello, thank you. I'm Dov Jacobs from Leiden University. And my question is related to the drafting of the judgments. What comes out of the discussion is the issue of time management, trying to make things faster. And I think this is, the issue of legacy implies a certain level of transparency. That's, when you're talking about legacy, you're talking about communicating something. And unfortunately, a lot of what goes on inside chambers is not transparent and cannot be due to confidentiality issues. But I think that's really important, and I pick up on the comments of the last discussants. I mean, beyond issues of translation, beyond issues of listening to witnesses, making summaries in advance, there are issues in the drafting process itself, which everybody who's worked in a tribunal or knows how it works are inefficient, and I'm sure, or possibly not, the two judges can give us some insight on that. But in terms of rewriting judgment protocols, I have the impression 20 years down the road that every new chamber is reconsidering how to draft it, in what order to put it, in what way to summarize statements, how to do footnotes. It's as if reinventing the wheel every time. And the ICC is doing the same thing. So more recently we had a confirmation of charges decision with endnotes, which is unreadable. So that's one example. The question of teams. The question of some teams at the drafting stage which weren't there during trial, don't know the trial at all. Change downsizing, which has affected some tribunals, which would not affect the ICC, I'm sure. But these are very concrete issues where, even if we're talking theoretically about competence, which is another issue, but we might discuss at another point, you cannot try to judgment efficiently if you don't have the team that is the same at the beginning of the drafting and at the end. You have downsizing, staff is rotating a lot, staying just 3 months and moving to another case. And I think these issues need to be discussed as well as a legacy of the ad hoc tribunals for the ICC. Thank you.
Oh, thank you. We take a few more questions before replying. Anis.
My name is Anis Ahmed. I worked in the chambers in ICTR until very recently. My question is possibly to Roman, Judge Moser, or Andres as to the use of technological aids, case management tools like case map, etc., in drafting judgments. That's number one. And possibly how the judgment drafting process should start from the first day of trial rather than after the final arguments. If you have any thoughts on that, thank you.
We take one more. Yes, Judge Ray.
My name is Florence Array. I was a judge here for 9 years and left as the vice president. And I thank Judge Mose for inviting me. What I want to say is really not a question, but a comment concerning the management of the court trial. Sometimes the efficient management of a trial depends on the trial chambers. There are some of our colleagues who are very lenient. They can allow the counsels to ask one question 10 times, and this affects the length of the trial. And also, there are some motions that some judges just accept anything. I know that some trials take very long because they grant motions for witnesses to be recalled. They allow witnesses to be questioned on the same issue 10 times without any comment or so from the presiding judge or the members of the trial chambers. Whereas if they had limited those questions and said the question after the second time, say the question has been asked and answered, it would have been more efficient and the trials would have taken a shorter time. That's why we have some trials that have gone on forever. Thank you very much.
It seems these 3 questions are somehow interlinked, so I give the floor to the panel members who wish to respond to them. I think the first one was mainly to Andres, which as I understood.
Okay, yes, and thanks for that very good commentary and good questions on the efficiency of judgment drafting. Perhaps I'll seize on the point of staff turnover. I would agree that in an ideal world, you would have the same team drafting from day one all the way throughout to the day of judgment delivery. Unfortunately, that doesn't always prove to be the case. But there are ways, in my opinion, that one can circumvent the problems that occasions. For example, in the Caramera case, we had turnover throughout the trial and also throughout the judgment drafting phase in our chamber's staff. But to sort of counteract the negative effects of that, we instituted a rigorous schedule of team meetings to keep people abreast of what is going on. We held full induction into the relevant facts to new team members, and also importantly on large substantive issues such as the contours of JCE, in our case also extended liability for JCE, command responsibility. We held trainings for the interns, for the junior drafters, and to really refresh the drafters even that had experience, to try to make sure that nobody was behind the 8 ball, so to speak. And I'd like to think that in conjunction with manuals that were developed and resources for the drafters, that helped us stay on track. Thanks.
Thank you, Andres. I think Anis's question was directly directed to you and, among others,
Well, Let me first say that I think we are all on the same wavelength, actually. We want to have judgment writing which has continuity, which starts as early as possible, where there is the same methodology all the time, when there are deadlines during the process, and where the witness summary starts from day one. I see no disagreement there. When it comes to whether the methodology may change from chamber to chamber, that is possible. But whether it change within, with other words, trial chamber 1, 2, 3, it's possible. But at least I can say, and Judge Harry will confirm that with all our trials, we had exactly the same methodology, and we were quite happy with it. Then the comment from Judge Harry, if I may pick that up, I agree with the fact, with the need of court control in order to avoid loss of time, and that is something I really think is absolutely necessary in order to save time. Of course, lawyers came from different traditions, and they may get a bit upset, in particular if you intervene in connection with witness questioning. And the point is to do it in the right way so as to find the balance, and so that both parties are affected, that everyone sees that it's about the truth, and that it is done in a fair, transparent way. Thank you.
Roman?
Maybe just from the appeals chamber point of view, about our drafting process, we have maintained the same working method since 2004, and we apply it in every case. We have not had as much staff turnover, I think, as was the case at the trial chambers, and also our timelines are briefer than timelines for trials. And so that means that we don't necessarily lose staff during a case, and also that the staff that we have are sort of well trained in applying the working method. Of course, as we come closer to the end of our mandate, there is more staff turnover, which is a concern, especially in a complex multi-appellant case. But we have tried to ensure continuity by having more than one coordinator in a case, for example. So on a complex case at the end, we have essentially 2 coordinators and the senior legal officers involved in every case. And so, of course, people will move on, but I think that we have tried to cover for this potentiality that we lose staff during the process at the end.
Thank you. May I ask? May I add that at the ICTR we had a legal linguist whose job it was to try to harmonize the terminology among all chambers. And also you said about chambers using different formats. In my chamber we had 2 formats, one for multi-accused trials and one for single accused trials, because they're very different. We are ready for more questions. Yes, Peter Robinson.
Yeah, hi, I'm Peter Robinson. I was a defense lawyer here, and I'd like to I'd like to just ask each of you why it's necessary to write such long judgments.
Well, we'll take a few more questions before the panel tries to answer. While we're waiting for people to come up with more questions, maybe we can take Peter Robinson's. Jagmose, do you think you wrote 2 long judgments?
Thank you very much for the question. The Bagli-Shema judgment was too long. It was the first acquittal, and it was 400 pages. It was too long. But it was such an extraordinary thing to do. It was the first acquittal ever, and there was a dissenting opinion, and it was just on the borderline, so the trial chamber felt that it was less than 400, but still it was long. I think everyone agreed that the judgment should be as short as possible, and there was a direct intention within the chamber to go down as much as possible. And I think you would see that for the single accused cases, we managed pretty well in most trials, I think, with about 100 or a bit less. I think it was difficult, also relating to the appeal chamber, to get further down. It's possible, but that's my answer. When it comes to the multi-accused trials, well, I'm guilty of 400 pages in one, but not 600 and not 700. I pass the question on.
Susan Lam.
This is definitely something that we confronted before the ECCC as well, and I would actually add to that question, I don't think it's simply a matter of length, it's a matter of language and accessibility as well. And in an environment such as Cambodia, where the number of fully qualified translators were less, we actually had a conscious policy within the trial chamber of having decisions as short as possible, having many decisions on procedural issues, particularly ones that were non-controversial, to go out in memoranda form. We had a rule of thumb within the chamber that where possible, interlocutory decisions would be less than 10 pages, unless there was an absolute need otherwise. But just to give a little bit of a flavour for why there is sometimes pressure to go beyond that, is that in relation to one of the more painful of our decisions before the trial chamber, namely severance of the proceedings, which was disputed in particular by the prosecution, that was one of the few exceptions in the trial chamber that went to 75 pages, because simply to address in a meaningful way all of the various strands of argument, even with deft drafting practices, the decision ultimately grew. And unfortunately, we were castigated by the Supreme Court chamber for failure to elaborate on some of those. So I think sometimes that's counterbalanced by the need to actually fully evaluate evidence and to address all the arguments of the parties, knowing that there's appellate scrutiny in relation to that. I think the other thing is that streamlined judgments are best facilitated well before the judgment process as well. Thus, a prosecution case that is as streamlined as possible, that causes fewer witnesses as possible, and that clearly links evidence that is being relied on to allegations in the indictment, will all immensely help a trial chamber's ability to organise not only its time but to streamline its judgment process. Thank you.
I think part of the answer, at least with respect to the interlocutory decisions, is that Peter Robinson submitted such long motions with so many arguments that we have to address. I know that Andres Perez wants to make a comment as well.
Thank you, President. Just to touch briefly on Anis's question, we didn't forget about you, Anis, about the use of technological aids. In the Caramera judgment, we did rely for some time on CaseMap as a technological aid, and I would suggest that it was helpful. Nevertheless, I would caution against considering a technological aid a surrogate for basic hard graft, and in particular, a rigorous deliberation schedule. In my opinion, deliberations are the beating heart of the judgment drafting process. It's the period where ideas are tossed, where the judge's recollections serve to point the drafting team in the right direction, and it's quite valuable in that regard. If we had the technological aid alone, we'd be left with a vast repository of about 5 years of evidence, and then still beg the question, where do we begin to search? So I think it's a good asset, but deliberations are the most key. Thank you.
Thank you. And we already have 3 names who have asked for questions. The first one is Charles Phillips.
Thank you. Former senior trial attorney, ICTR. My question is for Roman Boyd. I just wondered in appeal cases why it still takes 5 months to have an appeal judgment, based on the fact that you would have had the pleadings between the parties well before the oral arguments, and you have all the staff and all the jurisprudence. Why does it still take 5 months. I'm not terribly concerned or convinced, rather, that that is a success, a marked success at this stage, 20 years down the line, that it still takes 5 months to have an appeal judgment rendered. That's the first question. The second question is, how much input do judges themselves have in these judgments, considering the level of staffing that you've described here? Do judges actually write their own judgments? And if not, why not? What do judges then do if they don't write their own judgments? Would it be possible, perhaps, to appoint a lead judge in every chamber to write a judgment like it's done at the African Court for Human Rights here in Arusha, and then have the other judges either concur or otherwise? Just my thoughts on it. Thank you.
And the next questioner is the DPP of Uganda, I believe.
Much. My question kind of comes from the presentation by DPP Rwanda, and since Mr. Adan is here, I was talking about the archives, and I was talking about the 4 kilometers. I wondered, I don't have a background to this, but just from what I've heard this morning, is it possible for Mr. Adani to give copies of the archives to Rwanda, maybe at Rwanda's expense? Thanks.
Thank you. And lastly, the gentleman who's raising his finger, if you can provide him with a microphone. Oh, you have one.
Oui, je vous remercie. Je suis Yaya Boiro, je suis de la Cour de justice de la CEDEAO. J'avoue que j'ai trouvé les témoignages qui sont succédés depuis ce matin très pathétiques. Et cela m'amène à poser 3 questions. La première question concerne les chambres d'appel. Est-ce que les décisions rendues par ces juridictions-là sont susceptibles d'autres voies de recours? Dans l'affirmative, lesquelles? Deuxième question, je veux savoir, est-ce que le TPIR prenait en compte les demandes des victimes? Si j'ai bien compris ce matin, le procureur du Rwanda nous a fait dire que le sort des victimes n'a pas été en fait pris sérieusement en compte. Je ne sais pas ce que cela veut dire. Est-ce que la juridiction ne s'est pas prononcée sur les intérêts civils ou bien c'est réservé pour une autre date? Je n'en sais rien. Enfin, je voudrais demander à la juridiction, le TPIR, est-ce qu'il lui est arrivé de faire recours à des expertises, notamment à des expertises médico-légales ou autres? Je vous remercie.
Thank you, sir. The first question was asked directly to Roman Boyd.
Right, thank you. Thank you, Charles, for the question. I mean, obviously it would probably best be answered by a judge from the appeals chamber, not by the chief of the appeals chamber support section. But in any event, I can comment on the process. First of all, it seems to me that 5 months for drafting an appeal judgment is not an exceedingly long period of time. In the abstract, I think it's hard to evaluate it, and I have not personally sat down and compared the drafting durations at the ICTY or at other courts, compare them to the ICTR. Maybe when we finish with Butara, I will have time to do that. But in the meantime, if anybody has such a comparison, I would really like to actually see it. It might save me some time. Now, the input of judges into the process. Frankly, I find this even hard to sort of begin to address. The process is the judges. The support section and the legal officers are there to support them in their work. So it's not that the judges have input into the process, it's that the legal officers help them complete their work. So I mentioned during my presentation the compendium of issues, or the preparatory document. And indeed, the legal team does prepare such a document, which is based on the submissions of the parties. The legal team preparing the document is working under the direction of the presiding judge. So there is a judge in the process who is responsible for managing the direction of this preparatory work. Once the oral hearing takes place, there is a period, depending on the size of the case, of 2 to 4 weeks for the judges to meet to deliberate. And after that is when the formal judgment drafting process actually takes place. So, well, if we look at it like that, then the judgment drafting isn't even 5 months, it's 4 months, you know. Not that it would make very much difference in that comparison. But the process then is driven by the judges who give the legal team the direction. Then it's not only the presiding judge anymore. In fact, it's all 5 judges who give the direction, sometimes very, very specific direction, and sometimes the exact text that starts to form the basis of the appeal judgment. And then in a judgment, we'll have about 4 rounds of written deliberations where the presiding judge distributes the draft appeal judgment to his colleagues, who then comment in writing on that draft. So every judge on the bench, not just the presiding judge, but every judge on the bench has very direct input into the drafting of the judgment. And in the end, because the process involves these sort of multiple rounds, the judgment reflects every judge's view completely, and where there isn't a majority, the judges write separately or dissent. So I hope that sheds a little bit of light on that.
Thank you, Roman. Any more comments to that specific problem? I might add that in most trial chambers, normally a managing judge is assigned to liaise with the legal team and prepare the draft for the deliberation of the full team. And also in jurisdictions where the judgment is written by one judge and the other judges can either agree or file dissenting opinions or decisions, the drafting judge has a team. So I don't see this a big difference between how it goes on there and how we have practiced it. Then there was a question from the Ugandan DTPP on archives. Tom, will you deal with that?
Thank you for that question. Let me try and answer that by speaking above my pay grade, as it were. If Registrar Hocking is still in the audience, feel free to intervene or cut me off at any point. As you can imagine, it's a very sensitive issue. On a recent mission to Kigali with the Registrar, the same comments were raised. It was a decision of the Security Council to keep the archives as a whole within Arusha, and that the mechanism would be responsible for the management thereof, here in Arusha of the ICTR archives and in The Hague of the ICTY archives. That being the case, the records then need to be managed and preserved and made accessible through the application of general UN principles when it comes to providing access and management of archives. You mentioned that we should perhaps give a copy, at least to Rwanda. We have, as I mentioned in my talk previously, that we do have an online access system where all public judicial records are made available. The issue there is that, having said that, all of the public judicial records are available. Therefore, it also follows that the confidential and strictly confidential material is not available. Thereby, that's basically the problem. You know, we have strictly confidential material that is not publicly accessible, can only be made accessible through a judicial decision. Yeah, it's not as easy as just giving a copy. There are also other categories of records which are confidential and relate to other functions apart from the judicial records, and they cover functions such as enforcement of sentence, witness protection, which are very sensitive records, correspondence from third parties or external parties that were provided to us on the basis of not making those accessible to anybody else, assistance to national jurisdictions, detention management. There's a whole raft of other functions apart from the judicial records which we cannot make publicly available, unless it's a decision of either the registrar or a judicial decision to make those records publicly accessible. There's another category of records that we manage, and they fall under the administrative functions, finance, procurement, human resources. They also are managed within the context of general UN policies on records and archives. They generally are made accessible after 20 years. They're automatically declassified, but that whole declassification issue is a complex one that I probably don't have time to go into right now. But as far as the public judicial records, making them available to Rwanda, they are already accessible via our webpage. If it was seen as beneficial to the Rwandan authorities, we could probably give them a copy of all of the public judicial records, but that's not a decision that I could make in this forum or in my position as an archivist. Yeah.
Thank you, Tom. And then the intervention by Mr. Boireau. I think Erik Moser can respond to that.
Well, at least I'm happy to talk about the legal expertise issue, the last element. And let me say that my experience is that the trial chambers had an open mind to expertise, be it historical, linguistic, or any other sort, depending on the trial. But when it comes to legal expertise, I think it's a bit unusual that a legal court need legal expertise in order to dispose of its mandates. So I think we followed, in a way, normal court practices, the way we processed the expertise issue.
Thank you, Erik Moser. Any other takers on the panel? Susan Lam?
One feature I'd like to highlight in relation to the discussion on archives, one issue that's emerging before the ECCC is the extreme difficulty to deal with the evidence management and legacy dimensions of all of the information collected by tribunals when the seat of that tribunal is in country and where the level of international ownership or influence over those records are not clear-cut. This is particularly acute in Cambodia, where domestic political support for the tribunal is weak at best. I think there are a few people in the ECCC at the moment that are at all optimistic about the fate of the archives of the ECCC once that institution closes down. I think this is a little bit of a gap in our discussions to date about how to manage justice scenarios that are not fully UN endorsed, particularly where the management of records are concerned. Thank you.
Thank you, Susan. We are almost 15 minutes over time, so I'll just take one more question from the gentleman who was already marked. Yes, you are in the back.
Thank you, Chair. Name is Elijah Marong, former legal officer in Chambers. I had the privilege of attending this meeting from Tuesday, and one of the issues that came through over the past 2 days has been the shift in the practice of the Office of the Prosecutor from what were multi-accused trials, joinders, to single accused trials, given the completion strategy that was adopted in 2003-2004. So that is kind of best practice lessons learned for the prosecutor. Hopefully that would be taken up and be of benefit to both national jurisdictions when the tribunals close down and also the ICC. I wonder from the point of view of the judges at the ICTR, if you are going to identify one lesson or best practice over the past 20 years that could, in your view, be adopted in the management and disposal of cases from a chamber's point of view, what would that be for the benefit of national courts and the ICC? Thank you.
Thank you, Eladio. I think Eric Mercer is the right person again to.
You are asking me to choose one particular issue as the highlight of the improvement. It's an impossible task. But having said that, I think it's true that multi-accused trials were a burden. I think that is true. So the simplicity is of the essence. Having said that, and coming back to Mr. Robinson's questions about the length of judgments, when it came to the length of the judgment, of course, the multi-accused were long, but if you divide them with the accused, they are not necessarily longer than the single-accused judgments. It's a complicated picture. Everything is linked, as I said previously. I think 2 accused is a good combination. Takeru Timana was handable. Thank you.
It is my pleasure to introduce the second panel of the day. This panel will deal with the theme of sexual violence crimes and assessment of evidence in international tribunals. We are very honored to have this panel moderated by the Honorable Hassan Boubacar Diallo, Prosecutor of ICTR and the MICT. Mr. Diallo, you have the floor.
Thank you very much, Madam Bangura. Good afternoon and welcome back to all of you. I hope you've had just enough lunch to be able to stay awake. This panel is dealing with a very important topic of assessment of evidence, international tribunals, and the management of sexual violence crimes. Very, very important subjects. Courts of law are obliged to give decisions. They're set up to give decisions, to make decisions, and their decisions are based on evidence. They have to make findings of facts. The facts are not always very neat or clear or even welcoming. Sometimes they're a bit messy, but all the same, every court has to decide on the facts and apply the law to them. Probably deciding the facts is the most difficult part of the court's work, probably. The law can be looked up, but deciding on the facts requires various processes by the judges themselves, admissibility of evidence, assessment of the evidence, decisions on issues of credibility, the factors which they need to take into account in order to decide which facts to accept. They have to make inferences from facts, etc. And some of the panelists will look at those issues from various approaches, including the investigation and prosecution of sexual violence. We know, of course, the ICTR has made jurisprudentially some major innovations in that particular area, from the Akayesu case up to the latest decision in Karamera, recent decision of the Court of Appeal relating to the conviction of the senior leaders of the then ruling party for crimes of sexual violence committed by subordinates. But we have a very distinguished panel here to guide us through those issues. You already have their CVs, so I do not need to introduce them. I presume you've read those CVs and you know them, all of them. Our first presenter would be James Agwin, who is the Chief of Appeals in the OTP, and he's going to speak on ICTR prosecution of sexual violence. 10 minutes. I implore every panelist to stick to the time. Each of you has 10 minutes to do your presentation, after which we will pass the floor to the discussants. James.
Thank you, Mr. Prosecutor, and good afternoon, everyone. Earlier this year in January, the ICTR prosecutor released a best practices manual on the investigation and prosecution of sexual violence cases in post-conflict regions. That manual is available on our website, so if you're interested in it, you can consult that. Today, what I'd like to share with you is some of the practical recommendations contained in the manual for reducing the risk of re-traumatization for survivors and other witnesses of sexual violence. And I say reducing because, as our experience has shown in prosecuting these cases, eliminating that risk altogether is difficult in most criminal justice systems. Whether you practice in a civil or common law or hybrid legal system, survivors and witnesses will be required to relive these often painful events by providing statements to criminal investigators and others seeking to document human rights violations. And once those investigations are completed, which sometimes results in multiple statements being taken from the same witness, survivors and witnesses will be required to, or may be required to, present their testimony in court in often unfamiliar and sometimes distant courtrooms, and sometimes in the presence of the person who is accused of the crimes, and usually subject to probing examination by judges and lawyers. And what is more is, during their deliberations, judges must scrutinize their testimony to ensure that it's credible and reliable. And now, while testimony from survivors of sexual violence is not subject to any more rigorous assessment than any other witness to any other crime, the circumstances surrounding the crimes usually result in judges approaching some of the testimony with caution. Trauma and stress, for instance, are circumstances that may undermine the reliability and credibility of any witness's testimony, including sexual violence witnesses. Similarly, identifications made under difficult circumstances, including at night or for only a short duration, or from an obstructed vantage point, require particular caution in any case, not just sexual violence cases. The passage of time between the commission of a crime and a witness's report of the crime or their testimony in court likewise may raise doubts about the witness's ability to accurately recall details of the event, particularly when their recollection of events is not consistent with other evidence presented in the course of trial. Judges have to examine any significant variances among a witness's in-court testimony, the prior statements from the witness, and testimony from other witnesses to see what, if any, portion of that evidence can be credited. And additionally, judges must carefully assess every witness's demeanor while they're testifying in the courtroom, looking at such things as did the witness hesitate or attempt to evade answering a question, or provide an exaggerated or otherwise improbable response. Now, on occasion in our cases, these general rules that guide judges in the assessment of evidence presented at trial have resulted in the testimony of some or all portions of the testimony of survivors being rejected and being found not credible. And this result has been very difficult for survivors to accept because it implies that the judges either did not believe that a crime occurred or that their testimony made no meaningful difference. Our manual that was released earlier this year provides several practical recommendations on how to reduce these risks of re-traumatization and encourage a more hospitable environment for survivors to present their testimony. And a few of the key recommendations are what I'd like to focus on today. There are 4 practice tips that I would highlight in the time I have, and those are first, that prosecutors and investigators should avoid taking multiple statements from the same witness. Recounting the circumstances surrounding sexual violence can be an extremely painful and humiliating experience for most survivors and witnesses. Not all, but most, because each survivor and witness is their own person. Before proceeding to interview a survivor or witness, investigators and prosecutors should carefully analyze the strength of their case and review all the evidence that's been collected to date to ensure that the interview is necessary. Survivors and witnesses should not be asked to recount painful experiences when there's no real prospect of a conviction or a substantial prosecution. To make this decision, investigators and prosecutors must have a thorough understanding of the elements of the crime and the modes of liability that will be proved at trial. And before interviewing a survivor of sexual violence, investigators and prosecutors also should liaise with any NGOs or other organizations that may already have interviewed the same witness to establish whether it's even necessary to take another statement. Investigators and prosecutors should confirm the content of any earlier statement and determine whether any follow-up is required. In making this assessment, it's also important for investigators and prosecutors to take into account the procedural requirements imposed by the jurisdiction's rules and practices relating to the admission of prior statements. The second practice tip is that prosecutors should consider alternative ways of proving their case. Evidence of sexual violence may be presented in the courtroom through a variety of sources, not just survivor testimony. After all, not all eyewitnesses to sexual violence crimes are themselves victims. These other witnesses provide a readily available alternative source of evidence in the event a survivor is unable or unwilling to testify. Depending on the circumstances of the case and the rules applicable in the jurisdiction, evidence in specific sexual violence cases also might be established through judicial notice. In the Gakumbitsi case, for instance, the tribunal recognized that in cases where rape and other forms of sexual violence are charged as war crimes or crimes against humanity, the circumstances will be almost universally coercive. That is to say that true consent will not be possible. This judicial finding streamlined the presentation of evidence in subsequent cases and thereby reduced the burden placed on survivors to appear in court and testify about the absence of consent. Consideration also should be given to the use of statements in lieu of live testimony. ICTR Rule 92 bis, for instance, permits the admission of a written statement in lieu of oral testimony under certain circumstances. In the Caramera trial, the prosecutor relied on this rule to admit 19 statements, including transcripts of previous testimony on sexual violence crimes, in lieu of calling those witnesses at trial. Now, not only did this approach save valuable court time, but it avoided the prospect of the risk of re-traumatizing witnesses who would otherwise have to be called to present the same evidence live in court. Stipulations or statements of agreed facts between the parties likewise may reduce the burden on survivors. In some cases, in fact in many cases, the facts relating to whether the crime occurred are not disputed. The dispute instead focuses only on whether the accused is responsible for that crime. In these circumstances, the parties may agree or stipulate to the facts relating to the criminal act itself. Now, prosecutors will have to assess the strategic value of providing a stipulation in lieu of live testimony. But in those circumstances, even if it's considered prudent to call the witness to testify in person, there's also consideration should be given to whether an agreement to allow the evidence to be led in the case in chief without cross-examination as to the underlying facts would be possible and agreeable to the defense. The presentation of evidence from expert witnesses and medical professionals can also be another source of evidence. For instance, medical experts might be presented to establish the mental harm and bodily harm aspects of the crime of rape as genocide. The third practice tip is that whenever permissible, prosecutors should proof witnesses before testifying. The judicial process is likely to be a new experience for most survivors. They will be understandably anxious, particularly about having to confront the accused and answer questions about painful events. When permissible, prosecutors should try to make the witnesses more comfortable by meeting with them shortly beforehand to review what is likely to happen in the courtroom, the anticipated areas of direct and likely areas of cross-examination, review any prior statements or documents so they're not surprised if they're confronted with those during the course of trial, and discuss with them how it's appropriate to respond to questions from the bench or counsel. And it's also a good idea for witnesses to see the actual courtroom where they're going to testify so they're familiar with their surroundings. Additionally, as part of the final preparation for trial, the parties, either alone or with the assistance of the judges in a pretrial conference, should resolve outstanding disclosure and scheduling issues and other procedural matters to preserve more time for the actual witness to testify in court. And lastly, prosecutors seek, whenever possible, to try to corroborate key aspects of a survivor's testimony. Now, corroboration is not required, but it can nevertheless be an effective way to persuading judges about the reliability and accuracy of key aspects of survivor testimony. And with all these tips and the other recommendations contained in the ICTR manual, we believe that will help reduce the risk of re-traumatization of survivors and strengthen the presentation of evidence in sexual violence cases. And I thank you for your time.
Thank you, James, for your presentation and for keeping within the time limit as well. We next have Valerie Osterveld, who will also be speaking on the use of sexual violence victims' evidence. Valerie.
Thank you very much. I'm going to focus my remarks today on the procedural steps taken to elicit evidence of sexual violence. And I'm going to speak not only about the International Criminal Tribunal for Rwanda, but also the Special Court for Sierra Leone, because since we're looking at legacy here today, I would like to show that there has been a legacy from the ICTR to the Special Court for Sierra Leone on the issue of procedural steps with respect to sexual violence. And I do this because when the Special Court for Sierra Leone was created, the statute actually said in it that it was at that point in time to use the ICTR rules of procedure and evidence. Since then, they had been amended, but for the most part, they are based on the ICTR rules. I'm going to look at this issue through two lenses: protection and support provided to victims of sexual violence during trial in the courtroom, and also with respect to Rule 96 of the Rules of Procedure and Evidence in both the ICTR and the Special Court for Sierra Leone. During the ICTR trial processes, victims of and witnesses to sexual violence were protected and supported within the courtroom in a number of specific ways, which were also taken up and applied by the Special Court for Sierra Leone. And these were, broadly speaking, two types of protection and support put into place for those testifying about sexual violence. Protection from reprisals and stigmatization, firstly, and secondly, support to limit secondary victimization. given that the ICTR and the International Criminal Tribunal for the former Yugoslavia were the first international criminal tribunals that needed to put in place procedural efforts to address sexual violence victims, they undoubtedly broke new ground in doing this. And therefore, it's not surprising that the Special Court for Sierra Leone took on many of the new ways of doing things that the ICTR adopted. We also know that in many countries around the world, sexual violence is underreported and silenced. Rape is a violation related more to power and violence than to sex, and yet cultural practices often unfairly place the shame and the blame on the victims and not on the perpetrators. And this creates significant consequences for a victim's psychological and economic well-being. Victims of sexual violence, therefore, usually did not wish to testify openly in public before the Special Court for Sierra Leone and the ICTR. They did wish to testify, but not openly and in public for the most part, although some did. And therefore, these protective measures were absolutely necessary. And one of the most common protective measures was to protect the identity of the victim, for example, through the use of a pseudonym. Additionally, trial chambers also regularly permitted identifying information to be presented in closed sessions or in mixed sessions where some of the sessions were closed and some parts were open. For example, in one case at the Special Court for Sierra Leone, a protected witness had accidentally mentioned the name of the school that she had gone to. And this was in open session, and so the judges expunged from the record the name of her school because it was a small school and she could be identified potentially by the public. And the judges also requested the media not to use the name, even though it had been said name of the school, even though it had been said in open session. So while the general rule, of course, is for open sessions, for public sessions, an examination of the decisions of the ICTR and the Special Court for Sierra Leone shows that in this regard, judges, prosecutors, and defense counsel tended to accept the need for closed sessions with respect to the protection of the identity of victims of sexual violence due to the heightened consequences that they potentially faced if this identity information was made public. Another method that was used by both tribunals was face or voice distortion of the victim when so that their face or their voice was distorted when broadcast outside of the courtroom, for example, in the public gallery or in online feeds. And a less technical tool was also quite effective, and that was the use of a screen or a curtain, and that could screen the witness either from the public or be put in between the witness and the accused. On the support side, judges in both tribunals have adopted certain courtroom-friendly procedures, such as giving breaks to victims or witnesses testifying to sexual violence. And sometimes these breaks needed to occur quite often. For example, in the Special Court for Sierra Leone, there was one particular trial in which a victim had moved from testifying about witnessing sexual violence to talking about her own sexual violence, and she needed a break almost every 5 minutes or so in order to keep her composure. And this was granted by the judges. And one can see similar approaches in the ICTR, for example, in the Gakumbitsi trial. Other modes of accommodation were given. For example, in the Special Court for Sierra Leone, there was one witness who had a 4-month-old baby, and so she was given breaks in order to nurse her baby. Another method used by both tribunals was to permit victims who felt unable to say what had happened to them or who had done these things to them to write down what had happened to them or who had done these things to them. And then this was either read into the record or not read into the record, was given to the judges, depending on whether it happened in open session or closed session. And in the Gakumbitsi trial, I think this was captured very well when the victim said the reason why she could not say what had happened to her, but she could write it. She said, "Things of this nature are not spoken of. Our parents never taught us to speak like this. It was taboo." And that was respected by the judges, and the prosecutor, and defense counsel. Another way in which prosecutors in both tribunals attempted to limit secondary victimization of victims was already mentioned by James, and that is through the use of written statements through Article 92 bis in both tribunals, and also through the admission of formally adjudicated facts in both tribunals. So, for example, this happened in the Caramera trial, as James explained in the ICTR. In the Taylor case at the Special Court for Sierra Leone, several sexual violence victims and witnesses had transcripts of their testimonies from the Armed Forces Revolutionary Council or the Revolutionary United Front cases admitted under Article 92 bis. Finally, I should mention the use of support persons in the courtroom. For example, in the Special Court for Sierra Leone, it was standard practice to have a witness support person sitting near the victim of sexual violence or elsewhere in the courtroom, and this was also used in the ICTR. Turning to Rule 96. Rule 96, at the time that it was adopted into the ICTR's Rules of Procedure, it was groundbreaking. The rule says that prior sexual conduct of the victim shall not be admitted into evidence or as a defense. It also says that consent shall not be allowed as a defense if the victim was subjected to particular forms of fear or coercion, and also indicates that no corroboration is required for the testimonies of victims of sexual assault. And the Akayesu and Rudaganda trial judgments remind us why this rule was adopted, that this rule simply accords this type of testimony the same presumption of reliability as the testimony of victims of other crimes. Now, this rule has been challenged in the ICTR. For example, defense counsel in Musema argued that corroboration is required when a victim is testifying to the occurrence of sexual assault, but the court rejected this. Now, the Special Court for Sierra Leone has a different Rule 96. Originally, it was the same as the ICTR, but in 2003, it was changed. Rather than stating that consent shall not be permitted as a defense in certain circumstances, the rule indicates when consent cannot be inferred. For example, consent cannot be inferred by reason of any words or conduct of a victim where force, threat of force, coercion, or taking advantage of a coercive environment undermined the victim's ability to give voluntary or genuine consent. Also, rather than prohibiting questions about prior sexual conduct, the rule states credibility, character, or predisposition to sexual availability of the victim or witness cannot be inferred by reasons of the sexual nature of the prior or subsequent conduct of the victim or witness. And this is positive in one respect, in that it gets at subsequent sexual conduct, which was very important in the Special Court for Sierra Leone for bushwives, those bushwives who had stayed with their captors and continued to have sexual relations with their captors. It meant that that fact was not then inferred as creating consent to what happened prior. But at the same time, the Special Court for Sierra Leone's rule did not adopt the second part, which is the rejection of the prior or subsequent, the rejection of evidence about prior or subsequent sexual conduct, even if it doesn't affect credibility. So this is not necessarily the best way to go, and I would posit that the ICTR's approach is in fact the clearer approach. To sum up, the courtroom procedures in the ICTR were adopted, many of them, in the Special Court for Sierra Leone in order to create a court-friendly environment or a gender-sensitive friendly environment for victims of sexual violence. It's not to say that these always worked. In fact, there were cases where victims felt harassed by unnecessarily repetitive or aggressive cross-examination about the details of their sexual violence. But it did go quite some way to ensuring that the many victims and witnesses felt comfortable enough, safe enough, and secure enough to present evidence in both tribunals. And I think this shows that the legacy of the ICTR on sexual violence has continued through at least one other tribunal. We know, of course, it's gone further than that, but it's important to recognize this legacy.
Thank you, Valerie. We'll now move on to Gabrielle McIntyre, who will speak to us about reception of evidence assessments and the roles of the trial chamber and the appeals chamber in this respect. Thank you.
Thank you. To begin with, I would like to thank the organisers of this conference for inviting me, and also to thank our moderator, Prosecutor Jallow, and my fellow panellists and discussants. Before I offer my remarks, I would underscore that the points I will make today reflect my own personal views. My remarks will focus on the assessment of evidence by the ICTR. This assessment is, of course, very much at the heart of any court's work, and the ICTR is no exception. However, the ICTR's approach to the assessment of evidence was and is unique in many ways. The ICTR, as a pioneering international court, has needed to devise a coherent, consistent and fair approach to its assessment of evidence, drawing on a wide array of global legal traditions. The evidence that has been put before the ICTR over the past 2 decades has not only been at the heart of some of the most complex cases the world has ever seen, this evidence has also presented a variety of extraordinary challenges not typically found in national courts. And the ICTR has had to address these challenges and assess the evidence presented before it with care and close attention, and without regard to the myriad of passionately held and often conflicting outside expectations about what the ICTR can and should achieve. In this context, the ICTR developed a hybrid approach to the assessment of evidence, drawing on both civil and common law traditions and adapted to the circumstances of the evidence before it. In my comments, I will first touch on the legal framework governing the ICTR's assessment of evidence. I will then identify some of the special challenges the ICTR has faced, discuss responses to these challenges, and end by noting particular issues relevant to the assessment of evidence and criticism that has been made of the ICTR approach. As many of you know, the presentation of evidence at the ICTR follows an adversarial model, whereby it is the parties who typically present the evidence to be weighed by the trial chamber, as is true in common law traditions. The rules governing admission and evaluation of evidence, however, are more akin to those employed in the inquisitorial model, which gives wide discretion to judges in keeping with civil law norms. Accordingly, the guiding principle at the ICTR has been freedom of assessment. Thus, Rule 89, the primary evidentiary rule, provides that national rules of evidence are not binding, Rule 89A. The trial chamber shall apply rules of evidence which will best favour a fair determination of the matter before it, Rule 89B, and the chamber may admit any relevant evidence which it deems to have probative value, Rule 89C. At the same time, the freedom of trial chambers in their assessment of evidence has been restrained in a number of ways by Rule 89 and by judicial precedents. Thus, for evidence to be admissible under Rule 89C, it must have some modicum of reliability. Moreover, a number of tests or approaches have developed in the jurisprudence of the ICTR for the evaluation of evidence as a means of ensuring a fair determination of the matter. Many of these tests and approaches have developed in response to special evidentiary challenges that the ICTR has faced over the years in dealing with witness testimony, which has been the primary evidentiary source for the ICTR. These challenges have included the impact of trauma on witnesses, the passage of time between events and testimony, or between statements given to investigators and testimony given in court, the difficulties faced as a result of language problems, such as the use of translation and the illiteracy of many of the witnesses, the particular social and cultural traditions of many witnesses, and the reliance on accomplice witnesses. The trial chambers of the ICTR have adopted a variety of approaches to address these challenges. Thus, for instance, to ensure a fair assessment of evidence when time and trauma have eroded the ability of witnesses to precisely recall the details of events, the trial chambers in practice have applied a test developed by the ICTY, in which they distinguish between details that were peripheral to the events as opposed to the facts and details that make up the essence of the event. If the facts and details that make up the essence of the event are consistent and coherent, then the inability of the witness to recall precise details, such as the day or the time of the event, would not be a basis for disregarding the evidence. Where the discrepancies are material discrepancies, on the other hand, the trial chambers will consider the explanation given for the discrepancies. To offer another example, often the trial chambers have been confronted by discrepancies between statements given by witnesses to investigators and their in-court testimony. In assessing these discrepancies, the trial chambers have taken into account the inherent difficulties of translation, compounded in many instances by the inability of illiterate witnesses to review the statements in issue. ICTR trial chambers have also had to grapple with how particular social and cultural traditions have impacted witness testimony. In addressing this issue, the trial chamber in the Akiesu case received expert evidence on Rwanda's oral traditions and gave special attention to eliciting key information, such as whether a witness directly witnessed an event or was told of it by another party. Other trial chambers have taken different approaches, such as explicitly taking into account the social and cultural backgrounds of witnesses in evaluating their evidence. Additionally, in the absence of documentary and other evidence to identify perpetrators and command structures, ICTR chambers have relied heavily on accomplice testimony. To minimize the inherent dangers of doing so, the trial chambers have adopted a detailed approach to testing the reliability of accomplice evidence that includes assessing whether the witness concerned might have motive or incentive to implicate the accused, whether he or she has already been tried and convicted, and whether he or she has made a plea agreement with the prosecutor, in addition to other factors applicable to the assessment of all witness testimony, such as the extent to which discrepancies in testimony are explained. As these examples suggest, ICTR trial chambers have enjoyed wide latitude in their development and use of different approaches to address specific evidentiary challenges. At the same time, the requirement that trial chambers provide written explanations of their assessments and the right of appellate review have served as a powerful check on any less than reasonable approach to the assessment of evidence. This does not mean that the appeals chamber may substitute its own assessment of the evidence for that of the trial chamber, except for in a few very limited circumstances. In other words, the question on appeal is not whether the appeals chamber agrees with the evidentiary findings of the trial chamber, but whether it is satisfied that the findings under review could have been reached by a reasonable trial chamber. The fact-finding processes at the ICTR and other international courts, and their treatment of witness evidence in particular, have not been without criticism, of course. It has been alleged, for instance, that the evidentiary challenges faced by courts like the ICTR, including trauma, passage of time, difficulties related to language and different cultural and social traditions, are so profound that they act as impediments to any accurate fact-finding. It is also argued that the combination of these factors make it extremely difficult for international judges who often come from cultures and traditions far removed from those of the witnesses, to assess the credibility and demeanour of those witnesses. Indeed, it has been suggested that judges are too eager to explain away discrepancies as innocent mistakes and fail to find reasonable doubt in the most doubtful of instances. And it has been claimed that such a cavalier approach is taken because the costs and time taken by international courts like the ICTR, coupled with victims' expectations and the need to maintain international support for international criminal tribunals, imposes a burden of delivering results, and the results are convictions, not fair trials. Thus, it is argued, international judges are indirectly biased towards conviction. In my view, this criticism is too harsh. There is no doubt that the judges of the ICTR have faced tremendous evidentiary challenges in determining the cases before them. However, as I have attempted to illustrate, in response to those challenges, they have devised methods of approaching the fact-finding process that acknowledge those challenges, seek to understand how they impact on the particular evidence before the judges, and take that impact into account in making evidentiary findings. The ICTR trial chambers have also striven to be transparent in the fact-finding process by providing reasons for their evidentiary conclusions. The possibility of wrongful conviction resulting from evidentiary deficiencies is minimised by the obligation placed upon the chamber to give reasons for its evidentiary assessments, and by the right of appeal to the appeals chamber to challenge the reasonableness of a trial chamber's findings. There have also been a number of full or partial acquittals at the ICTR on trial and on appeal that run counter to the criticism that judges prioritise convictions over fair trials. Whatever one's view on the matter, there is unquestionably room for fruitful debate on the wisdom of the ICTR's approach, the ICTR's legacy for other international criminal courts in this regard, and how best to balance the different imperatives and unique challenges I've briefly sketched out today. That concludes my remarks, and I thank you for your attention.
Thank you very much, Gabrielle. Now we have Greg Townsend, who will look at it from a different angle, speaking to us about the use of domestic, mainly Rwandan court records within the ICTR. Greg?
Thank you, Mr. Jallow. Thank you, everyone. Thank you, the organizers. Having checked into this hotel 16 years ago, it's nice to be what feels like a family reunion here. With that said, my paper falls into the assessment of evidence part of this panel 2, as opposed to the sexual violence part. And perhaps I'll be talking about witness TA in the question and answer period. And I address specifically the case law about obtaining, disclosing, and using Rwandan domestic judicial records before the ICTR. I'll focus on ICTR decisions that dealt primarily with witness statements before gacaca courts in Rwanda, as well as the prosecution's disclosure practices for these particularly important pieces of evidence. I conclude that the ICTR case law and prosecution practice have helped advance international criminal law, and the latter has become to what's popularly referred to as a best practice. Early ICTR case law focused on case law on Rwandan judicial records often focused on the lack of an obligation on the ICTR OTP to make any affirmative efforts to obtain and disclose such records, including gacaca records, when they came into existence between 2001 and 2012. It was said one cannot disclose what one does not possess. In short, the prosecution submitting "we ain't got it" amounted to the end of the legal analysis. But the jurisprudence advanced to the point where "we ain't got it" wasn't good enough. And the first decision on point was that of 8 June 2000 in Bagalashima, and set a precedent. Trial
Trial Chamber 1, Judge Moza presiding, denied Maître Roux's motion. Francois, I'm not sure you're here. Je suis désolé. A Rule 68 motion, now seeking purportedly exculpatory written confessions made in Rwanda by 3 prosecution witnesses that had previously testified. The Bagalishima trial chamber held the prosecutor cannot disclose what she does not have. The trial chamber, however, on its own initiative, and here's the innovation, ordered under Rule 98 the prosecutor to produce these confessions. And Rule 98 allows for a trial chamber proprio motu to order a party to produce evidence. This decision gave as a rationale that these confessions, quote, could be material in evaluating the credibility of the prosecution witnesses. In effect, the prosecution was then obliged to request these confessions from the Rwandan authorities for its own witnesses and then file them, as opposed to disclose them with the trial chamber. 5 months later, however, a split arose between the trial chambers. In December 2000, Trial Chamber 3, Judge Williams presiding, with, I digress, a common law background, he rendered a decision in Chiangugu on a defense Rule 73 motion seeking an order to again compel the prosecution to disclose its prospective Rwandan detainee witnesses' written admissions of guilt. The defense relied on one authority, Bagalishima. Trial Chamber 3 in Chiangugu, however, denied the motion based solely on the lack of the prosecutor's possession. And it did not make a Rule 98 order. It held that Rule 98 didn't apply. It held, quote, it would be very strange indeed, if not incompatible, to order a party to obtain evidence for the opposing party beyond the requirements of Rule 68, end quote. So perhaps significantly, in Chiangugu, the Rwandan records sought were before trial, before the trial chamber was at the stage where it was assessing witnesses live in front of them. So this split arose. One trial chamber finding that Rule 98 allows it to order prosecution to go produce and get Rwandan records because they go to credibility, and another trial chamber disagreeing. After the decision in Chiangugu, other decisions on that line followed in Butare, in Zirorera, in Kajeli-Jeli, and Rudiganda, the latter two before the appeals chamber. Now, in contrast to that line, the decisions following the Bagalishima line followed in issuing Rule 98 orders in Media, Kajeli-Jeli, in Dayimbaji, Bagasora, Casimir Bizimungu, twice in Simba, Karamera in Chimahigo, in Nzabimana. Judge Byron in Chimahigo added that the prosecution is best placed to know what domestic judicial records exist for its witnesses, and such an order could be issued not just under Rule 98, but under 54, the general rule for trial orders. Gatete's trial chamber described this growing body as, quote, a practice that has developed at the tribunal of ordering the prosecution to obtain Rwandan judicial records pursuant to a trial chamber's discretion under Rule 98. Now, in Casimir Bizimungu et al., Judge Khan, as a single judge, uniquely ruled on the same issue, but did it within the framework of Rule 68 on exculpatory evidence, and said that Rule 68 created an inherent obligation on the prosecution. So another legal basis to do this. So if one were to cobble together all the decisive factors from the case law at the time, it appears that a 98 order, or a Rule 54, or a Rule 68, if you will, order to compel the prosecution to affirmatively seek out domestic judicial records was appropriate if such records go to the credibility of relevant witnesses and if it would expedite the proceedings and preparations. Secondly, if the witnesses were detainees or accomplices. Third, if the defense in some situations had made due diligent efforts, and if the identified records were so identified with specificity. Now, following this long line of Bagalishima-related decisions, the prosecutor saw the writing on the wall. And as part of pretrial preparations, trial teams affirmatively began to seek out from Rwandan authorities the judicial Gacaca records for its listed Rwandan witnesses. This was the case in Soromba, in which I helped prepare and try. Now, this practice of getting those records paid big dividends. For example, in Soromba, we received 11 prior witness statements from what was our presumed star prosecution witness, the bulldozer driver, who had knocked down the church in an attack killing 2,000 parishioners. We were expecting these 11 witness statements to amount to prior consistent statements if we needed to rehabilitate him at trial. As it turned out, the star witness flipped, the prosecution dropped him, and the defense called him. Okay? He testified in contradiction to his statements, and the 11 statements proved to be prior inconsistent statements that the trial chamber admitted into evidence to corroborate the other eyewitnesses. Other examples of this affirmative trend based on my review of case law appear in Gatete in 2009, in Batwari 2010, and Nzeyimana in 2010. Now, admittedly, even the best practices and best intentions can be confronted by investigative challenges on the ground. In Nzeyimana, the prosecution undertook at pretrial to request from the Rwandan authorities all records in Rwanda for its Rwandan witnesses, but the prosecution acknowledged that acquiring such records would be difficult. This was due to the fact that the Rwandan records at that time were being centralized, as in moving from each sector all over Rwanda to Kigali. I have a slide here, if someone could advance it, or at least push the keyboard. Understood. This picture will say 1,000 words. Essentially, at this particular time, the Gacaca records, once in Kigali, were unindexed and a bit of a mess. So the prosecution sent these photographs to the Nzeyimana defense, and in time, I'm happy to say, the Rwandans organized and indexed these centralized Gacaca records. But at the time we're trying to do disclosure, this is what the confrontation was, even with the best intentions. So I'm concluding here. ICTR case law has developed positively after the Bagalashima decision of 2000 and moved away from a solely possession-focused legal analysis for deciding requests for domestic records. Prosecution practice in recent years of seeking out such records on its own initiative represents a best practice. Seeking out such records is best done at the earliest stages of pretrial because they actually take time to get, as you can see from the picture, and to translate them. Okay. So the result of this case law and the prosecution's practice is the admission of more relevant evidence, including prior, consistent, and inconsistent statements. The availability of such evidence improved the ICTR's ability to better assess the credibility of many witnesses when trials are years, where trials are years after the events, with some prosecution-collected witness statements being, shall I say, less than complete, and with the many cross-cultural challenges for trial chambers to assess the credibility of Rwandan witnesses speaking through interpreters. These Rwandan records, often created closer in time to the events, are indeed valuable pieces of evidence. Though beyond the scope of this paper, one must consider also that the accuracy and reliability of Gacaca collected evidence is also linked to the challenges within the Gacaca process as a whole and dealing with crimes of such a massive scale, essentially without any lawyers. In sum, with domestic court records disclosed and admitted into evidence, the parties in the chamber were better able to test the witnesses and render justice. Thank you.
Thank you, Greg. Our final presenter is Caroline Bushman, Defense Counsel, ICTR, formerly, now with the ICC. Caroline, you're welcome.
Thank you. Good afternoon. I'll be speaking to you about collusion of evidence. And when I say collusion of evidence, I mean corruption of, in particular, witness testimony in a concerted manner. This is a problem for any court worldwide, whether domestically or internationally. It can lead to miscarriages of justice, and it clearly has an impact, an adverse impact, on the tribunal or court's mandate to ascertain the truth. In international conflicts, in international tribunals, when we're dealing with conflicts of such nature, the risk of this happening, of corruption, of evidence on one side or the other, are greater. In such situations, there's often a politicized environment where lots of individuals or groups might have an interest in procuring evidence that is false in favor or in disfavor of a defendant, or to dissuade witnesses from testifying. In addition, in international conflicts or international tribunals dealing with these sort of serious conflicts, there is a great gap geographically, culturally, and linguistically, as we have already discussed. And so it might be harder to assess these sort of allegations, whether they're true or false. But in many, many trials, in particular in the Rwanda Tribunal, these sort of allegations were made. And of course, especially when a country is left in the aftermath of a conflict, it wouldn't be too hard to find witnesses who, in exchange for some interest, some financial benefit, or other promises, might well want to come forward and produce false evidence if necessary. I'm thinking in particularly a vulnerable group are prisoners. Prisoners who have no perspective of coming out soon might well, in exchange for an earlier release, be ready to come and testify falsely. So this is a serious issue, and to talk more directly about the Rwanda Tribunal, in nearly all trials, witnesses have come forward to have recounted, and they have said that not only their evidence was false, but also the evidence of many others. They often have alleged that they have given false evidence either at the instigation of authorities or of civil society groups. I'm not here dealing with the accuracy of these allegations, but given the amount of them, it is something that should be treated seriously, especially because, if true, the consequences are significant, because a lot of the evidence cannot be relied upon. To give in the tribunals, especially in the beginning, there was perhaps not such an interest in prosecuting or investigating these kind of claims. Perhaps they were not taken too seriously. If I can give you a few examples of earlier cases, for instance, in Akayasu, on appeal, there was a witness of Tutsi origin who came forward, and she had a statement which was also notarized. She said that many people who came to testify against Akayasu had systematically manufactured their evidence. Unfortunately, the appeals chamber was not interested in hearing her evidence. In Kajeli, there's been a death row inmate who testified, and he said that his family and himself, they were threatened by a prosecutor, and basically he was promised, so he claims, that his death sentence would be commuted if he did not testify against a particular major. And these are just a few examples, because I only have 10 minutes. I can only state that these sort of allegations have not been made only by witnesses, but also by expert witnesses and researchers. For instance, there's been a woman, Human Rights Watch, her name is Tertsakian. She has spent a good time of her life researching Rwandan prisons. And she drew the conclusion that people were in very vulnerable positions where, because they were not seeing their families a lot, they were strongly encouraged at the same time by authorities to confess and incriminate others. We have Professor Reintjens. He testified about the involvement of civil society groups in collecting false evidence against Kanyabashi in the Butare case. Also, Kachawa has written an article called The Tribunal for Rwanda, From Crisis to Failure, in which he indicates that on both sides in Rwanda, there have been subcontracting networks for the preparation of witnesses to come forward with false evidence. And he says that these networks were directly or indirectly run by either units or individuals who were linked or allies to either the former regime or the current regime. So there's a potential basis to prosecute these sort of claims, and that's Rule 91 for false testimony, and there is Rule 77 for undue interference. There have been, over the years, there have been an increasing number of investigations that have been ordered by chambers. Sometimes amicus curiae have been appointed. It's obviously a high standard because you have to show that someone was willfully and knowingly providing false testimony. But such an inquiry can also include any other persons who have allegedly instigated people to give false testimony. It is throughout these investigations, very few of them have actually led to prosecutions, let alone convictions. And just to mention one example where the chamber at the end did order the prosecution because a amicus curiae came to the conclusion that there was a prima facie case under Rule 91. And this was someone, a witness who had testified in multiple trials, and he then recanted. He first recanted to a defense team in the presence of a prosecution team, saying that he gave false evidence, and then in the same week he testified under oath in another case, saying the same thing. So both these trial chambers ordered an inquiry, which led eventually to one of the chambers ordering the prosecution, but unfortunately this was overturned by the appeals chamber. Which leaves us with the case, there's one recanting witness who recanted in favor of the defense, and then later on he recanted again when an investigation was conducted. He recanted again, and he said he recanted in favor of the defense because of a defense investigator who instigated him to do so. So that led to the also to the prosecution and conviction of a defense investigator. So that's all that has happened in the Rwanda tribunal, which leaves the defense a bit with a feeling that perhaps these allegations are taken more seriously when they are used against the defense and rather than in favor, and which is also the position in the criminal court, the International Criminal Court, where they're taking this quite seriously. They have investigated, and there is a whole defense team now. Well, they're not in jail anymore, but they were in jail for nearly a year, and they're awaiting their trial. And there's also one witness in the Kenya trial who's alleged to have gone around and looked for corrupted evidence in favor of the defense. But there's no such investigation, or at least there's no prosecution that I'm aware of, like no public prosecution of any of the intermediaries in the Lubanga case, who in 152 pages were significantly criticized by the chamber for going around and incite children or alleged child soldiers to give false evidence. So my 2 points, because I think I have to round up. I just want to say, I think it's very important that we are aware that this is a reality. And I'm also not I'm definitely aware that this happens at both ends of justice. So this is not just for the chamber to take this more seriously and maybe to order more investigations and if at all the evidence is there, prosecutions. But also for the parties, most importantly, it is for the parties to make sure that the evidence that is produced before the tribunal or court is credible. And we shouldn't close our eyes for the reality on the ground that we are sometimes faced with. We should not close our eyes for the fact that people try to corrupt our witnesses. So with that in mind, I thank you very much.
Thank you, Caroline. That's the last presentation. We have a distinguished panel of 3 discussants, Estelle Dehon, Dov Jacobs, and Jamie Moss. Estelle, you'd like to start off? May I remind you, you discussants have only 5 minutes for their contributions.
Prosecutor, I may be much shorter than that, because I think we all are due a tea break. But I would put that forward only on the basis that we all return when we're meant to in the 15 minutes after the tea break. I think it's in the program. Yes.
And perhaps I still don't see it. Shall we continue? All right, I think fair enough. We should have our tea break then. So we come back in 15 minutes, as the program indicates. In 15 minutes, and Estelle, you will kick off. Thank you. Thank you. Hello, welcome back from the tea break. Please settle down quickly so we can proceed. We'll now move on to the second half of the program, which is to hear the discussants with Estelle Dehon, kicking off. Welcome, Estelle.
Prosecutor, thank you. It has passed into the mythos of the ICTR how evidence of sexual violence crimes emerged spontaneously before the Akayesu trial chamber, and how instead of foreclosing discussion of such evidence, because it wasn't included in the indictment, the crime of rape, instead of foreclosing the discussion of that evidence, the judges asked for more evidence, leading to the prosecution investigating and then eventually making an application, a successful application, to amend the indictment and to include 3 counts of rape in that indictment. And that amendment was allowed in June 1997, quite a way into when the trial was being heard. I interviewed Judge Pillay, who was presiding, in April 2003 about those events, and she recalled how first a male witness spoke of the sexual violence, and then a female witness, and then how the prosecutor, who was concerned to stave off criticism of these witnesses' credibility because of inconsistent prior statements, asked them, "Were you questioned about this when you were interviewed?" And both the witnesses said, "No, we were not." Well, it's part of the mythos as well that the judges weren't concerned with credibility. What they were concerned with was this compelling evidence, which was being given spontaneously by people, and they wanted to know more. But as Judge Moses said this morning, spontaneously given evidence presents a significant challenge for the trial process. And as Judge Pillay candidly confirmed to me when she was speaking to me, it was really quite outrageous that at that stage in the trial process, the indictment was amended to add wholly new charges. And the tribunal had to give the accused significant time to investigate and bring his own defense in order to mitigate what prejudice had been suffered. It seems that the ICTR's iconic response to spontaneously given evidence of sexual violence, both on the part of the judges and of the prosecution, is not going to be one of the legacies of the ICTR that persists if the Lubanga case before the ICC is anything to go by. In an eerie and frankly depressing parallel, evidence of sexual violence came out spontaneously again in testimony in that case. But rather than seek to amend the indictment, the prosecution took the position that in fact that would cause unfairness to the accused. And the majority of judges in Lubanga also refused to use Regulation 55 to recharacterize the sexual violence evidence as a means to define the elements of other crimes, although the excoriating dissent by Judge Odio Benito may yet influence in the future decisions in a different way. In light of this, it is even more important to recognize that international prosecutors must adopt a clear strategy from the outset that integrates sexual violence investigation into case conceptualization, investigation, and preparation. It is also crucial that this strategy not just focuses on sexual violence against women and girls, but also against boys and men. Both of these insights are to be found in the Prosecution of Sexual Violence Manual, produced by the ICTR and spoken of by James Arguin earlier in the session. The manual, in my view, is one of the standout legacies of the tribunal in the area of sexual violence. The pivotal insight of the manual is its second section, where it looks at the global strategy and it upfronts the need for prosecution strategy at the outset to recognize and integrate sexual violence into the way that it proceeds. It is regrettable that this strategic approach to sexual violence investigation and evidence gathering is entirely absent from the International Protocol on the Documentation and Investigation of Sexual Violence in Conflict, launched earlier this year in London at the Global Summit to End Sexual Violence in Conflict. It may be that this omission stems from the difference in foci between the manual and the protocol. The manual looks at investigation as an element of the prosecution of the offender, whereas the protocol focuses just on sexual violence, investigation and documentation alone. And in my last 30 seconds, I'm going to say that I hope, as Lubanga shows, and as Akayesu showed over a decade before, it is not sufficient for the investigation side alone to look at sexual violence. In fact, there was more than enough documented evidence in both instances of sexual violence occurring. The key element in relation to sexual violence is for there to be an integrated prosecution policy. And I hope that when the International Protocol is revised and its second edition comes out, that it will draw on the excellent and hard-won insights in the ICTR manual and will bring out the fact that sexual violence investigation has to be part of an integrated prosecution strategy, so that, in the words of the UN Secretary General for Violence in Conflict, Zeynep Hawa Bengura, cited in the protocol, there will be no hiding place, no amnesty, no safe harbor for perpetrators of sexual violence in armed conflicts. Thank you.
Thank you very much, Estelle. Can we now move on to Dov Jacobs from Leiden?
Thank you. So, as other presenters have done, I'm going to say that my views only represent my own views and not the institution I represent. Usually I don't need to say that because I'm the only person to agree with me, but just I'll put it out there. One general thought I had when coming to this conference and also hearing the talk this morning is a kind of pedantic academic reaction is, what does legacy mean? And obviously I'm not going to use up my 5 minutes doing that. But it necessarily has a normative side to it. It's not just, objectively influence, which some panelists have shown how the case law has influenced other tribunals. There's something more to the idea of legacy than just influence or borrowing. I'm wondering on different levels, legal, societal, narrative levels, expressive levels, which I think we can explore in further panels. What I'd like to do in the minutes that I have is actually look at the link between what is labeled as a procedural dimension of assessment of evidence and the actual substantive definition of crimes, because it's an arbitrary distinction. There are no neutral facts in a court of law. There are legally relevant facts. So, and I think this applies to sexual violence and rape, because to put it a bit bluntly, and hearing the other panelists, basically evidence that's difficult to obtain, you just wish away by changing the definition. You don't require the evidence anymore. So it's no longer a procedural rule, it's a substantive law issue. And we don't have time here to go in the way this has happened with a substantial definition of rape in the case laws ICTR and ICTY, but I think there's one element which comes out, and which is not very original, but that's a collective dimension of international crimes and how it relates to rape. And I think the collective dimension comes in two different levels. One is the question of contextual elements, obviously war for war crimes, widespread, systematic, etc. And the second one is modes of liability. So on the contextual elements, we've heard from other panelists that you can have circumstances where consent is not possible, that are inherently coercive. This is one way of wishing away the evidence. That the definition of rape in international law is, I know there's a debate about it and the actual ambiguity in the case law, but it's either coercion or lack of consent through coercion, etc. But you have this idea that you don't have to prove that in inherently coercive situations. The second way this comes in is through modes of liability, because again you have this collective dimension and you might establish the fact pattern of rape, but then you have to link it to the defendants. And in the recent appeals judgment in Carremera, they confirmed extended JC for sexual violence. And it's funny to see, well, funny is not the word, it's interesting to see how there are different approaches on this idea, which actually changes the legacy in terms of narrative. Because it's not the same to say that the sexual violence was part of whatever common plan under JC or the common plan at the ICC, or to say that it was a foreseeable consequence of it. And you have different shades in there. I mean, at the ICTY, you have the Krajishny judgment, which actually stayed on the normal form of JC side of things by saying that it was not foreseeable. It's a question of, it's a natural evolution. That sexual violence happening was a natural evolution of the crime pattern, so therefore it was included in JC1, whereas in Carremera it's actually moved into JC3. And I think that's really interesting, and you can contrast with Katanga, where, I mean, I'm sure you're all familiar with the judgment, but basically even though evidence of sexual violence was brought forward, Katanga was not convicted for it because the chamber considered there was no proof that this was part of the common plan, that he had knowledge of it. Again, what message is it sending in terms of narrative? Taking it from a different perspective, usually crimes of sexual violence are probably pervasive in societies where there is conflict, independently of the small period of conflict. And you can wonder what kind of effect or legacy an international tribunal can have for broader societal concerns about gendered violence, and I'm just curious about that. The final point, sorry, I'm going very fast, but the time forces me to do so, is trying to look at the ICC. Generally, what's nice about working in another tribunal is that the ICC makes you look good in past years. And it's the same about evidence and sexual violence. And I won't go into detail about evidence, but the prosecutor at the ICC has been repeatedly criticized for the use of hearsay or NGO reports, etc. And in terms of sexual violence, you gave the example of Lubanga. This is not a symposium on the ICC, so I won't explain why I disagree with you about Odio Benito, and I hope it doesn't influence future cases. But you have the case law in the Kenya situation where there's what has been criticized by many, a certain approach to what is a crime of sexual nature and forced circumcision. And it has puzzled a lot of commentators, the fact that the chamber considered that forced circumcision is not inherently sexual in nature. So on a lot of levels, whether it's evidence, sexual violence, or the relation between the two, a lot of people will consider that the ICC is actually taking a step back. And so in that respect, there might not be so much of a legacy. Thank you.
Thank you, Dov. We finally have the last discussant, Jamie Moss. Jamie, you're welcome.
So I'd like to first thank Prosecutor Jallow and the organizers of the conference for inviting me. And one thing that I would like to do in the 5 minutes that I have is to try and make a link between the prosecutor's colloquium that just ended that was focusing on this shift from international courts having primacy over international crimes to the context that we're now dealing with, which is the principle of complementarity being the guiding principle, and of course the emphasis on prosecutions of international crimes at the national level. So the focus that I'd like to take right now is sort of what, to pose the question, which rules of procedure and evidence with respect to crimes of sexual violence will be followed at the national level when these crimes are litigated as international crimes? So without repeating too much of the very thorough explanation that my colleague gave about Rule 96, this is considered one of the key reforms, one of the landmark changes to rules of procedure and evidence with respect to sexual violence cases. And just to remind you, the key elements are that corroboration of victim testimony is not required, that information about the victim's prior sexual conduct cannot be admitted as evidence, and most importantly, and many of my colleagues on the panel have already reiterated this, that lack of consent can be inferred from the environment of coercion that characterizes war, mass violence, and detention. And I think what this means is that, at least in the international courts, that victim testimony alone is sufficient to prosecute and convict. In practice, corroborating evidence strengthens cases. However, such corroboration need not be physical evidence, such as medical or forensic evidence. Rather, witness testimony and other forms of documentary evidence can serve this purpose as well. In all of the landmark rape cases, both at the ICTR and at the ICTY, the cases relied on victim and witness testimony to establish criminal responsibility for rape. And I'm sure for many of you, you can recognize that unlike the ad hoc tribunals in many national jurisdictions, corroborating evidence is often required. This may be medical or forensic evidence. It may be a formal requirement, or it could be a requirement that's more informal, that's sort of an expectation in order for a case to proceed in court. Typically, such physical evidence is used to establish the elements of the crime under domestic penal codes, and although they vary, these typically would include the following: to demonstrate recent sexual contact, to confirm the identity of the perpetrator, and to document physical injury as evidence of use of force and victim resistance, which is inferred to prove lack of consent. In many jurisdictions, a formal medical certificate completed by a physician, very often for a fee paid by the victim, is required in order for a case to proceed. And this can happen even in cases of conflict-related sexual violence. And I think, as many of you know, often such evidence is unlikely to be available. Further, in both conflict and non-conflict related sexual violence, forensic evidence and clinical findings may be undetectable, even when rape is known to have occurred. This can depend in part on the nature of the violence itself, for example, the threat of force rather than the use of force, the likely delay between the assault and the subsequent medical evaluation, and the availability of forensic evidence collection techniques, among many other factors. So one thing that I'd just like to sort of pose as a question for discussion is what exactly will what will we take from these innovative rules of procedure and evidence as we are looking at a system that's shifting to hybrid, regional, and national courts. When there is domestication of treaties and laws that incorporate crimes of genocide, crimes against humanity, war crimes, are we also going to incorporate the innovative rules of procedure and evidence that have come alongside especially for cases of sexual violence? And I just want to pose that as a question. I hope that in the conversation that those prosecutors among you or even others, advocates, NGO representatives, might weigh in on that. So thank you very much.
Thank you, Jamie, for a brief presentation, but with a very weighty, important question. How do we bridge the gap between the rules, the principles, the procedures of the international and the national systems? Have the advances we made in the prosecution of sexual violence, are they reflected in any way? Have they been transferred to the national systems? I think that's a very important question. Now that we've had the last discussant, the discussion is open now to the floor. Introduce yourself and don't take too long. If it's a question, just come to the point.
Have they learned about this issue of the necessity not to take multiple statements? Looking now at multiple organizations existing who are going into the field, I'm thinking specifically of Syria, and taking statements, ex-prosecutors going in, taking statements of allegedly raped women, and NGOs going in, taking statements. For what purpose? There is no tribunal. It's questionable whether there will be a tribunal, and if there is, you're going to have this vast array of statements that may end up being inconsistent. And one of the key lessons of the Rwanda Tribunal is exactly this: don't do this. And yet now, NGOs, governments are doing exactly this. So I just wondered what your thoughts were on that.
We'll take Mr. Taku.
Yes, thank you so much. I rise to comment and to ask a particular question about, we now talk about sexual violence in respect of the bushwives in Sierra Leone. When do you draw a distinction between other inhumane acts and sexual violence as such? And I say so because I was involved in the defense of the Revolutionary United Front for Sierra Leone when this jurisprudence was laid down. And there's a fear that they could criminalize various forms of marriages in the African community. How do you see the role of cultural sensitivity in investigating these crimes? Do you rely on reports established by NGOs and other interest groups, activists in the field, in order to characterize some of maybe other inhumane acts, maybe cultural practices, no matter how despicable they may be, to use that to criminalize various forms of marriages in the African community? And finally, we talk about gender crimes. Where do you fit the evolving pattern where men and also men could also be victims of sexual violence by men or women by women?
Okay. Charles?
Charles Adiogun Phillips. I prosecuted a handful of cases before the ICTR. Mine is not a question as much as a comment and reaction to quite a few things. that I have heard. James, I'm particularly worried about your suggestion about the involvement of NGOs at any stage of investigations into sexual crimes because of the wider collateral issues that may be associated therefrom. So I just thought I'd point that out. Pressure on witnesses and affecting the reliability of their evidence. I'm particularly interested in the remarks on the spontaneity of the evidence on rape, and having prosecuted 12 genocide trials myself, I thought I should pass a comment. There was a reason why indictments were amended during trials. And that has a great reference to something that has been missing from the discussions here, the cultural impact and the cultural sensitivity of investigating rape in the context of Africa. Now, when you have a sexual violence investigative policy that excludes women, female investigators, and you send men into the field to investigate sexual violence, you come back with nothing. It's as simple as that. And when, as a prosecutor, I'm confronted with a witness statement of a witness that is a witness to the rape of several women in the same room, and she just happens to be the only woman in the room that is not raped, it begs the question, how then did she survive? Well, in essence, it turns out that she was probably interviewed by men. And when then I turn up with a female member of my team, Renifa and Florida Kabasinga, who is Rwandese, she is then able to extract from that witness the fact that she was actually a victim of rape and had chosen to conceal it because she didn't feel comfortable speaking to men about it. Now, that is not in your sexual investigation or prosecution manual. And that is perhaps the most important aspect of investigating sexual violence. And it goes on beyond that. Because then when I then find out that she's actually a victim of rape, and I ask her why she's concealed it, well, first of all, there were male investigators. Secondly, because she's finally found a man who's taken some interest in her and she's managed to remarry. She then volunteers to be a witness in my case, my star witness. But she asked the question, I would only be a witness if you can guarantee me that my new husband will not find out that I was a victim of rape. I then am in the position to make a decision either as a prosecutor or as a human being to allow this witness to relive the experience. And I can't guarantee her with all the lofty witness protection measures that we have in place, in quote. I'm not ready to take on that responsibility. Now, those are the challenges that prosecutors face in terms of investigations and making decisions in the field whether or not you want to take a victim of sexual violence to court. And the distinction must be made between a witness to sexual violence and a victim witness of sexual violence, because the considerations are separate. It also affects the judges who adjudicate on their testimony. Part of the legacy of the tribunal was the laughing judges, who, when a defense witness challenged a prosecution witness on the fact that she was covered in human excrement, they found it funny. It is also the same trial chamber or different trial chambers that would laugh or suggest to a prosecution witness and ask her, the prosecution wants to find out where indeed did the action take place. Well, wrong choice of words, because there's nothing actionable about a woman being raped severally. Now, those are some of the lessons that we have learned in the trenches about prosecuting and investigating sexual violence. Thank you very much.
Thank you very much, Charles. The judge from the ECOWAS court, yes.
Thank you, sir. My name is Michael Wright from ECOWAS. My question goes to James and Valerie. In the last 2 days, we were told by the prosecutor that one of the considerations for referring cases back to Rwanda was the fair trial standard, fair trial requirement, rights of the defendant. The defendant will be afforded a fair trial in all of its ramifications. They talked about the Valerie especially talked about shielding the witness and maybe she testifying from behind a screen or distorting her voice and the rest of it. I want to know what's the jurisprudence on counterbalancing, and I'm sure you've heard this before, the competing interests, first of the defendant to a fair trial with all of its ramifications, as opposed to re-traumatizing the witness, the victim, in terms of confronting the perpetrator in court. I'm coming from the background that if one of the fundamentals of the rights of an accused is the right of confrontation. So if he cannot see the witness, the voice is distorted, her mannerisms and her whole demeanor cannot be observed and examined, is that defendant afforded a fair trial? To the extent that the crime is alleged to have been committed and the prosecution is required to prove that the defendant is responsible for committing that crime. And if the defendant is not afforded the opportunity of confrontation and in some cases cross-examination, because I'm understanding that the witness's testimony need not be corroborated. So is it your word is as good as mine, or just your word is sufficient? What's the jurisprudence on the defendant's right to a fair trial in respect of confrontation?
Thank you. We'll take one more question and then come back to the panelists. Madam?
Thank you very much. My name is Janet Salejai. I'm the chair of the Institute for Human Rights and Development in Africa. But I'm also a private legal practitioner in the Gambia. And I've had the privileged opportunity of taking part in several consultancies related to women's rights in the Gambia. And I would like to respond to the question posed by Jamie Moss regarding what do we do with some of these good practices in the international tribunals and how do we put that into the national setting. Well, I would like to report that I had the rare privilege and opportunity of attending the two years ago, the forum organized by the prosecutor in Rwanda. And there I learned about a lot of innovative new provisions contained in Rule 96. And when I went back home also, I had the rare opportunity of being given the opportunity to work on a consultancy relating to gender-based violence generally in the Gambia. And with the knowledge I got from this, that forum, I was able to work on amending the criminal code in the Gambia, and we now have the Sexual Offences Act in the Gambia, which has taken on board all these provisions relating to corroboration, lack of consent and coerciveness, also evidence of prior conduct and all these things. All these things have been taken on board. I'm glad to say that we have a Sexual Offences Act in the Gambia 2013, and this was due to the exposure I had to some of those practices. And I thank the prosecutor and all those who are involved in these things. With regard to, I would like to thank Charles, because I'm a women's rights advocate. I'm pointing out some of these cultural sensitivities that we have to take into consideration when it comes to the trial of sexual offenses, and also the candor and the demeanor of judges, the prosecutors, and the defense, because these are all very important when it comes to dealing with victims. But I find it very difficult with the other aspect of cultural sensitivity relating to the forms of marriages in Africa. As a women's rights advocate, I would say that any form of marriage in Africa, regardless of what your culture is that involves coercion or force, should be frowned upon. It doesn't matter where you're coming from, and nobody can justify that. Once it involves coercion or force, it doesn't matter what your cultural background is. I think we should be frowned upon. Thank you very much.
Thank you for sharing the good news about the new Sexual Offences Act in the Gambia. I'm pleased also that at least the Uganda workshop we had has had one positive outcome in the Gambia. Until now, actually, I thought my information was that it's only one other country, and that's in Latin America, and I believe Costa Rica, which has actually legislated along the lines of the Akayesu judgment in terms of the definition of sexual offense, in terms of rape, which highlights the problem that Jimmy has raised, that the jurisprudence of the tribunals, not just sexual violence, but in other respects too, needs to pass over into the municipal legal systems. And that, it seems, is not happening as much as it should. The practice is also, and also the jurisprudence, for instance, in the area of sexual violence, where we have in the tribunal been able to secure convictions for rape without any need for forensic evidence. It's something which is very commendable, but it also has not, I believe, found a place in the national legal systems. The prosecution of sexual violence in most national legal systems is so intricate, so difficult, so dependent on forensic evidence, which is not available in the majority of the countries, that the process becomes almost impossible, or is fraught with a lot of difficulty. In many of the developing countries, you don't have really the supportive systems which enable you to do DNA testing and other scientific, testing, which is a requirement for prosecution of sexual violence. So a major challenge we have really is how do we make sure that the gains we have made at the international level, particularly in this difficult area, how can we ensure that they are also secured within the municipal legal systems of the member states? But the floor is now for the panelists to react to various questions which have been posed and the comments which have been made. Which order do you, who wants to kick off first? All right, Valerie.
I'd like to make a comment on two of the questions, one of which was directly addressed to me, as well as James. The first question I'd like to speak to is the one about the bushwives in Sierra Leone. I think that the judgment in the Armed Forces Revolutionary Council judgment and the appeals chamber judgment made it very clear that when we're talking about the bushwife system in Sierra Leone during the conflict, that is not about the marriage system in Sierra Leone. And in fact, there was no marriage. It was a system of slavery during the conflict. And the case law, as well as the Charles Taylor case law, has made it absolutely clear. The bushwife system was about sexual slavery plus domestic slavery, and that is not the same thing as any kind of marriages under Sierra Leonean law. So they made that distinction. They are, of course, linked in that what happened to the bushwives was discrimination against women and girls taken that much further during the conflict. So discrimination that had pre-existed taken that much further during conflict. And I think the Sierra Leonean legal reforms that happened in 2007 through the adoption of the 3 gender bills, and then the 2012 adoption of the Sexual Offences Act, get at that and correct, at least in law, the discrimination that pre-existed. On the question from the ECOWAS judge about what happens in the courtroom and the ability of the defendant, the accused, to face the victims and witnesses, in fact, the voice distortion and the facial distortion doesn't happen as between the victim, witness, and the defendant. It happens for broadcasts outside of the courtroom. So for the public, for the online broadcast. The use of the curtain, yes, it can sometimes separate the victim from the accused, but at the same time there is a video feed in many of the cases so that the defendant can see the face of the victim at the same time. I don't know if you want to add to that, James.
James?
Thank you. Let me start with the collection of statements. As the first commentator noted, it is a key lesson of the ICTR that only professional investigators assisted by prosecutors should collect statements from witnesses. But the sad reality is that there are a lot of statements being collected by NGOs and others who are not properly trained in taking those statements. And that is a key recommendation in our manual, that statements should always be collected by trained investigators and prosecutors. What I was recognizing in my comments, though, is that before you take a statement from a witness, if you're operating particularly in a post-conflict region or a conflict region, the likelihood is that someone else has already been out there collecting statements, and that's the point of the first commentator. And that's a reality, particularly in human rights investigations, where they're collecting statements not for use in criminal trials, but for other purposes. And they may not be cognizant of the legal elements and the modes of liability and the rules of procedures and evidence that govern the admission of those statements. Nevertheless, if you're going, before you go out and interview a witness, again, particularly a traumatized witness, as we're talking about, it's important to know what's already been said, one, and it's important to look at that prior statement, if you can get it, subject to the confidentiality restrictions that always exist, to determine whether or not it adequately covers the needs of your case, of the investigation that's being conducted. And if so, then you must take the next step and confirm that that information was accurate. You can't just take the statement collected by someone else and try to use it, and I think we all understand that. That remains a key recommendation in our manual, and that was the import of what I was saying. Simply recognizing that, yes, investigations must be conducted by professional investigators and prosecutors, but the reality is, in the course of that, you're going to encounter witnesses who more than likely have already given statements. You can't just ignore that reality. You have to confront it, and I think that picks up on Greg's comment, too. You have to know who your witnesses are before you present them. And that requires some diligence in knowing what prior statements they may have given so that you can prepare, one, to, well, assess whether in fact their testimony is credible and reliable and should be presented to the tribunal, but also to prepare for any potential cross-examination or other impeachment of that witness. So I think that is one of the best practices recommended by the manual, and I'm sorry if I misled you otherwise. Also, the manual also is quite clear in its recommendation that teams of investigators should be diversely staffed, precisely to address the witness's preference in terms of being interviewed by someone perhaps of the same cultural background or certainly of the same gender. And that is a core recommendation in the manual. It's certainly not something we learned that lesson early on, and our investigative teams were restructured to account for that. And in fact, as pointed out, that's a key part of our global strategy that's recommended in the manual. With regard to the fair trial standards, I don't have much to add to what was said, but I will say this. In assessing any fair trial right, it's subject to a rule of proportionality. If the interests of justice require, then the fair trial right can be impeded to some extent. But the prejudice to the accused can't outweigh the interests of justice. So there's always a balancing that goes on, and that's reflected in the tribunal's approach, because it was never the case that the immediate response was to shield a witness from view of the accused who has a right to confront that witness. There were always measures of procedures that were adopted, and the least restrictive measure was always the preference, unless there were compelling needs for a more restrictive environment, such as complete shielding. So, for instance, at the tribunal, anonymity, the use of pseudonyms to protect the identity of the witness from the public were used. And those were subject to disclosure to the defense so they could prepare for their trial for examination of that witness. And then other things were closed sessions, where again, as my colleague pointed out, those sessions were closed to the public, not to the accused. And similarly, in some other cases, there were screens used, but usually other means were used so that the accused could fulfill and exercise his right to confront the witnesses against them. So I think, bearing that in mind, it's as you start with the least, if there is a legitimate need for the interest of justice to protect a vulnerable witness, then you start with the least restrictive means first, and then you have to measure whether or not more restrictive means need to be applied. And I think that's exactly what the tribunal did.
Thank you. You want to come in?
Thanks very much. James' answer about the manual has saved you all from me reading out the section about gender diversity and parity, and about the need to ensure that cultural sensitivities are understood and dealt with. And the manual, in fact, one of the reasons that I think this is a particularly excellent element of the legacy of the tribunal is because it is hard won, and the tribunal recognizes a lot of the mistakes and discusses openly the mistakes that were made in the prosecution, investigation and prosecution of sexual violence in its opening chapter, and precisely the issues that were raised earlier about male investigators, about lack of cultural sensitivity, about issues which prevented women from coming forward are discussed. The more interesting point I just want to touch on is exactly the one that was asked at the end, about what do you do when you're presented with a witness who wants to give evidence but may not completely understand the ramifications, or may not be willing to take that step if she doesn't, or he, because men are equally important in this, doesn't understand the ramifications. And certainly the international protocol, and I think also the manual, are very clear on this, that the first principle is you do not risk the witness who you are putting forward. And if it comes down to you having to make a choice between that witness not going forward and giving that witness the choice and the witness saying no, or risk to that witness, then that is a clear choice that you make in favor of the witness's safety. And that must be right.
Just two brief points. The first one on NGOs. In fact, my experience is that some NGO people from Human Rights Watch or other NGOs are actually sometimes more experienced than OTP staff in terms of expertise. But that being said, I do share the skepticism about the use of NGO reports and methodology for a number of reasons. The re-traumatization, what you said is that there's a legal definition and they're not trained to take the evidence. But I think it's not an all white or black situation. And even though I'm skeptical about the direct use of NGO reports in some ICC cases, you can separate the type of evidence you're using it for. So you're more likely to be able to use NGO report for contextual elements, the widespread nature, because it's not necessarily the incidents you're charging. Whereas for linkage evidence with a defendant, you're less likely to be able to use NGO reports. So I think there is room for, with the methodological caveats you put, for some use of NGO reports. The second point, if I may answer to Prosecutor Jallo's comment about taking the legacy to the domestic level, I think we have to be careful because everything the international tribunals did is not great. And this idea of forensic evidence, there was a time in domestic criminal law where there was no forensic evidence, and we invented it because it's better. It proves things where witness statements might not prove things. So and I'm not saying it's always perfect, but there are certain rules of evidence at the international level where I won't give a number, but a number of cases which went through at the international level would be thrown out or ended for abuse of process or mistrialed for a number of reasons given by Caroline, for example, or Lubanga, with intermediaries. So maybe even if we do acknowledge the nature of international crimes and the difficulty of gathering evidence, that is not necessarily a model generally. And we should be very wary of just, we should acknowledge that it was the best that the tribunals could do in those circumstances, but it's not an ideal situation. Yeah.
If I can follow on with Dove's comments here about NGOs taking statements, there's a dilemma here, obviously, and the multiplicity may not be ideal in some situations, but they're on the ground first. These courts take years, and I think this was your Syria example. And so I mentioned earlier some statements may be better because they're closer in time to the events. They're also feet on the ground. They may be finding people that the tribunals never get to, and people may be willing to talk about these things when they're fresh, but when they get farther away in time, they shut down, they close down, they don't want to go there anymore. So there is a tremendous value in that, and I can tell you anecdotally, Africa Rights wrote a report about Saromba case that served as very helpful in that case. Again, taking it into cognizance as a part of a whole investigation package. Now, my dear friend Charles, I can't, in this group of opinion makers, let one comment go. And I think you talked about laughing in the courtroom. And I think we're talking about an incident where I was in court. And I want to be really clear here that we shouldn't take away from this, and it's an important part of the legacy. The laughing was not directed at the witness, okay? And you would find it hard to believe that in genocide trials there's moments of levity, but believe it or not, there are. And the laughing directed at, I would say, a poorly formulated question by counsel was what drew that response. And an inaccurate press report about the laughing at the witness had a whole long series of ramifications and spill out. And so I don't want to go away from this legacy conference saying my witness was laughed at. And she knows that. And Rwanda needs to know that. And we all need to know that in this room. But thank you, Charles.
Yes, I'll be very brief. Just on the fair trial issue, I would like to point out that in producing this report, the OTP has been so kind to invite the defense, and we got a panel to discuss all the issues that we were concerned with in terms of challenging the evidence and in terms of how this evidence is obtained, because they want to avoid second victimization, and we obviously want to have an opportunity to scrutinize the evidence. And it is, I mean, I'm just looking at the ICC statute. It's a delicate balance, and none of these measures can be imposed if it is prejudicial or inconsistent with the rights of the accused in a fair and impartial trial. And to be fair on the OTP, some of these concerns have been incorporated in this report. So I just wanted to point that out. Thank you.
Thank you, Caroline. If we don't have any more questions or responses from the panel, I think we have one round. Oh, Jamie? Yes, please.
I just wanted to follow up on the point about forensic evidence. And I think that there were 2 points that I was trying to raise. When you're speaking of sexual violence as an international crime, the point is that it's the context in which it's occurring that's important. And I think that's why the tribunals recognized that the context of armed conflict, of mass violence, of detention, of serial rape, of forced marriage, these are crimes in which the element of consent can be assumed by the context in which the crime occurred. And many of the evidentiary techniques that were developed in domestic criminal justice settings were designed to prove individual lack of consent to an individual act of rape by an individual perpetrator, and specifically often a perpetrator unknown to the victim. So I think that the point is that are these techniques actually commensurate with the crimes that are being adjudicated? And secondly, even if you consider the kinds of forensic evidence that are available in cases of rape, there are many instances in which either physical evidence of injury or biological specimens that if you had every technique in the world to get DNA testing still wouldn't actually necessarily help you with the case itself. And one really good example is that anytime there's a threat of force where someone is essentially submitting to an act of violence because of their fear for their own safety, for the safety of someone else, there may or may not be any evidence of injury. So in that case, you can do a medical evaluation and take a statement, but you may not expect that there would be substantial medical injury. So again, the question is, what is the utility? How does it help advance the case? And can there be exceptions made when you're talking about crimes that are being committed in this kind of a context? So I just wanted to clarify that. And there are many kinds of forensic evidence, as I'm sure everyone is aware. So even among the papers that were circulated, they were mostly focusing on autopsy reports and ballistics. And the techniques that are used with survivors of sexual violence can be similar but still different in their applications. Thank you.
Thank you, Jamie. We have time for one more round of questions. Bagel? Okay. Can you take the mic, please?
Sorry. My question is directed to Caroline. This is about witness collusion, which has been an issue in few cases and for few witnesses. how do you perceive from your angle? Because you have named some of the organizations, civil society, they are doing. But as far as ICTR is concerned, 2 trials were happening and defendants were behind both cases. How do you?
I have to raise that a bit, yeah. Bernd Borchardt, former head of ULEX in Kosovo and now a founding director of the German War Crimes Institute. 2 issues. One, just more to reinforce that what Gregory said about NGOs and others taking witness statements. My own experience was that I set up together with my colleagues in the OSCE mission in 1999, working in the neighboring countries of Kosovo, the opportunity for people to give witness statements to us. I mean, we had some policemen, but also some laymen. And we did that more as a test, and the feedback from the witness was so overwhelmingly positive that they had the opportunity to talk to someone whom they felt they could trust, that we continued that on a broader scale. We got later aware it gave the ICTY some leads to find witnesses. The statements that we collected, I admit, were not overall very useful, not in general very useful, but we could also publish them in a book without names, of course, which left the testimony of what had happened. And the second issue is more a question from my more recent Kosovo background. I appreciated a lot what you said about what Jim said about the manual for how to deal with victims of sexual violence, but how to get did the ICTR do any systematic work on how to convince victims of sexual violence to come forward? There is, from NGOs, etc., victims organizations, the assessment that there were between 10,000 and 20,000 victims during the Kosovo conflict, and we had 13 cases. Thank you.
Thank you. Nuhu?
Ok, je vous remercie, Monsieur le procureur. Ma question va à Caroline, qui a parlé de la collision des témoins. Je m'excuse d'abord, je me présente, je suis Nouhoun Diallo, greffier adjoint de la Cour, mais ancien staff de ICTR. En fait, je voudrais poser la question à Caroline. Les cas que nous avons eus de collision de témoins, à ma connaissance, au niveau de ICTR, la plupart du temps concernent les équipes de la défense. Sauf erreur de ma part, il y a eu des cas où des enquêteurs de la défense ont été jugés et condamnés. Il n'y a pas eu de cas de côté des équipes de procureur. Est-ce que cela veut dire qu'il n'y a pas ce genre de pratique du côté du procureur, ou bien les juges sont plus enclins à regarder du côté de la défense dans ce domaine? Je vous remercie.
I'll turn to the right here. The lady right at the back. Oh, that's Rosette. Been with the, I believe, since the inception. She's one of the veterans of the struggle.
Thank you very much. Okay, I have to move apparently closer to Charles because my comment concerns some of his comments. It's all very easy for those who came a little later to criticize how poorly the investigations were conducted in the very beginning. Just for the record, there was a sexual violence team which was chaired by a woman, Elizabeth Farr. We had two specialist investigators donated by the Dutch government who were in charge of the interviewing. And I was on that panel, and I think I'm still a woman. So it is not that the people who were sent were male investigators. There are so many other factors that we have to look into that prevent victims of sexual violence from coming out. The second point is, whereas gender plays a major role, every situation varies. I participated in one of the investigations in the Arab Spring, and victims of sexual violence would never speak to women, especially the men. The only people they could speak, the men could only speak to women, and the women could only speak to men. Who would have expected that in an Arab country? So we still have many lessons to learn, and we should go slow when we are criticizing. Thank you.
Thank you. Andras Vamish-Goldman, Executive Director of Justice Rapid Response. I want to go back to the question that was originally asked by Nina Tavakoli, and which has been now responded to 2 or 3 times, including from the floor, about the information being collected by organizations and groups without jurisdiction. And we seem to be assuming that there are really 2 possibilities. One, we wait a long time for international justice to happen, and then you will get professionals doing the collecting. Or 2, we allow groups who are not professional, may not be trained, may not be collecting the information correctly, and may well be endangering the survivors, but it's better than nothing. And I think we can't just leave it at that. I think there is a third option. The third option is making sure that there are specifically trained professionals who are available quickly to be able to go on the ground. And we need to work towards that. That's what we are working towards. And I think to the extent that these experts can replace untrained no matter how enthusiastic and how well-meaning people, is the better option. And this leads me to a question that I think Nina asked, but I don't think it was addressed by the panel. Under the jurisprudence that we now have from the tribunal, if there is information collected by these groups without jurisdiction, let's say it's documentary information, what will its admissibility be in a subsequent accountability process? Thank you.
I have a couple of observations to make on the impact of the ICTR's legacy on the investigation of sexual violence. One a positive example from another domestic jurisdiction, and one sadly a slightly less positive one from a hybrid tribunal. The first, many of you may recall that on the 16th of December 2012 in New Delhi, there was a notorious gang rape that occurred against the backdrop of sadly pervasive sexual violence within India. One national response to that was to constitute a commission by the name of the Verma Commission, which drew directly on Rule 96 and various features of the ICTR jurisprudence on the prosecution of sexual violence, many of which were ultimately adopted in Indian legislation, not all, but many. The ICTR practice and jurisprudence is also immensely useful to Indian civil society who are activists to end impunity for sexual violence for 2 principal reasons. Firstly, the jurisprudence in relation to a coercive context, which is very relevant to a lot of very low-level, low-intensity quasi-armed conflicts around India. And secondly, the idea that you can have rape prosecutions, successful rape prosecutions, in the absence of forensic evidence. In the Indian context, forensic evidence, sadly, actually amounts for a lot of acquittals for reasons that are inappropriate. And so the idea that you can circumvent this evidence where it can't be used appropriately or where it's actually irrelevant has been hugely useful. The example where I think the legacy of the ICTR has not been fully actualized is before the ECCC, where unfortunately the primary case before the ECCC did not include any sexual violence allegations at all. And the official explanation for that from the investigators was, well, we didn't get any evidence, the witnesses never reported that they experienced sexual violence. Apparently in ignorance of the fact that, as we all know in this room, this is unusual. It would be unusual for a witness to simply volunteer this information. And secondly, that, well, there might have been sexual violence on the ground, but we don't think it's relevant against our particular accused. I think this has had a massive reputational impact on the ECCC that's been very hard to recover from. Also, as an aside, the same cultural sensitivities of victims of sexual violence in Cambodia are observable. And the other thing is that some features of sexual violence before Cambodia are unusual, and in particular the practice of forced marriage, which many commentators have and advocates tried to characterize as sexual violence, but unfortunately it doesn't really work in that light, because while consummation of said marriages was required, both parties to those marriages were coerced, and so it doesn't easily fit within the framework of sexual violence. In relation to the ECCC's struggle to investigate sexual violence in case 2, I'd like to pose a question to conclude my observations, is that many of the trial judgments of first instance before the ICTR actually did record rape convictions, only to be overturned on appeal because of an alleged absence of notice to the accused, who are often significantly higher up the chain of command. And I'm wondering if any of the panelists had any specific lessons learned in terms of linkage or inquiry notice in relation to rape convictions or prosecutions. Thank you.
Thank you. Yes, Madam. I think this will be the last question. We could go on for a while, but we don't have much time now left. Yes,
okay,
please,
thank you. For the last question, I'll be very short. My name is Beni Yi. I work for Redress, and my question relates to the charging of rape. What are the lessons learned from the ICTR on how to charge rape as a crime against humanity, whether it is charged as a standalone crime against humanity, or whether it is charged cumulatively with other crimes against humanity, or whether it is charged as an act, for example, of torture or other underlying crimes? Thank you.
Any members of the panel want to respond? James, to the comments and the questions?
Well, first of all, I think in the practice of documenting best practices as part of kind of wrapping up the legacy of the tribunal, I think it's been our mission, certainly within OTP and I think in the broader ICTR community, to look at not only where we succeeded, but where we could have done better. And in the process of that, that's not meant as a criticism. That's meant to share best practices for the future. Because often you learn the best practices from where you could have done better, or your failures, than where you succeeded. Because quite frankly, when you're addressing complicated cases such as we are, the answers are not always apparent. In a tribunal such as ours that just started from scratch, there were a lot of new things that had to be created, new procedures, new ways of doing things that had to be learned. And over time, we developed them. And our goal in trying to preserve the legacy or share the legacy of the tribunal is to document all of that so that others learn from where we succeeded and also avoid some of the mistakes that were made along the way. And that, I think, is essential to any compilation of a legacy of any kind of entity like ours or not. So I just want to clear the air on that. There's certainly no means to criticize. We did the best that we could do at the time with what we knew at the time, but that doesn't mean we don't look back and try to improve for the future. In terms of collusion, my sense of that was, I see no indication of how a standard would be applied differently to the prosecution versus the defense. I think as we have been discussing all during this panel, there's settled rules on the assessment of evidence that I think apply equally to both the prosecution and the defense. And what really turns on it is the quality of the evidence. And if to suggest that there's some bias in favor of one side, there are standards that govern those accusations as well. And there can't be easily thrown out that because in one case there were allegations that were credited as to defense teams, that means there's an onus put on the defense that is not put on the prosecution. It just means the quality of the evidence may not have been the same. And unless there's some tangible basis for saying otherwise, I think we presume that judges will judge these cases fairly and impartially, and I have yet to see a case where that's been otherwise in these allegations of witness tampering or collusion. In terms of how to convince victims to come forward, that is a very difficult obstacle, and that is something that we struggled with in the manual and have whole sections of the manual devoted to some of the approaches for approaching witnesses, particularly in terms of talking about instances of sexual violence. It certainly is not the case that it is as simple as putting in a female member of the team and then everything is fine. That's certainly not the approach, and that certainly is not any kind of panacea. And also what we make quite clear throughout the manual is that you must consider the cultural context in which you're working. So it is not surprising to me that in other cultures, there's a different dynamic where it might be easier for men to talk to women about it or vice versa. All of that has to be taken into consideration in planning an investigation. And by no means am I suggesting there's a monopoly on behalf of criminal prosecutors or professional criminal investigators, that they are the only ones capable of conducting these investigations. And I think Justice Rapid Response proves that point. In fact, they're highly trained investigators. And I think the idea of the roster is a terrific idea, particularly given my experience in working in a conflict area. That is, in fact, often the only reliable basis for doing it, because quite frankly, the human rights approach to documenting human rights offenses, human rights violations, is not really looking toward preserving evidence for future use at trial, but that needs to be factored into, particularly with high-level accused. And on that point, linking the high-level accused has been a primary challenge that we faced at the ICTR, because so often in the superior command responsibility, the higher-ups that we were going after were not the ones perpetrating the crimes on the ground. And linking them to that proved to be very difficult. Again, I won't take up all the time because I know we're running short, but our manual does have several practical recommendations for how you should find that linkage evidence. And it includes, for instance, if you're investigating an incident, finding out who perpetrated that incident, who else was present, what orders were given. And there's a series of questions that are proposed in our manual that investigators should consider asking the witness to try to draw the link between the person who actually committed the crime on the ground, the physical perpetrator, and the person who is ultimately responsible at the top of the hierarchy. And I know the protocol also adopted by the UK has similar recommendations. And also adds some other ideas that should be considered in preparing an investigation along those lines. In terms of lessons learned in the charging of rape, I think what we've struggled with primarily is, again, it's a development in the law of pleading practice, the specificity required of the charges in terms of all the details that have to go into the indictment to give fair notice to the accused. And I think there have been different approaches over the years to pleading practice. And the pleading practice of the prosecution has changed over years in response to that jurisprudence. I don't think there's any one answer. What matters most is that there's fair notice to the accused of the charges against them. And whenever the specificity can be provided, in terms of dates, times, locations, identity of the accused, and all of those details, we should provide them. And in terms of whether you charge it as a standalone crime or cumulatively, I think there has to be consideration of that in the strategy of the case. But I think my own view is it should be charged as a standalone crime whenever the evidence supports it. And cumulative charging is permissible, but I think you have to consider the circumstances of each individual case.
Okay.
There's so much that I could respond to, but I think I'll just focus on the last point, because it's a very interesting point. And if you look at what the ICTY did in terms of charging rape and sexual violence, where there was a lot of cumulative charging, you look at what the ICTR did, which the practice varied, and you look at the ICC in the way that it has responded quite negatively to cumulative charging. It comes down to your jurisprudential, in a philosophical way, your jurisprudential approach to how you want to characterize these crimes. And there's a lot to be said for characterizing rape as a standalone crime, so that it is properly understood and it is properly given the respect that it deserves. There's also something to be said for recognizing that rape also amounts to torture, also amounts to genocide, and can be elements of other crimes. But I think it does come down to your jurisprudential viewpoint, and that makes it very complicated.
Briefly, just to be, the bias between the defense and the prosecution, there is one, and it's in favor of the defense. It's called the presumption of innocence. So the evidence cannot be assessed in the same way. The defense is not bound by bringing evidence that has the same level of credibility. They're just meant to, shed doubt on the defense of the prosecution. So when this idea of equality I think is fallacious in that context. I have a question actually, and for those who do research and empirical research, is there a link, might there be a link between compelling victims to testify with victim participation? And I'm wondering if anyone has done any study on, might there be an evolution in practice in that respect at the ICC, so that the fact that there is a whole procedure which might give assurances to victims might have a consequence on their participation as witnesses. So I'm just wondering. And the last one on cumulative charging, I think in those cases, and you mentioned philosophy, I think you're right. It's not just a legal issue. It's a question of fair labeling. It's a question of recognizing something. And there's always a thin line between acknowledging a fact and making it a legal reality. And I suppose maybe that won't be very popular, but maybe at some point the legal reality of sexual violence was necessary. But this created problems, and we're faced with this issue of consent, for example. Is it really rape we're talking about, this kind of sexual conduct in war? Because we're stripping away everything we understand about rape. I know in one case the prosecutor had said that you don't need consent to show absence of consent for torture or other things, but you can consent to sex. Consent, everybody understands, or I would say everybody understands rape as unconsensual sex. So I'm not saying we should do that at the tribunals. We heard all the difficulties. But is that really rape that we're talking about? Are we really not stretching the idea or understanding of rape in the context of war, with the sociological dimension of rape in domestic systems where you won't have this context? And maybe now that there has been this legal recognition, we should try to avoid all those problems again by, you acknowledge a conduct, but what's wrong with just recognizing it as bodily harm? Ultimately, which is what they did with rape as genocide, initially. I think that we should be aware that our sociological evaluations don't necessarily lead, not saying they never, but don't necessarily need to lead to legal change. It's like with cultural genocide, but that's a different issue. Thank you.
Just 2 words on that. It's not necessarily agreed that consent is a question purely of fact. Then the way in which rape is conceptualized, and in particular the way that consent is conceptualized, is heavily gendered. And in fact, it may not be a question just of fact, but it may be as much a philosophical question as the way in which it's charged is.
Yes, I will be very brief. First of all, what next after I made my points? We are here at a legacy conference, and this tribunal is about to close. But there will be other tribunals, and there is also the Permanent International Criminal Court. So first of all, I'm hoping that some of these points will be considered in the future, because I do think it's very important that if there's evidence that is convincing up to a prima facie standard, that these sort of allegations are looked into. That's the only way that we can prevent this from happening. But there's also something more concretely. Though these cases are finished and most of them confirmed on appeal, if we can prove that some of these defendants have been found guilty on corrupted evidence, then there is a possibility to ask these cases to be reopened. There is a review procedure. It is not easy to do that in reality because the standard is really high. You have to show, you have to come up with new evidence that was not available during trial or not and could not have been obtained with due diligence. And so, but if, you know, there's still diligent defense counsel who are looking into this issue quite carefully. On the other point, if I understood well, your view was that there's been more allegations against defense. Well, I've looked at this quite carefully, and I really would disagree with that. There have been allegations against either members of defense teams or people associated or allegedly associated with the defendants. There have definitely been these allegations, but in my review of the case law, it seems that one of the very striking repetitive situation has been prosecution witnesses recanting, some of them who later on became defense witnesses. That is, I mean, obviously, we can't get into a yes, no, I don't have numbers. I haven't actually calculated that way. But I do know that that is something that happened very, very, very often. And there is this perception, and that goes beyond the ICTR, there is this perception when we're talking about witness interference, that this is always done by either the accused, family of the accused, or anyone who is like associated with the accused or the defense. And there's less, I think, awareness that this is also really happening at the other side. And just one last point, as I said, there's been a bit of in the ICTR, there has been a development. It's been taken more seriously towards the end. And I mean, in some ways, that also resulted in a higher level of acquittals. And some people, chambers always take a different approach. But as I said, there has to be awareness that this is a real issue.
Thank you, Caroline. I have to resist the efforts of other panel members who want to continue. We've already eaten almost 15 minutes into the time of the next session. Let me thank all the panelists and the discussants, and let's give them a round of applause. Thank you.
Our sincere thanks to Prosecutor Jallo and to our distinguished panel members. At this time, we will call on our third panel on the theme of cooperation of domestic justice mechanism with regional and international courts. And I will kindly remind our audience that this today will be the first part on this very compelling discussion that will continue tomorrow morning at 8 o'clock. Our panel will be moderated by the registrar, Mr. Bongani Mojola. Thank you. Ladies and gentlemen, can I kindly remind you that we're running late? If you do not mind, please get back to your seats. We would appreciate that. Thank you very much. Ladies and gentlemen, we'd like to reconvene at this time. Thank you.
Daryl. It's Daryl Mondes. Daryl, you are one of our Registrar Majola, Registrar Mondes.
Good morning, everybody. Good morning. My name is Bongani Majola. I work for the ICTR, and I'd like to welcome you to this session and to also welcome our presenters. We will have presentations today, and if there is time, we may also hear one or two of the discussants. And then tomorrow morning we will hear the rest of the discussants, and then we will open it up for discussion. I feel that we should not hear the presenters and then discuss, because we may be trapped in the discussion and not hear the discussants. So we will hear everybody. We do not have enough space on the podium, so what we're going to do after the presentations, we will rearrange the furniture on the Titanic and get the discussants up here. I would like to ask for an exemption from introducing the presenters. They are described on the program, and the Honorable Prosecutor did borrow 15 minutes of our time. And so our topic is on an important issue of cooperation of domestic mechanisms with regional and international courts. And I've got an array of speakers who are on the program, and in the interest of time, I will not be referring to them. But I say that this is an important topic because these international tribunals do not have the law enforcement mechanisms of their own, the police and so on, and they therefore, and they don't even have territory. They have to request permission to step on anybody's territory. And so cooperation therefore becomes of critical importance. We will hear from a number of varying backgrounds and see what conclusions we can come to and what lessons we can learn. I would like just to appeal once more to the presenters to try to limit their comments to 10 minutes and to the discussants to limit theirs to 5 minutes. I would like therefore to start with Ms. Sarah Attica, who is the Chief Witness Support and Protection in the Mechanism for International Criminal Tribunals, who is sitting to my far right. The floor is yours. Well, good morning.
Good morning, Mr. Majola. Thank you very much for that introduction. My presentation will be my way of connecting the dots from the significant role of witnesses in the judicial process to the introduction of protection on our African continent. Today I want to tell you a story, a success story. It's a story that can often be traumatic, but this is a story that is a success because it reflects the empowerment of witnesses who testified before the ICTR. It reflects the empowerment of a country as a whole, and it reflects a paradigm shift in witness protection that has reverberated throughout the continent. In my days working in Kigali as a victim support officer, I met hundreds of witnesses, and the pattern was always the same. The witnesses were usually afraid and uncertain at the beginning of our encounters. Sometimes their suspicion was evident, but it would almost always end in relief, whether it was because the witness felt that she had contributed to international justice or simply because her story had been told. Excuse me. How is this possible, you ask? I want to give you a behind-the-scenes view of international criminal justice that is rarely ever seen. When I would meet a witness for the first time, I always tried to put myself in their shoes. For most, the trip from Cyangugu in western Rwanda to Kigali was in itself the furthest they had ever traveled from home. And before even testifying at the ICTR, there remained a journey of approximately 1,000 kilometers to Arusha, a destination that was completely unfamiliar in every possible way. The witnesses were unaccustomed to the mode of transportation. It was the first time for many to be on an airplane. Communication was conducted through an interpreter. Upon arriving in Arusha, they had little time to adjust before they would have to face the environs of international justice. As a member of the Witnesses and Victims Support section of the ICTR, I would try to minimize their discomfort in this unfamiliar territory. Witnesses would receive a briefing before they left Kigali, and this briefing gave them a real depiction of what a day in court would be like. Counseling was provided by qualified professionals, which they continued to receive while they were in Arusha. The support they received was holistic, from preparing them to see the accused for the first time, to providing them with clothing that was appropriate for their appearance in court. Even after their return home, a support structure remained available for them through the ICTR sub-office in Kigali. But these efforts would have been in vain if the witnesses' safety could not be guaranteed. In response, the ICTR developed various methods of protection. Sometimes it was as simple as providing a pseudonym, or an ingenious way of arriving at a witness's village so as to avoid revealing the true purposes of our visits. Often it required teaching witnesses about their role in ensuring their own safety. We explained to them that when they returned to Arusha, when they returned from Arusha, they should not draw attention to themselves. For instance, by discussing their recent trips with their friends in bars, local bars, or flaunting their new clothes immediately upon arrival. In this way, WBSS helped to empower the witnesses who testified before the ICTR, but it still required the cooperation of national authorities. When the ICTR first began its witness protection program and spoke of providing pseudonyms or having support available to witnesses on 24-hour hotlines, it was as if we were speaking a foreign language. 20 years ago, the idea of witness protection in Africa was a novel concept. Indeed, the only country on the continent that had a functioning witness protection program at that time was the Republic of South Africa. Understandably, at first, we faced resistance. Witnesses feared repercussions, and there was a mistrust of the unknown. At first, witnesses were not willing to come to testify in Arusha, but there was no other option. The ICTR was established to try those most responsible for the genocide in 1994, and it needed witnesses to do so. Trials overwhelmingly relied on eyewitness testimony rather than documentary evidence. As a result, we began to sensitize witnesses and other stakeholders. Through targeted trainings of local law enforcement, prosecutors, and other stakeholders in the judicial process, a partnership was forged. We sensitized them on the importance of having an unbiased witness protection program that provided support both to prosecution and defense witnesses. Although the basis of these campaigns was the ICTR's fundamental need to bring witnesses to Arusha, inevitably the seeds of witness protection were sown. With the start of the Gacaca process, it became clear to Rwanda that it needed a more formal witness protection program if victims and survivors were to tell the stories to these community courts. Consequently, the Rwandan government established support units for victims and witnesses and placed them under the National Public Prosecution Authority and the Judicial Police. Both of these offices had been key participants in ICTR's efforts to engage and sensitize the community. It became obvious that Rwandans had begun to take ownership of the process of witness protection. The Judicial Police appointed focal points, and the NPPA established offices in each of the provinces. These local offices, each equipped with trained witness support staff, proved so effective that today the United Nations rely heavily on them to ensure the continued protection of our witnesses. Through the seeds sown by the ICTR, witness protection in Rwanda flourished. Faced with the challenge of ensuring unbiased protection to prosecution and defense witnesses in more traditional fora as genocide trials in 2008, the Supreme Court established a second witness protection unit independent from the NPPA. The creation of this second protection program was instrumental in helping Rwanda to secure the transfer of ICTR cases such as Uwinkindi and Munyagishari to its domestic courts. Now you can see why I call this a success story. A mere 20 years ago, witness protection in Rwanda did not exist. Today, the country has functional mechanisms that meet international standards. But I'm yet to finish the story, Madam Timekeeper, if you can indulge me. In helping to build capacity for witness protection, the ICTR did not stop at Rwanda. Interest in learning from the ICTR's experience began to grow with national authorities, and regional courts requested capacity building in the area. To date, the ICTR, and indeed the MICT, have conducted trainings for various stakeholders in Kenya and Tanzania. These efforts have not only strengthened witness protection domestically, but have also enabled partnerships between national protection programs and international courts. The experience of the ICTR shows international courts cannot do it alone. They must rely on member states' support if they are to be of any relevance in the evolving field of international justice. In closing, allow me to share a personal anecdote. Last week when I was in Kigali, I met a witness who reminded me of the empowering nature of protection. She recalled a visit to the ICTR offices nearly 10 years ago, when she had tuberculosis in her 9th month of pregnancy. Through partnerships made between ICTR and local hospitals, she was able to safely deliver her child and to overcome the tuberculosis. She proudly showed me a photograph of her 9-year-old son and said, if it was not for WVSS, I would not be alive today. This story is just one example of the effects of the support and protection that the ICTR has provided to witnesses over the last 20 years. What began as a seed selfishly sown in the hills of Rwanda has today become the channel through which the entire model of witness protection in Africa has shifted. Conclusively, we can say that the legacy of the ICTR's Witnesses and Victims Support section will carry on long after the ICTR doors have closed. Thank you.
Well, thank you very much, Ms. Attika. I'd like to immediately follow your presentation with that which also relates to Rwanda on the referral of cases that would be presented by Mr. Richard Karejieza of the mechanism within the next 10 minutes. Thank you.
Thank you, Bongani, distinguished delegates. 10 minutes is probably not enough to canvass such a broad topic, so I propose this afternoon just to focus on some of the key lessons learned from our 11-bis referral experience, and even within that experience to focus on empowering domestic jurisdictions. The architecture of international criminal justice is such that ultimately the bulk of prosecutions will have to be conducted by national jurisdictions rather than the international courts and tribunals. But with countries emerging from conflict like Rwanda, there will be challenges of capacity, of will, and will require support, broad support, national and international, in rebuilding judicial capacity and infrastructure. And I'd like to focus on about 6 lessons, some of which were actually emphasized in the just concluded prosecutors' colloquium over the last 2 days. The first is that to have any meaningful change, there must be political will, and I think the Chief Justice of Tanzania really underscored it. There must be political will to build and maintain strong and independent criminal justice institutions with an enabling environment to execute their mandate. With the setback experienced in the first round of rejected referrals, Rwanda went back to the drawing board in an attempt to address the concerns of the tribunal and furthered reform that enabled the successful referral applications during the second round, and that exhibits a strong political will to pursue domestic prosecutions. But even distinct from Rwanda, we have other countries. I think there are about 9 countries which between them have prosecuted Rwandans for international crimes. And even a developed country like Belgium, which has done the bulk of prosecutions, 8 in number, you can see political will at work after initial setbacks. Belgium was the first to arrest the 3 wanted Rwandans, Kanyabashi, Ndembaje, and Higaniro, and immediately the OTP asked Belgium to defer. In the event, there was a deferral in respect of 2 of them, but Belgium persevered and actually prosecuted Higaniro with the Sovo nuns, and has since, prosecuted a total of 8. Even in the case of Ntuyahaga, where the OTP this time tried to defer. In fact, I was just telling James, on the 16th of March 1999, the OTP decided to withdraw the indictment against Ntuyahaga, but it was actually an application, an 11-bis referral application without an 11-bis, and the tribunal sympathized and said, no, the provision in the statute and rules is for primacy, and its national jurisdictions have to defer to the tribunal, and there's no provision for the reverse. So, but notwithstanding that setback, Belgium persisted and pursued, and it's currently still, investigating probably more Rwandan fugitives than anyone else. So there must be political will. Second is that rebuilding judicial capacity and infrastructure requires time and substantial resources. It's important, therefore, in the process of rebuilding this capacity, to forge effective partnerships between the key players who will both, advocate for the change and help in mobilizing resources to drive that change. We actively engaged government, civil society, bilateral and multilateral donors, which helped us, have these reforms prioritized on the national development agenda, and thereby, help in mobilizing resources. You'll recall, of course, that Rwanda was emerging from conflict with so many competing demands: health, education, resettlement, relocation, defense. There was still an ongoing conflict in the Congo. So justice isn't normally that high on the agenda. So it took a lot in advocating for the reprioritization of justice on the national agenda. Third lesson is that legislative reform should be approached in a holistic manner with a view to aligning existing penal processes rather than superimposing an alien or foreign one over an existing substructure that may create what may be perceived as a 2-tier system, an exclusive club for VIP criminals, and then the bulk of society not benefiting from protections. In fact, an early criticism of the early reforms in 2007 was the abolition of the death penalty in respect only of referred cases, when it remained on the statute book in respect of all other criminals in Rwanda. That was rectified, however, within 4 months, so that by July 2007, the death penalty was abolished across the board. Criticisms, however, continue in respect, for example, of preferential treatment on conditions of detention, or even better legal aid, defense legal aid arrangements in respect of of transferred fugitives. And I believe my colleague, former monitor, Anis, will be talking about his observations in that respect. And even Jean Bosco from the International Crimes Unit may elaborate further on that, or on the perceptions of a two-tier system. The fourth that also relates, of course, to I mean, once there's reform, legislative, administrative reform, there has to be skills enhancement, you know, building new institutions. There were developments in the penitentiary sector. A first-class prison in Mpanga, currently occupied by some 9 convicts from the Sierra Leone Tribunal. A new facility, a holding cell in Kigali for remanding transferred or extradited fugitives, but also skills development targeting key players in the criminal justice sector responsible for management, investigation, and prosecution of international crimes. It's very important that a critical needs assessment is done prior to embarking on capacity building initiatives. And in fact, I think it was around about 2007, because of the rather haphazard manner that capacity building was being done on a bilateral basis or you know, through NGOs. Rwanda centralized the planning and implementation of training initiatives through the ILPD. I'm told there's 1 minute. I can always come back to that. But related to this is the creation of specialized units for war crimes investigators, prosecutors, and judges. And for those of you who may have read the Human Rights Watch report, they draw from, I think, 3 European jurisdictions, France, Germany, and Netherlands, and it applies with equal force to the Rwandan situation. We have an ICU that handles these crimes. We have specialized investigators, witness protection. So yes, that's capacity building. 5, networking is very important among war crimes prosecution units where witnesses or suspects transcend national boundaries. Prosecutors tend to be a bit territorial. If you thought criminals were, prosecutors are worse. But we have seen brick walls come down through networking with the European Genocide Network, more recently with the International Association of Prosecutors, Forum for International Criminal Justice, which isn't being used so much, but even informal collaboration with specialized units. It's not uncommon for Lars Plum to call me on my cell phone in the middle of the night. Informally, we're sending a request, but in the meantime, can you start running the search? And bang, you know, by Monday, the search is done, and when the formal request comes on Friday, he can get his results in an instant and be able to move. And we need that to happen. Last but not least, I've overspent my time, is fair trial rights require that an accused be provided with legal representation where he or she is indigent. And it's important that funding of a legal aid program is factored into planning for the domestic prosecution of international crimes. It was announced, I think, on Monday or Tuesday this week in Rwanda that the government had injected 9 billion francs, which is about $15 million, into a legal aid fund. Government had already paid up 55% its contribution, and the donor community is putting up 45%. That is very, very important. I'll wrap up by just suggesting that there are more lessons than the 6 points I've just enumerated, and the OTP is in the process of compiling a best practices lessons learned manual on this subject, which goes beyond capacity building. It goes into litigation involving transfers, best practices which may apply to extradition, and it should be published before the closure of the ICTR. With that, I thank you very much, Mr. Chairman, and distinguished delegates for your indulgence.
Thank you very much, Richard. I would like to quickly go on to Mr. Siri Aliba from the Extraordinary Chambers in the Courts of Senegal, who will talk about the hybrid international courts. Over to you, Mr. Ba.
Merci, Monsieur le Registrar. Les juridictions internationales hybrides le sont à un double point de vue. Elles sont hybrides d'abord de par leur composition, parce qu'il y a des juges nationaux et des juges venant de l'étranger. Elles le sont également parce que dans le droit applicable, parce qu'elles appliquent aussi bien le droit interne que le droit pénal international et certainement les meilleures pratiques pour parvenir à des procès impartiaux et équitables. En ce début du XXIe siècle, elles ont connu une certaine fortune, sans doute pour contrecarrer un peu le gigantisme et le caractère onéreux des tribunaux pénaux internationaux. Elles sont apparues comme étant une réponse appropriée pour la commission, pour la répression de la commission des crimes à grande échelle, des crimes de masse et des crimes internationaux. On a commencé d'abord en 2002 par le tribunal spécial pour la Sierra Leone, qui est le fruit d'un accord conclu entre les Nations Unies et la République de Sierra Leone, et qui avait pour mission, ce tribunal, de poursuivre les principaux auteurs, les principaux responsables des crimes internationaux, génocide et crimes de guerre, mais également des crimes au droit sierra-léonais qui avaient été commis à partir de 1996. Il y était même inclus les auteurs d'entraves au processus de paix, ceux qui tendaient à saper la marche du processus de paix. Il y avait dans ce tribunal plus de juges étrangers que de juges nationaux. En première instance, par exemple, c'est deux juges internationaux, deux juges étrangers nommés par le secrétaire général des Nations Unies et un juge sierra-léonais nommé par le gouvernement sierra-léonais. À la chambre d'appel, c'était 3 juges nommés par le secrétaire général des Nations Unies et 2 juges nommés par le gouvernement sierra-léonais. Le procureur était nommé par le secrétaire général des Nations Unies, c'était certainement un étranger, et le procureur adjoint nommé par le gouvernement sierra-léonais. En 2003, un accord a été conclu également entre le Royaume du Cambodge et les Nations Unies, qui avait abouti en 2004 à la mise en place des tribunaux ou des chambres extraordinaires au sein des juridictions cambodgiennes. C'est une loi cambodgienne qui a créé ces chambres extraordinaires, mais à la suite d'un accord intervenu entre les Nations Unies et le Cambodge. Là, la tendance était un peu inversée parce qu'il y avait plus de juges cambodgiens que de juges internationaux. Et tous les juges et procureurs étaient nommés par le Conseil supérieur de la magistrature du Cambodge. Bien sûr, les juges et procureurs internationaux étaient proposés par le secrétaire général des Nations Unies. Par exemple, en première instance, il y avait 3 juges cambodgiens et 2 juges internationaux. À la chambre d'appel, qui était composée de 7 membres, il y avait il y a, parce que ce tribunal-là existe toujours, 4 juges cambodgiens et 3 juges internationaux. Ils sont tous nommés par le secrétaire général, par le Conseil supérieur de la magistrature du Cambodge, les juges et procureurs internationaux étant proposés par le secrétaire général des Nations Unies. C'est une procédure de civil law qui est à court parce qu'il y a des juges d'instruction, des co-juges d'instruction d'ailleurs, un juge d'instruction international et un juge d'instruction cambodgien. Il y a également 2 co-procureurs, un procureur cambodgien et un procureur international. La règle, c'est de rechercher le consensus, mais lorsqu'ils n'arrivent pas à s'entendre et si le différend persiste pendant plus d'un mois, ils peuvent saisir une chambre préliminaire qui doit trancher le différend. Si la chambre préliminaire n'arrive pas à une décision, la procédure suit son cours. Après ces chambres extraordinaires cambodgiennes, il y a le tribunal spécial pour le Liban, qui a débuté d'abord par la création d'une commission d'enquête internationale par le Conseil de sécurité des Nations Unies en 1985, si je ne m'abuse, et ensuite en 2005, si je ne m'abuse, suivi en 2007 de la création du tribunal. Là-bas, sur 11 juges, les 4 sont libanais. Et ils sont tous nommés par le secrétaire général des Nations Unies. Le procureur est nommé par le secrétaire général des Nations Unies, et c'est un étranger. Et le procureur adjoint est un Libanais, nommé par le gouvernement libanais. Il y a enfin les chambres extraordinaires au sein des juridictions sénégalaises. Il ne faut pas se laisser abuser par l'appellation au sein des juridictions sénégalaises. Elles ont un caractère international parce qu'elles ne sont nullement dépendantes de la hiérarchie et de l'ordre judiciaire interne du Sénégal. Elles ont été créées le 22 août 2012 à la suite d'un accord conclu entre l'Union africaine et le gouvernement du Sénégal pour poursuivre le ou les principaux responsables des crimes internationaux qui ont été commis sur le territoire tchadien entre le 7 juin 1982 et le 1er décembre 1990, ce qui correspond à la période d'exercice du pouvoir par Hissène Habré, parce qu'il a été renversé le 1er décembre 1990. Il est allégué que des crimes massifs y ont été commis et ont entraîné 40 000 morts ou disparus. La première plainte avait été déposée en 2000. Elle avait abouti à une décision de la Cour suprême du Sénégal qui disait qu'on ne pouvait pas le poursuivre au Sénégal parce que les crimes avaient été commis à l'étranger, par un étranger et sur des étrangers. À l'époque, on n'avait pas la compétence universelle dans le Code de procédure pénale sénégalais. Bien que les crimes de génocide soient poursuivis, fassent partie du droit coutumier international comme les crimes contre l'humanité, et bien que la Convention de 1948 ait été ratifiée par le Sénégal, les juges internes n'acceptaient pas à l'époque la notion de compétence universelle. Le Sénégal a modifié sa législation en 2007 pour pouvoir le poursuivre, mais les avocats de Hissène Habré ont saisi la Cour de justice de la CEDEAO pour dire qu'on attentait aux droits de Hissène Habré. Il y avait là un caractère rétroactif. La Cour de CEDEAO...
Excusez-moi.
La Cour de la CEDEAO avait répondu qu'il fallait créer une juridiction internationalisée. En 2012, la Cour de justice internationale s'est également prononcée sur la question parce que la Belgique avait attrait le Sénégal devant la CIJ. Pour la règle aut judicare aut dedere, il fallait soit le poursuivre, soit l'extrader en Belgique, où une plainte était pendante. La Belgique également, dans ce différend, a tranché ce différend en faveur de la Belgique, en disant que le Sénégal devait le juger ou l'extrader. C'est une cour qui est composée d'une chambre de première instance et d'une cour d'assises qui également juge en première instance et en appel. Le procureur est indépendant. Tous les magistrats sont nommés par la Commission de l'Union africaine sur proposition du ministre de la Justice du Sénégal. Les peines encourues peuvent aller normalement jusqu'à 30 ans d'emprisonnement ou un emprisonnement à perpétuité lorsque l'extrême gravité du crime ou la personnalité de l'auteur le justifie. Le budget n'est pas énorme, c'est un tout petit tribunal, c'est un budget de 8 600 000 euros environ, 5 milliards 600 000 francs de CFA. Et la durée de vie du tribunal est prévue pour 40 mois. 23 mois pour l'instruction, 10 mois pour le jugement en première instance de la cour d'assises, 3 mois pour que les juges s'imprègnent du dossier et puissent tenir les conférences de mise en état, 3 mois peut-être pour le déroulement du procès et 4 autres mois pour délibérer sur les crimes et rédiger le jugement. Pour la cour d'assises d'appel, ils ont 7 mois, ce qui fait un total de 40 mois pour un budget de 8 600 000 euros à peu près. Bon, si le temps est épuisé, je vais devoir m'arrêter. Je vais devoir m'arrêter là. I have more time. Ce qui distingue ces juridictions ad hoc et ces juridictions hybrides de la CPI, c'est que les juridictions ad hoc et les juridictions hybrides ont une primauté sur les juridictions nationales. Il y a une compétence concurrente, mais lorsque les juridictions hybrides ou les juridictions ad hoc demandent aux juridictions nationales de se dessaisir, elles doivent le faire, et ce, à tous les stades de la procédure. Par contre, la CPI a une compétence plutôt subsidiaire. La priorité est laissée aux États. Et ce n'est que lorsque le Conseil de sécurité, sur la base du chapitre 7, demande à la CPI de se saisir d'une affaire, ou lorsque les États eux-mêmes lui défèrent la compétence, que celle-ci peut agir. Sinon, à titre principal, ce sont les juridictions nationales qui doivent être compétentes, parce qu'elles sont estimées comme étant les plus légitimes et les plus appropriées à mener ces procédures. Sauf si maintenant, elles ne peuvent pas ou elles ne veulent pas mener des poursuites. Parce que ce n'est pas un blanc-seing non plus qui est donné aux juridictions nationales. Donc, primauté des juridictions ad hoc et des juridictions hybrides, et complémentarité, subsidiarité de la CPI. Je vous remercie.
Thank you very much, Mr. Aliba, for that presentation. I would like, without any waste of time, to request Mr. Anis Ahmed to talk about the monitoring of referred cases. Over to you, sir.
Good afternoon, Mr. Majula. Good afternoon, audience. I think I've been invited here because I monitored the transferred cases from ICTR to Rwanda for about 2 years, and I'll speak to my experience about that. While doing so, I'm cognizant that the rules applicable to monitoring say that I shouldn't speak to media. I'll read that restrictively and assume that I'm speaking to an enlightened audience of professionals, and therefore I'll not speak about specific cases, but in general about the principles of monitoring and the experiences that the monitors have and the lessons learned. After about 4 or 5 reversals in 2007 and 2008, ICTR transferred its first case to Rwanda in 2011, and I acknowledge the presence of Judge Florence Ere here, who was the author of the first transfer case to Rwanda, which became successful. And as Richard said, principally, the reasons of the success of the first transfer case to Rwanda was because in the period between 2007 and 2011, Rwanda effectuated in its justice and legal sector changes that had been the changes that were the reason for denial of transfer motions to Rwanda. And the principal changes, and I think Richard articulated them, were the absence of death penalty, witness protection program, which existed earlier in the prosecution office of the NPPA, was transferred to the Supreme Court of Rwanda. A robust, at least so at that time was said, a legal aid program for the accused, especially in respect to the transferred cases. And the conditions of detention were brought in line with international standards and as articulated by the ICTR in its initial denial motions. As a result of the first transfer case in June of 2011, the first accused was transferred almost 9 months later in April 2012. The transferred case, the first transferred case of Winkindi, articulated that Rwanda had now the capacity to grant fair trial to the first transferred accused of the tribunal. However, at the same time, it effectuated a robust monitoring program such that if there was a violation of a fair trial, there would be a revocation of the case at the instance of the prosecution and the defense. Now, I must acknowledge that this also happened in the background of something that the judges did themselves. In April of 2011, the judges brought in a change to Rule 11 bis, and the change was very significant. Until then, it was only the prosecutor who, if he felt it appropriate, could have a monitoring program for the transferred cases. The judges brought in a parity in that they said that the chambers or the judges themselves, through the registrar, can have an independent monitoring program such that they could independently assess whether the fair trials of the accused are being observed in a transferred case, and this was only in respect of Rwanda. As a result, the Winkindi case appointed the African Commission of Human and People's Rights based in Gambia as the first independent monitor who should take over the responsibilities upon the transfer of the first accused. The judges felt that the ACPHR had the requisite independence and the qualifications as enunciated in its mandate to be that independent observer. For various reasons beyond the scope of this discussion, the negotiations with the African Union continued, and they couldn't be effectuated until the first transfer, physical transfer of the accused happened. As a result, the judges, again in a very interesting innovation, created an interim arrangement in which tribunal staff members, independent tribunal staff members belonging to the registry and the chambers, were sent as the representatives of the chambers, and in particular the president, to monitor these transferred cases in the courts of Rwanda and provide, at that time, confidential monthly reports to the president in respect to the ongoing proceedings there. And this happened. When the first accused was transferred on the 21st of April 2012, 2 ICTR monitors were there with the actual transfer of the accused from Arusha to Kigali, and thereafter followed every single activity in the transferred case. This was a work in progress. It was the first time an interim monitoring arrangement had been created, and the monitors, as well as the whole arrangement, learned as we went by. I think the first important thing that we did in terms of the lessons learned in the first 2 months of monitoring and dealing with our interlocutors and stakeholders in Rwanda was to request the President Johnson at that time, to create guidelines for the prosecutors, for the monitors, so that the monitors themselves And those being monitored knew what we were talking about and what was the remit of this monitoring program. Judge Johnson, as his last act as the president of the tribunal, in charge of the monitoring program on the 29th of June 2012, issued the guidelines which became the guiding principles for the monitoring program that finally took over in the absence of the African Commission. And those guidelines did two very important things. First, they guided the conduct of the monitors in respect of what to do, but more importantly, what not to do. And I'll come to what not to do in a little while. But it also told those who we were monitoring and those who were observing, who were monitoring the monitors, as to what the monitors were doing. And I think that transparency brought in a lot of clarity and acceptability of the whole monitoring scheme. And I'll straight away come to the principles enunciated in those guidelines, which thereafter, in a slightly modified form, were also adopted by the president of the residual mechanism, to whom the observation or the overall superintendence of the monitoring program transferred as of the 1st of July 2012. And I think the first important, and I've got 4 principles lined up here, and I think I'll restrict myself to the time allocated because I love my voice, but I'll try to restrict. Non-intervention in the judicial process. The first principle, and we derived this from the OSCE principles of the monitoring of the ICT wires transferred cases, and of my own monitoring as a prosecutor in Cambodia when the Open Society Justice Initiative and others from the University of California very robustly monitored us and told us what we were doing and what we shouldn't be doing. Non-intervention in the judicial process meant that we kept a safe distance from the judicial actors of Rwanda, just not to be interfering, and more importantly, not to be seen to be interfering. We would not meet judges. We will just go and introduce ourselves to the judges and tell them that we are monitoring this program in terms of the ICTR's transfer order, and that the Prosecutor General of Rwanda and the Kigali Bar Association has accredited us, accepted us as monitors, and that we'll carry these badges, we'll be present in your courts, we'll report objectively about it, but we'll not interfere in what you are doing or what you should be doing. And I think that brought in an added level of acceptability because the judges accepted us. We knew that the judges knew that we were being in the court, and to the extent that at times the judges would hold proceedings if one of the monitors was not present or was away for a short while, to allow the monitors to come such that the proceedings can be conducted in the presence of the monitors. It also ensured that the parties accepted that we were independent, not just of the parties, but also of the judges, that we were not some kind of super judges or super observers of this case, and that we'll have a greater role than just reporting about that process. I think the second important principle that we observed, and I think that was also articulated in those guidelines, was of consistency, and the guidelines call it harmonization. And I call it in ordinary language, building relationships. I think it was very important that the Rwandans saw, our interlocutors saw, same faces monitoring over a consistent period of time. That built in relationships, it built in a lot of trust, and it built in a lot of acceptability, such that we didn't have to insist on things and documents and access to courts and access to accused and detention facilities. It came on its own, and I know I have just 1 minute left. So consistency, building relationships, same set of people, same set of interpreters, and asking same set of questions repeatedly so that there were follow-ups. The third thing that we did was transparency and publicity, and I think the judges, the presidents agreed with us. Initially the reports were confidential, but they were then made public. And I think it's very important because a lot of people were monitoring the monitors, and a lot of people were monitoring the proceedings even remotely from abroad. And I think that brought in an added level of transparency and acceptability that even we could be critiqued, and a lot of press reports were written critiquing the interpretation given by the monitors. And I think the fourth important thing, I think I kept the most important thing for the end, but I have 1 minute to do that, objectivity. I think we reflected an objectivity both in our deeds and in our reports. We involved the views of everybody. We went out of our way to interview everybody concerned, not just the defense counsel and the prosecutors, but also civil society, also members of the press, even those who were monitoring or writing, members of the diplomatic corps who were observing, members of the legal community in the form of the Kigali Bar, and in fact the academic community who were interested in those programs. We did not give personal opinions. At times that became very restricting, but I think in hindsight I realized that not giving personal opinion meant that we were considered only as reporters while leaving the decision to the judges in respect of whether the proceedings were fair or not. The other thing that we did was we didn't recommend any changes or any changes to the justice system. A lot of our interlocutors would come to us, including defense counsel, some in the prosecution, particularly the prison director, and said, tell us what we can do to improve. And I would say, look, that's not my business. I'll just report how things are happening. It's for you to interpret. It's for the judges to decide whether you're doing right or not, or the accused to file applications for revocation, and then for you to justify whether it's fair or not. And the last thing we didn't do, and that was also slightly restricting at that time, but I think in hindsight was right, was we did not comment about other cases. We restricted ourselves to commenting only on the transferred cases, and we didn't comment on the larger justice system of Rwanda, whether just because Owinkindi was getting a good or a bad trial, Rwandan justice system was good or bad, and so on and so forth. And I think that also brought in a lot of acceptability, and because we read our remit restrictively, I think the acceptability was even more. And the last thing, Mr. Majola, I know I've worked together with you, you grant me that indulgence of 1 minute. We didn't allow our reports to be trials within trial. We didn't allow reports to be used as fora to argue their cases. We told the parties, don't argue your cases through us. Let us report how you argue your case in the court, and let us write what we consider needs to be written. And I think I should shut up there. But I think it's been successful. There have been 2 revocation applications, very actively citing the reports of the monitors. I think that goes to the fact that they were considered reasonably reliable to base their revocation applications, and I thank you.
Well, thank you very much. Mr. Yanis, we are making good progress. And I would like to give the opportunity to Ms. Kate Gibson, Defense Counsel, ICC, to talk about defense cooperation issues. Over to you.
Thank you very much, Mr. Registrar. And I also wanted to thank the members of the organising committee of this conference for inviting me to be part of this panel. I've been asked to speak on cooperation issues, particularly the impact that they had on the work of the defence. And I think for most defence counsel arriving in Arusha for the first time to work on one of these cases, one of the most surprising aspects, and there were many surprising aspects, but one of the most surprising was how quickly you would be blocked in terms of investigations without some form of state cooperation. So you couldn't talk to a prisoner in Rwanda, you couldn't interview a Belgian or a French soldier, and you couldn't photocopy a Gacaca document unless you had some kind of state authorization. And as you're all aware, the structure of the ICTR was such that the defence operated as this external body and had a real independence from the institution. And that independence was really important for a number of reasons. One of the disadvantages of that independence, however, was that we had to approach governments and armies and national courts and state mechanisms in our personal capacity, and not necessarily with the weight or the gravitas of the ICTR behind us. So if the prosecutor of the ICTR makes a request for assistance or cooperation from a state, he or she is doing that as the prosecutor of the ICTR, with which UN member states have an obligation to cooperate. And that situation is very different from me writing in my personal capacity to, say, the Belgian Ministry of Defence, hello, my name's Kate, I'm representing X before the ICTR, he's charged with genocide. It'd be quite helpful for me if I could maybe come and look through your super secret military archives and maybe photocopy some stuff. Doors just didn't open to us in the same way as the prosecution. Of course we could ask for the assistance of the registry in facilitating cooperation, and we had some notable successes in that regard. After the tireless work of General Kavaligi's lead counsel, Paul Skolnick, Trial Chamber 1 in the Bagasora trial heard the testimony of Colonel Luc Marchal, the Belgian commander of UNAMIR's Kigali sector, and 3 members, French officers of the Opération Turquoise. And this was only possible after significant legal and diplomatic wrangling between the defence and the UN, the defence and the état-majors of the Belgian and the French armies, the ministries of defence. But we had the registry in our corner, fighting with us to try and facilitate this cooperation. So we did have some successes in that regard. When it came to Rwanda, as a general rule, the defence enjoyed relatively consistent access. Visas were generally issued. We were able to pass in and out of the country without any problems. We were given access to sites, to prisons, to prisoners, to court hearings. There were some exceptions, but as a general rule, there was access. Of course, we also had the ability to just walk into local or national registries of courts and make requests for documents in the same way as the prosecution could. And sometimes just hours after the prosecution had been there asking for the same documents. When we were doing things like that, we would sometimes put our very bright pink defence badges sort of at the bottom of our bags and just come in as concerned citizens or academics. But we were able to get access to a lot of documents that were really relevant to the trial chamber's determinations of the truth of the events in question. Getting our hands on Gacaca documents was a bit of a different story, particularly when, in our case, we were looking for a lot of obscure documents up in the east of Rwanda. And my good friend Greg showed you a picture of the way in which these Gacaca documents were being stored at the time. But being a defence counsel and not a prosecutor, I wasn't scared off by a few sacks. And I spent a few memorable days on my hands and knees with a particularly gracious Gacaca coordinator going through, they were flour sacks actually, so you get a bit of flour. Going through and trying to find copies of the documents that we wanted to bring before the chamber. And I think that's an example of real cooperation at its purest when you're on your hands and knees with Gacaca coordinators. We did get some significant assistance. I think it's also worth noting that the defence, to an extent, was at the mercy of this oscillating relationship between the ICTR and Rwanda. And the Prosecutor General this morning described that relationship as a mixed bag, which I think is accurate. It oscillated between the sort of collaboration that has allowed the transfer of cases to happen and other times active hostility. I think the first epic clash was over who would get to try the high-level accused, given the concurrent jurisdiction that was operating between the tribunal and domestic Rwandan courts. And in 1996, the then prosecutor, Richard Goldstone, had the first big win when Colonel Bagasora was subject to 2 competing extradition requests, having been arrested in Cameroon on the back of a Belgian arrest warrant. And the ICTR asserted its legal primacy and Colonel Bagosora was sent to Arusha. What's interesting is that not long after that, Kigali had a significant victory when it took Frodwald Karamira, who's the former head of the MDR, out of Goldstone's clutches, when bizarrely he had escaped in Addis Ababa airport during his transit back to Kigali. What's interesting is that Prosecutor Goldstone reportedly backed down over Karamira, who was a significant accused, when Rwanda, for the first time but not the last time, threatened to stop its cooperation with the ICTR. And this was something that happened during the early years of the tribunal, when decisions that were viewed as wrong or adverse in Kigali would lead to cooperation stalling or being problematic. Obviously, the defence was in some way involved in these problems that arose, but the major issue for the accused and for the overall fair trial rights was that when this cooperation stalled, investigation stalled, the trial stalled, and the idea of an expeditious trial slipped further and further away from the accused. I'm getting a 2 minutes down here, a 1 minute over here. I'm going to go with the 1 because it's late in the afternoon. So I'll just wrap up and say, overall now I can compare my experience on 3 cases at the ICTR with my role now as a defence counsel at the ICC. And looking back, I think the cooperation that we as defence received at the ICTR is almost unimpeachable. The ICC has a lot to learn for the way that the ICTR, particularly members of the registry, worked with us to facilitate state cooperation on our behalf. And I think it's part of the ICTR's legacy that can be held up and celebrated. Thanks.
Well, thank you very much, Ms. Gibson. Quite interesting. And then finally, last but not least, I'd like to ask Mr. Jean Bosco Mutangana to talk on the domestic justice mechanism's perspective on referred cases. Over to you, sir.
Thank you. First of all, may I say that I'm honored to speak before this respected and eminent audience of the principals of the ICTR and the MICT. Not only as a prosecutor from Rwanda, but also as a prosecutor who is involved in directly involved in the prosecution of the 2 cases that has been transferred to my country for trial. Having said that, I would say that there are a number of domestic justice mechanisms that have been put in place to prosecute these cases. A number of them have been mentioned by the previous speakers, but I would like to also speak about them. When we received the first case in April 2012, as prosecutors, I would say we were prepared to go on with the trial, and indeed the case has advanced steadily. And the first case that was transferred, I would say it has now reached the midway, while the second one is also coming. So the reforms that Rwanda has been undergoing for the last 10 years, or maybe starting from 2003 when we got our current constitution, it was very clear that we had to undergo reforms because the constitution brought in a lot of things, the new courts, the new structures. So we had to undergo the reforms, of course, for the betterment of our own judiciary and the legal system in the country, but also as time went by, these reforms were necessary, among others, to address the concerns of the ICTR when we started requesting for the transfers, as Mr. Richard Karigesa mentioned. So, among others, to address the concerns of the ICTR, and also the extraditions that we had applied for from other states. So, under these reforms, which is one of the most important mechanisms that have helped us to receive the cases and to have that kind of, I would say, international recognition of our own judiciary back home. These reforms also focused on the criminal law regime of our country by having, for example, genocide was not in the penal code of Rwanda which existed between 1977 and 2012. So as you know, it was a very big challenge. But now the Penal Code of Rwanda clearly, categorically defines genocide and the constitutive elements of the crimes of humanity, war crimes, and genocide. Also, the criminal procedures of the country have been, there is a lot of amendments that has been made. But more to that, there has been 2 special units that has been set within the prosecution department and the High Court to handle these cases. The International Crimes Unit of the prosecution was established, and I actually head that unit. And we have a team of senior prosecutors who are handling these particular 2 cases that were transferred to Rwanda and other cases extradited to Rwanda from other states. So by establishing this unit, the prosecution of Rwanda ensures that investigations are carried out and by all means must be of high standard and quality. Besides that, we have also gone into some kind of recruitment of experienced and specialized personnel who have got experience of the ICTR, and those who can give us some better advice on how to move on, because I must confess that not so many prosecutors from Rwanda have had the access of working with the international tribunals, but the few that we have been recruited to give that piece of advice. So they are primarily charged with giving advice and expertise with regard to these files, and they liaise with international tribunals. Sarah mentioned about the witness protection. In order to meet the threshold of having the tribunal also sending these Rwandans back home for trial, a number of issues, including witness protection matters, were raised. So now there is a witness protection unit which is administered by the judiciary under the direction of the Chief Registrar of the Supreme Court. And this unit has been staffed with registrars, and these registrars and a number of people working in it are there to assist any investigators and anybody who is willing to have this unit helping him or her from other states, but also primarily looking at the interests of the victims and witnesses. Being the last speaker, I think you'll give me 2 more minutes. So I would say that also specifically on the transfer of cases, there has been a specific legislation that has been enacted. It's the law relating to the transfer of cases to Rwanda. And the first one was of 2007, but then it had to be amended also by 2012 legislation, which is currently in use. And this legislation creates a legal framework for facilitating ICTRs and other states in extraditions. I would say the transfer law is there, and it is a specific procedural guiding legislation in the cases that has been transferred. We have a criminal procedure code, but the cases transferred to Rwanda, for those cases we use this one in addition to the criminal procedure code. So, well, that is how it is, but this legislation is in place to help us. It contains a lot of articles that provide for which court is competent. This is the High Court. It talks about the bench. The bench is constituted by 3 judges. It talks about why is it 3 judges. First of all, this is in the appreciation of the president of the court. Given the seriousness of the case, he or she may decide to appoint 3 judges. But normally, under the Rwandan law, ordinary cases are tried by a single judge. I would also say that with regard to the rights of the accused persons, this law provides guarantees of how the accused person's rights must be respected, ranging from the right to defense, and the right to have adequate facilities and time. And I would say that there has been, the defense is available for the 2 cases that has been transferred, and the government foots the bills for them, and they enter into agreement with the Ministry of Justice, which foots the bills. And also, in terms of facilities, there has been the provision by the penitentiary or prison authorities to make sure that these people have got enough materials to use during the preparation of their defense. This law also provides for alternative means of testimony. By the High Court of Rwanda is equipped with video conferencing materials that have been acquired through the support of the ICTR and the German government. So witnesses can still testify without traveling to Rwanda, and these equipments are installed and have been used by other countries. Because right now, at the stage where we are in the trial, we haven't called the witnesses in any case. Thank you. We are looking forward to have the first witnesses coming up in the case of Unkindi, and we shall see whether we have witnesses either in America or in Europe who are not willing to come. And they will be testifying through the video conference. But besides that, the law provides for further alternate means of tendering in evidence. It provides for depositions, it provides for commission rogatoire, it provides for a judge sitting in a foreign jurisdictions and taking evidence from the witness, which will be used in Rwanda. So this law is very clear on those matters. On witness protection, I'm coming to the end of my presentation. The High Court has powers to interpret protective measures similar to those in the rules of procedure and evidence of the ICTR, and this is in our law. And as we speak now, witnesses who are protected right away from the ICTR are still protected, and additional witnesses who gave in testimonies when the cases arrived in Rwanda and who wanted protection are protected, and they have been given pseudonyms. So there is no any issue of the witness protection, because the law provides for how the president exercises this in terms of protecting witnesses. Also, Foreign Defense Council issues. The defense lawyers from abroad can come and be certified by the Rwanda Bar, and they would go on pleading, defending their clients before the Rwandan courts. Finally, let me talk about monitoring. Last time when we were here in the colloquium, I mentioned about our relationship with monitors. I would say that I think Mr. Nis has been there for the last 2 years, and I would say that the relationship is good. We have an open relationship with them. They ask questions whenever they want. They meet any official they want to meet. And every institution, the prisons, the courts, the prosecution, the registrar's office, the monitors have got access and right to go and speak to them on any queries they may be having pertaining to the case at hand. So I would say that without taking much time, these are some of the important mechanisms that we have been undergoing, and the trials are still going on now. So we are still in the infancy of conducting prosecutions of these cases. It would be a speculation for me to know where and when these cases will end. But I can say the path we have taken is already excellent. And as the previous speakers have spoken about the reforms and issues of witness protection and everything, I can confirm that where we are now is very much ahead compared to where we were more than 10 years ago. Finally, I want to note that the European Court of Human Rights decided that the cases from Europe be extradited to Rwanda. That is something very important. Thank you.
Ladies and gentlemen, you've heard for yourself the wonderful presentations. Before you can ask your questions, there has to be an intervening act which will be provided by our discussants. I had hoped that some of them would do so, but we have run out of time. And for that reason, I would like to follow the program, which provides that we will start tomorrow at 8:30 in the morning. I suppose that is acceptable. to everybody. I don't see any objections. Thank you very much. So we will start with the discussants, and then after the discussants, the presenters will come back onto the main table, and we will then open the discussion for questions. Yes, and then we'll get comments also. For the rest, I would like to wish you a happy evening and a good night, and we.
Seren has some administrative.
Oh, I'm told that I am overstepping my jurisdiction, so I withdraw my good night.
Most obliged, Mr. Registrar. Thank you very much. I would like to do the necessary housekeeping and take a few minutes of your time, if I may. First of all, kind reminder for our delegates who are sponsored, we do need copies of your passport. Photocopies can be done at the reception desk. For our guests that have rooms at the Palace Hotel, the shuttle will leave at 6 p.m. today from here to the Palace Hotel, and will leave tomorrow morning at 8 a.m. from the Palace Hotel to this venue. And for our guests that are leaving today or tomorrow morning, you're kindly requested to go across the hall to our staff room to tell us if you still want to leave us today. We hope not. If that is the case, we will certainly endeavor to make sure that all necessary arrangements are made. And I would like to stress that tomorrow we have our group photos. And that will conclude our housekeeping, and I will give the floor again to Mr. Bongani Mojaola.
Would you please just remind us what time is the group photo, please?
I am sorry, that information will be forwarded to you tomorrow morning. I was just...
Okay.
We just like to make sure that the ladies are dressed appropriately for the photo.
Oh, okay, classified information. All right. I would like to, with your indulgence, close the session until tomorrow morning, 8:30. All the best. Thank you.